of hairs found at the scene as being Caucasian hairs. And in candor, Judge, I cannot recall if during the opening statement he specifically referred to the hairs found in Miss Baker's left hand as being the hairs of Chris Melton, or if it was during his proffer in the Saudi motion. I know during his proffer in the Saudi motion he certainly did, but he has referred to those hairs as Caucasian hairs, which is directly from Mr. Peterson's lab report, and is also through cross-examination, in the opening of envelopes with Lieutenant Liedall, placed issues as far as the manner in which those hairs were maintained in evidence at issue as well. So Mr. Cruz has made hairs kind of a central part of the early part of this trial, which I think leads to a situation where the state is almost compelled in certain ways to address that issue, and we would do so through the testimony of Mr. Larry Peterson. It would essentially be rebuttal type evidence. I think the law on this indicates that rebuttal evidence can be evidence that's presented in response to assertions made by defense counsel, particularly through cross-examination. Obviously, we would still have the Daubert hearing that we would need to hear. I know that we try to get as many things done before trial as possible. We did not think this was going to be an issue because we took Mr. Cruz's Daubert motion to mean that he was not necessarily going to get into hair analysis either. But, I mean, I think as it applies to any party in a trial, you can't have your cake and eat it too. If you're going to get into a certain body of evidence, then the other side has an opportunity to respond from that same body of evidence. And I think that's the situation we're in now. We're trying to connect with Mr. Peterson to be here hopefully around midday in an effort to make him available to address this issue this evening / late afternoon as well regarding a Daubert motion. I believe that that's all the preliminary issues that the state has, but if I could have a moment to confer with Mr. Bolton. Thank you, Your Honor. That's all we have this morning.
And I just have a question. Mr. Peterson is on your full witness list. Is that right?
Yes, Mr. Peterson is on the state's full witness list. And he is also actually noticed on the defense's witness list. So I would say that as well. The defense has placed this individual on their witness list.
Okay. All right. Thank you, Mr. Cruz. Any response to that or response to having to do some motions late in the day or anything else?
Sure. So in regards to, and good morning, Your Honor. In regards to Ms. Lacone's Daubert motion or Daubert hearing, I have no issue with that. I do want to make sure I understand the state's argument in regards to Mr. Larry Peterson. As the Honorable Court is aware, I believe in our Daubert motion I provided law as well as some articles from the FBI just regarding and I don't know if he's doctor, but just in case, Dr. Peterson's findings. As I stated in opening, the purpose of the hairs is what law enforcement knew at the time this investigation was going on. But I also stated in opening that the science has been deemed unreliable. The reason we brought it up was because at that time they knew. So it actually just went to the investigation, not the scientific validity of the hairs themselves. We're just going to what law enforcement, at least at that time, had been aware of. Ultimately, later, we know that Dr. Peterson's findings, they have no scientific basis as far as identifying a particular person. So as far as Dr. Peterson, we would stand by our Daubert motion, the Honorable Court, and we would do whatever the Honorable Court would like us to do in regards to same.
All right. Thank you, Mr. Cruz. Well, we will have the Daubert hearing based on your motion. And obviously, you can make whatever argument you need to and cross-examine this person. And we'll just have the hearing like we're supposed to. So we'll do it. And we'll do it after the jury leaves for today.
Well, I would ask this. Due to the notice being today, may I have until tomorrow to prepare for the hearing? I don't have anything related to Dr. Peterson with me here today.
Well, let me ask the state a few things about all of that. You wanted the court to hear the Daubert motion with regard to the other witness today because that person needs to be able to leave and go back, I assume. Is that right?
That's correct, Your Honor.
What is your position with regard to Dr. Peterson? Is he coming from out of state or anything like that?
I think it's just Mr. Peterson.
Okay.
I'm
All right.
not 100% certain, not that it matters for purposes of this discussion, Your Honor, but I would say that he isn't coming from out of state.
Okay.
He is a very seasoned witness, I guess would be a good way to talk about age without talking about age. And then we do have him in hotel accommodations for this evening, given that it may be into the late afternoon. We're hoping to do it this afternoon so that maybe Ms. Lycon and Mr. Peterson could both testify tomorrow, at least to give us a chance of that. But obviously, we've leave it in the court's discretion as to when to schedule the Daubert hearing. And so that's our statement on that.
All right, thank you. I do think having the Daubert motion this afternoon with regard to the other witness is appropriate, given what you said about her needing to go out of town. But I'm going to grant Mr. Cruz's request to give him time, and the state time if you need it, obviously, to prepare for that. So we're going to have the Daubert motion with regard to Mr. Peterson tomorrow morning at 8:30. And if I need to bring the jury in at 9:30, I'll make that decision later today. I'd prefer to start at 9 because we're going to leave early, but we'll have it at 8:30 tomorrow morning. And that will be for Mr. Peterson. So I'll see you all at 8:30 and Mr. Peterson at 8:30. All right.
Thank you, Judge.
Yes, sir. Hey, Mr. Cruz, anything else?
No, ma'am.
All right. Thank you. I'm going to ask our bailiff. Where's Miss Linda? Oh, come on. Oh, there you go. I'm sitting down. I didn't see you over there. Can you knock on the door and see if they are ready with their, thank you. Taller. All right, very good. You can have them come out. Thank you. All right, you may be seated. Thank you. Good morning, ladies and gentlemen. We're ready to resume the trial in the state of Georgia versus Edrick Faust, SU 24CR0547. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Yes, ma'am.
All right, thank you. State may call their witness, and we have a continuing witness, I believe, from yesterday. Is that correct?
Ashley Hall.
Thank you. If you could get Ashley Hall, please. Mr. Cruz, you have the floor.
Yes, ma'am. Good morning, Mrs. Peavy Hall. How are you?
I'm doing well. How are you?
I'm doing okay. Thank you so much for asking. Between us breaking yesterday and you testifying now, has any attorney spoken to you about this case, your testimony?
I talked to the DA this morning for a little bit.
Okay. Your Honor, I have a motion.
All right. Ladies and gentlemen, I'm going to have you go back into the jury room. I'll see you in a moment. Please don't discuss the... You all may be seated. Yes, sir.
Sharon, before I get into the motion, may I ask Mrs. P.V. Hall some questions about the conversations that she had with these? Can you tell the Honorable Court about your discussions with the state?
He was just reassuring me about coming in today and said I was okay from yesterday and just I keep telling the truth like I'm doing.
Okay. Did he talk to you about your testimony in any way?
He just said I did a good job, that's all.
Okay. Did he say anything about how you should answer my questions?
He did not. He just said just be truthful like I've been doing.
Okay. Did he ask you to review anything?
No.
Okay. Excellent. And if I haven't asked you a specific question, just in general, well, specifically, who spoke to you? Let me ask that question.
Chris did.
Okay. And what did Mr. Bowden say exactly?
Objection, asked and answered.
Sustained.
Okay, sure. Based on what Mrs. P.V. Hall has stated, the only thing I would request at this time, Your Honor, is just to instruct the state that once a witness is under oath, neither party, myself or the state, is to speak with them in any manner until they finish their testimony or before the testimony starts.
Thank you. Any response from the state?
I'm not aware of any rule that prohibits that. So, I don't know what the basis is.
Well, I agree with the state. There isn't any rule that prohibits what you have elicited from this witness. I think both parties realize they can't talk to a witness about their testimony in any specifics in that way. That has not been shown, so I'm not going to give that instruction. I think both parties are aware of the law. All right. Thank you. If you'll bring the jury back out, please. Thank you. All right, you all may be seated. Thank you. Mr. Cruz, you have the floor.
Yes, ma'am. Mrs. P.V. Hall, I believe we left off yesterday just discussing how Ms. Baker was with intimate details about her life. I believe we left off yesterday. I think the last question that I asked you is that when you were speaking to law enforcement, you said that there were certain things that Ms. Baker wouldn't share with anyone. Is that correct?
That would be correct with regards to her relationship. That would be something between her and her partner.
Okay. And is it fair to say that Ms. Baker was not the type of person to share really intimate and private details about her life?
When it came to her partner, yes.
Now, would you agree that Ms. Baker was a down-to-earth person?
Yes.
Outgoing,
Yes.
fun, funny?
Yes.
Okay. She was in a sorority?
Yes.
And even while in law school, which you would agree is very tense, is that correct?
Yes, I agree.
She would still find time to go out, have cocktails, hang out with you?
Not very often.
Okay.
Like I said, we were extremely busy at that time. We might try to get to a Georgia game, but it's definitely not like what undergrad was like at all. You might see a friend real quick after class, but you don't go out like you would in college.
I believe your exact statement to law enforcement was you leave class, get a cocktail, then go home and study. Is that fair?
Not every day, but sometimes.
Ms. Baker also had a friend circle. Were you aware of her friend circle?
Yes.
Okay. And there were times when Ms. Baker would go out with a gentleman by the name of Steve, who was an attorney?
Well, she would go out with the law office, and Steve was part of that.
Okay. And Ms. Lauren Sherling as well?
Yes.
Had Ms. Baker spoken with you about Steve the lawyer?
She did.
Mr. Cruz, why is that relevant?
Just discussing her friend group, Your Honor.
All right, I'm going to overrule the motion and allow you to continue, Mr. Cruz.
Yes, ma'am. And I believe you stated this on direct, but I just want to make sure I'm clear. So just to make sure I'm 100% clear, The day before Ms. Baker's passing, which would have been the 18th, you were leaving home for the night. Is that correct?
Yes, that is correct.
And you informed Ms. Baker that you would not be home that night. Is that right?
I did.
And you stated that she began cutting up, saying she was going to be alone for the night. Do you recall making that statement?
Yes, we were sitting there just talking and cutting up about the week and what was coming up that weekend. So, yes.
Is it fair to say that Ms. Baker being home alone that night was a big deal to her?
I wouldn't say that was a big deal to her. I think she was just cutting up just since we were all leaving. She was just excited. She had things to do. She was going to the law library to see her friends or to study. We've all been alone in that house at some point. It was not unusual.
Is it true that you heard Ms. Baker ask Chris to come over that night after finding out that she was going to be home alone?
She asked, but she knew with his job that it was probably not likely. And so she was not surprised when he could not do it.
Okay. Thank you. After Ms. Baker's passing, you returned to the Deer Park home to gather your belongings.
I did.
And when you returned home, none of your jewelry was missing.
Nothing was missing in mine, no.
Your drawers had not been rummaged through?
Nothing. Only the stuff you can tell from the firefighters.
Yes, ma'am. And is it fair to say that you had numerous items of value in your bedroom?
Yes.
Ms. Peavy, do you remember the layout of your Deer Park home?
I do.
Okay, you had your own bedroom and you had your own bathroom. Is that right?
That's correct.
And you and Tara, this is probably clear, so forgive me, I just want to make it clear for the record, but you and Tara did not share the same bathroom.
We did not share the same bathroom.
Okay, you had your own toilet, shower, and bathtub.
Correct. But her bathroom did have the door open to the main room.
Say that again?
Her bathroom had the door open to the main room,
So she could actually
go
walk
through.
through her room and then go in her bathroom?
Yes.
On January 25th, 2001, Mr. Melton came to your home. Do you remember that?
Again, this was 25 years ago. I'm sure it happened.
And would you agree Ms. Baker was killed on January 19th, 2001?
I would agree to that, yes.
So you would not disagree that Mr. Melton was at your home within a week of Ms. Baker?
No, I would not disagree to that, no.
Do you remember on the day that he arrived to your home, he called the woman by the name of Miss Leah Tucker?
I do not.
Was seeing a summary of your statement to law enforcement refresh your recollection?
That's fine.
Court's indulgence. So I'm showing you what is going to be marked as Defense Exhibit 22. And I'm showing you this for the purposes of refreshing recollection. If you would, please look at page 2, paragraph 2, sentence 2 and 3.
Okay.
Your Honor, I just would ask Mr. Cruz to show me the exhibit before he shows it to the witness.
All right, that's appropriate. Mr. Cruz.
And again, Mrs. Peavy Hall, page 2, paragraph 2, sentence 2 through 3. And you can just read it silently, okay?
Okay. Okay.
Okay. Do you recall making that statement to law enforcement?
I do.
Okay. And that phone call to Ms. Leah Tucker occurred after 8:15 p.m. at night. Is that correct?
I did not see that on there, but
That is going to be paragraph 1 and 2.
okay.
Full paragraph 1, paragraph 2, sentence 2 through 3.
Yeah, I read that, but yes. So some around, I think on there it says sometime around 8 to 8:15. But yes, Leah Tucker was a cheerleader with him at Georgia College, and they were just really close friends. At the time, she was seeing someone as well.
Yes, ma'am. And Mr. Melton set up a dinner with her for 5:30 on Friday, January 26, 2001. Is that correct?
I do object again to relevance.
Ms. Cruz, care to respond to the objection?
Yes, ma'am. It goes to the evidence that we presented in our opening about Chris Melton's actions after Ms. Baker's death.
Okay, I'm going to overrule the objection. You may continue.
Repeat your question, please.
Yes, ma'am. Please forgive me. Mr. Melton set up a dinner with Ms. Leah Tucker for 5:30 p.m. on Friday, January 26th.
Okay.
Is that correct?
That's what it says in the statement. Yes, correct.
Okay. And we would agree this is at a week after Ms. Baker's death. Is that correct?
That's correct. But again, at this time, we were all reaching out to all of our friends and the people that cared about us at this time.
Yes, ma'am. And the
She
follow.
knew Tara as well.
I'm sorry.
She knew Tara as well.
Yes, ma'am. The next day, on January 26th, Chris called a young lady by the name of Holly Hufford from your home. Is that correct?
That's correct.
And Chris set up a 1:30 p.m. lunch with Ms. Holly Hufford for January 26, 2021. Excuse me, 2001.
Okay.
Is that correct?
That sounds correct.
Well, not if it sounds correct. Is it correct? Do you recall making a statement based on a summary of your...
From what you have in front of me, yes.
Now, Ms. Peavy, Chris actually went to lunch with Ms. Hufford, right?
Yes.
And you know that because you joined Chris at the lunch with Ms. Hufford. Is that correct?
I don't remember that, but I'm sure I did.
If you'll look at page 3 of that document, we're going to start at paragraph 2, the first sentence. And after you read the first sentence, look up and I'll direct you to the next portion of that.
All right, say that one more time.
Yes, ma'am. Page 3,
Yes.
paragraph 2, the first sentence. Well, don't read it out loud. Just to refresh your recollection, you can read it to yourself. And after you read that sentence, look up and I'll direct you to the next sentence.
Okay.
All right, if you'll go to page 4 and read the 3rd through the 4th paragraph in full.
Okay.
All right, is it correct that you joined Chris at lunch with Ms. Hufford?
Yes, it says that my husband, Chris Hall, and I joined him.
Yes, ma'am. And during the lunch, you told law enforcement that Chris was flirting with Ms. Hufford. Is that correct?
Chris was very flirty to anyone he spoke to. That was just his personality type.
So is that a yes or a no?
I guess that was a yes, but he didn't mean it in any way that you would call being flirty. That was his personality.
Well, not what I mean. Were your words that...
Yes, those were my words.
And during lunch, Chris was also gently rubbing Hufford's lower back.
He might have been. Again, this is 25 years ago.
Sure. Would reading the summary of your statement refresh your recollection?
Probably would.
If you'll go to page 5, and starting at the last paragraph to the top of page 6. So start at page 5, last paragraph, read that paragraph to the top of page 6.
No, at the time, you have to remember I was very protective of Tara. She was my best friend. And even when I met Tara, Tara met my now husband, she didn't even like him. We were very protective of each other. So Chris, even just talking to another girl in my emotional state was the reason I was upset about him talking to any girl.
Yes, ma'am. My question is, during the lunch, was Chris gently rubbing...
Yes, he was gently rubbing her back.
And when you and your husband,
He was my boyfriend at the time, yes.
yes, ma'am. when you and Mr. Hall left, Chris continued to hang out with Ms. Hufford. Is that correct?
Yes.
May I approach you to retrieve that exhibit?
Yes.
Is that okay? And I still have free reign, Your Honor?
You?
Thank you. Those are my questions. Thank you so much for your patience.
You're welcome.
Any redirect, Mr. Bolden?
Very, very briefly.
Go ahead.
Ms. Hall, there are a couple things I neglected to ask you yesterday.
Okay.
I meant to. Are you aware generally with how the fire started at 160 Fawn Drive?
Yes, I am. They actually had me walk the scene that next day, or the day. And with walking, I noticed by the oven there were some fibers. It looked to be from, we realized it was from, I had a cream chenille blanket that was on the back of the chair that was next to Tara's door. And they had used that to start the fire on the oven. And we still saw.
I also neglected yesterday afternoon to ask you about the clock in Tara's room. Were you familiar with that clock?
Yes, it's a new clock, but it looked like an antique. It was a little, I guess, like a wooden stand clock with just a little clock face.
And to the best of your knowledge or recollection, was that clock functional?
Yes, it was brand new. Even she likes things that looked old, but this was a brand new object.
Then my last question, Ms. Hall, is do you remember in the days following the fire and Tara's death, providing samples of your hair to law enforcement?
Yes, I mean, we would do anything they asked us just to make sure they could proceed and find out who did this to our friend.
Thank you, ma'am. That's all I have.
Any recross, Mr. Cruz?
No, ma'am.
May this witness be excused.
I'd ask that she be excused.
All right. And is she under subpoena from you, Mr. Cruz?
I believe so, so I would ask that she remains on call.
All right. But you're okay with her leaving today? No objection to that?
Correct. Once we have 24-hour notice, we need to.
All right. Thank you. You are free to go. If you are under subpoena with the defense, then you are still under subpoena. But you may leave now. Thank you. You may call your next witness.
Valerie Low.
You please get Valerie Low.
Good morning, ma'am.
Good morning.
Can I have you raise your right hand, please? Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And if you could just be sure to speak into that microphone so that we can hear you. If I can't hear you, I'm afraid the jurors might not be able to.
Okay.
Ma'am, if you could start out by stating and spelling your name for the record.
Valerie Lang Low, Valery Langlowe.
And, ma'am, what do you do for a living?
I'm a district administrator in a school district.
I want to take you back to August of 2000. What were you doing at that time?
I was student teaching at Oconee County High School.
Were you in college?
I was.
Where were you in college?
University of Georgia.
Beginning that August of 2000, did you move into a new residence?
We did, yes.
And what was that residence?
We lived in Deer Park on Fawn Drive.
Who were your roommates there?
Tara Baker and Ashley Peavy.
How did you come to know Tara?
I had met Tara probably sometime the year before. Ashley and I lived together the year before, and so I met Tara through Ashley.
And can you describe, I guess, what it was like to get to know Tara as a roommate as opposed to a friend or an acquaintance?
We all got along very well, and I mean, we were all very busy, either in grad school or finishing up college at the time, and we were just all busy. So we all got along fine, and everybody kind of did their own schedules.
Okay. And if I didn't clarify this earlier, in that fall semester 2000, did you graduate that December?
I did graduate in December.
And then did you start a graduate program in January?
I did. I had started my master's degree.
If you could please, ma'am, describe what you observed about Tara as it relates to the fall semester.
My schedule was different in the fall because I got up early to go for student teaching. So I was gone a lot. I know she had started law school, and so her schedule, she was busy. So we really, didn't, we were home in the evenings together, but we again, everybody had their schedule, and we were extremely busy, all of us, that particular semester especially.
During the fall, would Tara occasionally spend the night at her boyfriend's house?
Yes.
And by boyfriend, do you mean Chris Melton?
Yes.
Would there be times when Chris would spend the night over at Fawn Drive?
I don't recall.
As you transitioned from the fall semester into the spring, or I say spring, but January semester, did you notice a kind of a change in Tara's approach to law school?
She had made comments that, she...
And I'm sorry, I don't mean to interrupt. I don't want you to testify to anything that she may have said, but just did you get an overall impression as to her approach to law school?
Yes. She'd started another semester. I was starting grad school, so I think a lot of our patterns had changed just because it was a new semester.
Okay. And what change was that, if you can recall?
Probably at home more. I know I was at home more.
What about Tara?
Same. Mm-hmm.
So on Thursday the 18th, do you recall what your schedule was like that day?
I had class. When I started my grad program, a lot of my classes were in the evenings. So I would have been home, and I think I left sometime before maybe 4 o'clock or around 4 o'clock. I can't remember the exact time. And I had class that evening till probably 7:15 or 7:30, I believe.
And what did you do after class?
I was going home for the weekend, so I immediately started heading in that direction when I left.
So you didn't go back to Fawn Drive?
I did not.
Did you see Tara that day at all?
I don't remember. I think that she probably got home the time I was leaving. I don't remember.
Ma'am, what, if anything, do you remember about the weather that evening as you were leaving town?
It was very rainy. I do remember that, just driving in the rain and, it being dark, but I just remember that it was raining.
I want to talk about kind of the relationship between the three of you in that house. How did the three of you get along as roommates?
We got along great. Ashley and I had lived together the year before, and, it was no different when Tara moved in. I mean, we all got along great. There was no girl drama or anything like that sometimes can come along with roommates.
Were you careful to look out for one another?
Yeah, we were all safety conscious about, things being, locked and, that kind of thing. I've always been that way.
Did all of you have boyfriends at the time?
Yes.
Did anybody give an apartment key or a house key to their boyfriend?
I have no knowledge of that.
Why would that have been?
I don't think that they would have ever been at the house. There would be a time.
Any response to the objection?
I'll rephrase the question.
All right, I'll sustain it. Let you rephrase if you choose to.
Based on the relationship that the three of you had, you, Ashley, and Tara, would you have given a key to your boyfriend at the time?
No.
Why not?
There would have been no reason for him to have been at the house if I would not have been there.
based on your impression of the relationship, again, that you shared with Ashley and Tara, was that consistent throughout the house?
I would assume yes.
Ma'am, I've been told that, well, let me rephrase. Were you the one that would keep the house clean?
Yes.
Can you describe that a little bit?
I was just the clean one of the group. There's always one, I guess, when you live with roommates. And so I was the one who would clean and tidy up the house, and just that was something that I enjoyed and still enjoy doing.
Do you remember, or if you recall, in the days after Tara's death, do you recall hearing about certain parts of the house being wiped down or anything like that?
I do remember hearing that.
What if anything, do you recall about that?
I think at the time it was more about, fingerprints, or they were, doing whatever you do after something like this happened, and the house was clean and things were, wiped.
Do you recall what areas of the house they were referring to?
I remember they asked, if certain patterns of cleaning, if, I would have cleaned this or cleaned that, that kind of thing. But it was, maybe doorknobs or around the doors or windows, that kind of thing.
And is that something that you would have cleaned?
Not typically. I mean, I kept things dusted and vacuumed and just your normal thing, but I didn't deep clean the house all the time.
Dr. Low, we'll talk a little bit about your observations of Tara's relationship with Mr. Melton. Is that something that she would have confided to you about?
No, we didn't have that kind of relationship. I was private, and I would have never. I mean, we didn't talk about that kind of thing.
Did you ever personally observe any arguments between Tara and Chris?
I did not.
Did you ever hear Tara arguing on the phone with him?
I did not.
Bear with me just a second. Questions I have. Mr. Cruz may have some questions for you. Thank you, ma'am.
Thank you.
Cross-examination.
Dr. Low, first and foremost, I want to let you know I am sorry for your loss, tremendously sorry for your loss. I thank you for your courage in coming to testify in court to help the jurors find the truth in this case. My first question for you, are you nervous?
I think anybody would in this situation.
I tell you don't be. I have some very softball questions for you, if that's okay. Okay. There was a statement that you made to law enforcement that I wanted to ask you about. Do you recall stating it was almost like somebody knew that we weren't going to be home?
If you'll show me the transcript, I can.
I don't have a transcript, but I can play the recording for you. Is that fair?
Sure.
Okay. Your Honor, excuse me. Would the recording refresh your recollection?
Sure.
Your Honor, I like to play the recording outside the presence of the jury.
All right. Ladies and gentlemen, I'm going to have you go into the jury room. Please don't discuss the case. We'll be with you shortly. All right, counsel, we're going to take just a brief recess. We're having a computer issue with Ms. Satterfield's equipment. So if you just hang tight for a moment.
Yes, ma'am.
And actually, yeah, let's just hang tight for a moment. Excellent. Okay, thank you. Thank you, Mr. Dickey. Appreciate it. All right, back on the record. Mr. Cruz, go ahead.
Yes, ma'am. And if I may, Your Honor, a lot of my questions come from this recording, so I'd just like to play that pertinent part so we won't have to send the jury in and out. I'm going to play from minute mark 15:24 for you. And just to save the jury time and respect the honorable court's time until minute mark 31:52. Is that fair?
No. The only thing that and this is probably in some of the notes from way back when, I think like New Year's, like I always came home for breaks and stuff, like I'm a little homebody, but we went to, Ashley and Chris and Jeff and I went to Hilton Head for New Year's, I think. So we came through Athens, maybe to pick them up or something, and Tara was there, and we were like, what are you, why are you here by yourself kind of thing, it's a holiday,
This is of 2001, right? Or like 2000 going into 2001.
Yeah.
Okay.
And she's like, oh, well, I'm going to go, or maybe it was, I don't even remember, it may have been right before Christmas. At some point during the holiday, we went to Hilton Head just for the weekend, and she was there, and we were like, Tara, why? It was New Year's, because we wouldn't have been gone for Christmas, and we were like worried about her being there, like, you need to go home and be with your family, like during break or whatever. Like, we just were shocked that she was there. And, we went on our trip or whatever and came back to school, in January or whenever classes started back. But when class started back, we hadn't been there, 2 weeks, because I had just graduated in December and I was starting my master's in January at UGA. We had not been back, whatever week or week and a half, whatever all that was when all this happened. She hadn't been going to Chris's house at night. So when I say she went there that often, it was weird that she was at home.
Oh, okay. So I didn't catch that earlier. Like, she was at Chris's house, like, almost nightly?
It was a lot.
Okay.
It was for that, but like I said, I can only speak to first
3 months,
semester.
yeah.
I don't know, what her life was like before. But when we came back from break, and Ashley will tell you the same thing, there was a significant change in that. But again, that's her business. We didn't want to ask any questions. And I think maybe Ashley or I maybe did say, are y'all okay? And, so maybe they were having a tiff or whatever. But Tara was really private about her life and, details and that kind of thing. But there was definitely a change when we came back in January. She was not spending, she wasn't spending the time she had been spending at Chris's.
Okay.
Which is, why everybody was wondering if something was going on. But we, like I said, we didn't pry, we didn't ask, that was her business. We just said her, basically just checking on her. And Ashley, she may have exposed Ashley yeah, we had a tiff or a fight or whatever.
Yeah.
But
But it was like a noticeable shift.
definitely.
Is that fair to say? I don't want to put words in your mouth.
No, it was definitely a shift. And like I said, you can go back to the notes of when all that, and I'm sure that
I'll have to go.
we said the same thing, because it was just, like I said, I can't remember a lot of things, but I remember the details of a lot of this that were just very vivid to me, that something wasn't right.
And she was a very private person.
Yeah, she was, she wasn't one to overshare, what's happening in life. And maybe to Ashley, maybe she confided in her more, because, they were friends for a long time.
Okay. Were you aware of any of her sexual life with?
I'm going to fast forward the piece to get to the next portion that I'm going to ask you questions about, okay?
More so probably day to day, doing stuff together, hanging out, because Tara was always doing the law school thing and studying.
Okay.
And, and I think going back to the whole Chris and January thing, I don't know. I remember one of the things she said was oh no, I'm just trying to buckle down and I'm basically she needed, that was a distraction for her, and she was buckling down on her studies was kind of the way she blew off when we checked on her to make sure she was okay. Just because her behavior had changed. And not her personality or anything like that. It's just no, I'm just...
Like her routine.
I'm just, yes. And if you live with somebody and something's completely...
In the last portion that'll be a part of the examination, Ms. Low, Dr. Low, excuse me.
everything, and she was like, I don't see anything that's missing, like, from your stuff. Everything looks just like you left it. It was, like, in perfect shape, like nothing's gone. I mean, I even had, like, you know, there's big jars you throw in money and change, and I even had, like, that in my, like, if somebody wanted, if they were coming there to rob us, they would have, I mean, I
Had a
had
field day.
expensive jewelry, I had, you know, purses, I had, like, I mean, they could have taken a ton of stuff, but nothing.
Do you recognize your voice?
Yes.
Is there a first recollection?
Yes, those are my statements.
Thank you. Thank you, Your Honor.
Your Honor,
Yes.
trying to make good use of everybody's time.
Yes.
I think this is probably a good time to address Mr. Cruz's residual hearsay motion.
All right.
I would say that the state does not oppose him asking what I.
All right, let me get the residual hearsay motion, though, that you're talking about, because there were 3 that were filed. So, all right, so Mr. Bolden, you're talking about the pending motion that the defense filed on January 20th with regard to Dr. Valerie Low Lang. Is that right? Is that what you're referring to?
Yes, Your Honor.
Okay, and your position is?
We don't oppose that motion.
All right, any response?
No response.
All right, then I will grant it. Motion was filed, the state does not oppose it. All right, anything else before we bring the jury back?
No, ma'am.
All right, could you bring the jury back, please? He just wants to see the motion. I have written at the top of it my order, but you can show that to the state, Mr. Allen. Michelle, you can take a look at it if you want. We'll make a copy if either one of you want it. All right, thank you.
Oh, that's fine. Just gonna get in there and start talking to them, asking them this side's approach. Will you at least let us know what you're going to be talking about? Okay. Thanks.
Please be seated. Mr. Cruz.
Yes, ma'am. Dr. Lowe, you would agree with the statement that the day that Ms. Baker was killed, it was almost like someone knew that you and Ashley weren't going to be home. Is that correct?
Those are my statements.
I can't hear you.
Those are my statements, yes.
Yes, ma'am. Can you pull the mic up? Thank you. And the reason you said that is because it was rare for both you and Ashley not to be home. Is that correct?
That's correct.
I'd like to discuss your observations of Chris and Tara's relationship. Is that okay?
Yes.
During the first semester of law school, during the first semester of school, Ms. Baker, Mrs. P.V. Hall, and yourself, you all stayed together at 160 Fun Drive. We would agree on that.
Yes.
Okay. You would agree that during the first semester of school, Ms. Baker would always be at Chris Milton's house. Is that fair?
I can't say always. Often. A lot.
Do you recall telling Investigator Black, first semester of school, she would always be at Chris Melton's house all the time, like every night. It seemed like she was never at home. And then when we got back for second semester, Tara wasn't doing that anymore.
That's concurrent with what we just heard, yes.
Well, no, that wasn't on what we just heard.
Right,
That's a separate. Okay.
Yes.
But you agree with that statement?
Yes.
And you would have no reason to disagree that the first semester of school entailed August of 2000 and December of 2000.
Correct.
Right? Let's talk about second semester. Okay, second semester for the purposes of our conversation would have been January 2001 until May 2001. Was that fair to say?
Yes.
Now, on New Year's Day of 2001, do you recall stopping back by your house at 160 Fun Drive?
I don't remember exactly. That's been 25 years ago which day we stopped by, but we did stop through Athens.
Based on the recording that you heard, do you recall stating on New Year's Day 2001 you were on the way to Hilton Head Beach? It was you, Mrs. Ashley P.V. Hall, Chris Hall, and your significant other. Do you recall making that statement?
Yes.
And when you stopped in at your home on New Year's Day, you found that Miss Baker was home alone.
Yes.
And you were shocked to find Miss Baker home alone on New Year's Day. Is that correct?
Yeah, I mean, typically college students would go home during the holidays, but I, hadn't lived with Tara, so I didn't know her patterns of when she went home and when she wouldn't have gone home.
Okay, and based on our discussion regarding how she was with Chris from August to December, is it fair to say that you probably expected her to be with Chris?
I don't know where I would have expected her to be. It was the holidays, so.
But you and Miss Ashley P.V. Hall, you two were with your significant others, is that right?
Yes.
Now, from January 1st to January 19th, that's going to be the focus of this portion of our conversation, okay? You would agree Miss Baker had stopped going to Chris Melton's home, is that right?
She hadn't stopped going there. She just wasn't going as often, I would say. I don't remember fully, how many days a week or anything like that.
Do you recall making the statement, when class started back, we hadn't been there in like 2 weeks, we had not been back, week or week and a half, whatever all that was when all this happened, she hadn't been going to Chris' house at night. Do you recall making that statement?
Do you have the transcript, or is that what you just played?
Do you recall making that statement?
I'd like to see it.
You would like to hear it?
Yes.
I would move to introduce minute mark 1632 through 1651 of Defense Exhibit 22, which is court's indulgence. Ms. Lang, do you recall speaking with law enforcement agent Elizabeth Bigham?
Yes.
Okay. And do you see Ms. Bigham in the courtroom?
Yes.
Okay. And you've heard portions of your recording with Ms. Bigham, is that correct?
Yes.
And is it fair to say that it was you on that audio?
Yes.
Okay. Had it been altered from what you heard, had it been altered in any way?
I'm not aware that it had.
Okay. Thank you. Your Honor, I would move to introduce portion or minute mark 1632 through 1651 of Defense Exhibit 22 into evidence.
Any objection?
I don't know that he's laid the grounds for it being an inconsistent statement. So I guess I would object on this ground.
All right, I'm going to sustain the objection. I think that's correct, but I'm going to let you refresh your recollection, and I'm going to ask the jury to go into the jury room one more time. Please don't discuss the case, and we can do that.
Well, Your Honor, I have a case for you.
I'll let you.
But
outside the presence of the jury.
Yes, ma'am.
You all may be seated. So, Mr. Cruz, you can tell me whatever you want to, and that's fine. But it sounded like she was offering to have her memory refreshed, which you had already done, and you can do that again if you choose to. But if you want to make a different argument, go ahead.
I'll follow the Honorable Court's order. I'll just put the case law on the record if
All right.
the Honorable Court will allow me. Your Honor, just for purposes of the record, I provide the court with Hayes v. State, which is 320 Georgia 505, page 518. That is 910 Southeast 2nd, 198. This is a 2024 case. It states, if a witness testifies that he cannot recall making a prior statement, this is the same as a denial, and extrinsic evidence of the prior statement may be presented in evidence. In support of that proposition, I also cite Scuniers, which is S as in smile, C as in car, O as in orange, N as in nice, Y as in yellow, E as in eggnog, I as in rhinoceros, and S as in sailor. V State, 318, Georgia, 855, 901 Southeast 2nd, 170. That's a 2024 case. Also, Murdoch v. State, which is 299, Georgia, 177, page 179, which is a 2016 case, cites or states, if the witness testifies that he cannot remember the underlying facts, this is an implied denial of any prior statement on those facts. So I just wanted to put that on the record, Your Honor.
All right, thank you. I think at this point, Mr. Cruz, I'll let you refresh your recollection. The understanding of the court from this witness is not necessarily that there's no memory of any statement being made, but the specific question that you asked. You can go ahead and refresh your recollection. If that doesn't satisfy you in your questioning, we'll go ahead and talk about sort of the next steps, and you can renew your motion.
Yes, ma'am.
All right, go ahead.
Thank you, Your Honor. And let the record reflect that I am playing minute mark 1632 through 1651 of Defense Exhibit 22, which is identified as Ms. Valerie Low's interview with Agent Elizabeth Bigham.
Started back. We hadn't been there like 2 weeks because I had just graduated in December and I was starting my master's in January at UGA. We had not been back a week and a half, whatever all that was when all this happened. She hadn't been going to Chris's house at night. So when I say she went there that often, it was weeks.
Does that refresh your recollection?
Yes.
Any other questions of this witness?
No, ma'am.
All right, any other motions we need to take up before the jury comes back in?
Not from the defense, Your Honor.
All right, thank you. All right, you may call the jury back in. Anything from the state? All right. You all may be seated. Mr. Crease, you have the floor.
Thank you, Your Honor. Now, during the month of January 2001, Ms. Baker had stopped going to Chris' home. Is that correct?
Yes, I don't know how many days a week or anything like that, but she was not going as often.
My question specifically is, during the month of 2001, Ms. Baker had stopped going to Chris' home. Is that a yes or a no?
Yes.
You also noticed that she was no longer spending much time with Chris. Is that correct?
That is correct.
You would agree that there was a noticeable shift in the relationship between Chris and Ms. Baker before her death?
I don't know anything about their relationship necessarily, but her patterns had changed.
Okay. Ms. Low, you recall speaking with Agent Bigham in regards to the shift in Ms. Baker's relationship? Do you remember that conversation?
I do.
Okay, so this isn't the first time you've been asked that question about the shift in Ms. Baker's and Chris Melton's relationship. Is that correct?
That is correct.
In your statement to Elizabeth Bigham when she asked you, but it was like a noticeable shift, you said definitely, it was definitely a shift. Is that correct?
That's correct.
Okay. Let me ask you this. Would you agree that some of your answers have changed here today versus when you spoke with Agent Bigham?
No, they have not.
No?
I mean, it's been 25 years, so I've been asked lots of questions over the years.
That's fair. And you would agree that you spoke to Ms. Bigham last year. Is that correct?
I believe it was, I don't remember when the arrest was, maybe 2023?
Sorry. I am incorrect. Do you recall speaking to Ms. Bigham on May 3rd, 2024?
Yes, I do remember speaking with her.
And some of the questions that I am asking you, you've learned are the same questions that Ms. Bigham has asked you, correct?
Yes.
And would you agree that some of the answers that I've gotten originally have been different from the answers you've given Ms. Bigham?
I don't recall that, but I mean, I'll listen to the statement that you played.
Okay. Is there any reason that do you feel the need to protect Chris Melton?
No, I don't.
Okay. And you are going to be truthful and honest with the jury?
Yes.
Okay. After noticing the shift in Ms. Baker's relationship, do you recall asking her if everything was okay?
Yes.
And based on Ms. Baker's response, it is fair to say that your takeaway was that Chris was no longer a focus for Ms. Baker.
Her focus was on school.
Is it fair to say that her relationship with Chris was a distraction for her?
Yes. Her focus was on school.
Now, we've agreed that on January 1st, or New Year's Day, Ms. Baker was home alone. Is that correct?
Yes.
Okay, and January 19, 2001, she was killed. Is that correct?
Yes.
And I like to put this in context for the jury, okay? We agree that 3 people stayed at 160 Fun Drive. We've already discussed that. We agree on that, correct?
Yes.
Okay. And although Ms. Single may or may not have been single, I want us to assume that she's with Chris Melton, okay?
Can you repeat that?
Sure. We're going to assume for this conversation that Ms. Baker is still with Chris Melton on January 19th, okay?
Yes.
You were dating Jeffrey Hall.
Yes.
Okay, so we have 3 roommates. We have Jeffrey Hall. Ashley Peavy was dating Chris Hall. Okay, so we have Chris Hall. So we have Miss Baker. We have you. We have Mrs. Peavy Hall. I want to make sure I get her name right. We have Chris Hall. We have Jeffrey Hall, and we have Chris Melton. So at any given time, there could be 6 people in that house. Is that right?
Correct.
Okay. And even with the single car in the driveway, there could still be at least 2 people in the house. Is that right?
Correct, if someone had somebody there.
Okay. Well, boyfriend, girlfriend, couple. Is that fair? Okay. Based on the number of people that could be in the house at any given time, is it fair to say that it seems as if the person that killed Miss Baker was certain that she would be home alone?
Sustained.
Your statement to law enforcement was that it was like someone knew that she was going to be home alone. Is that
I'm going to overrule that objection.
Can you repeat that?
Absolutely. Your statement to law enforcement was that it was like someone knew she would be home alone. Is that correct?
I did make that statement, yes.
Now let's talk about the items that you had in your room, okay? You had a jar full of change and money in your room. Is that right?
Correct.
That was not taken.
No, sir.
Okay. You had a lot of purses in your room, correct?
Correct.
Those were not taken. Is
No,
that
sir.
right? And you also had expensive jewelry in your room. Is that correct?
That's correct.
And that also was not taken. Is
No,
that
sir.
right?
No,
And
sir.
I'm sorry, I didn't mean to cut you off.
Go ahead.
No. I think you were answering. I spoke
I
while
said
you were
no, sir.
speaking. I'm sorry.
I said no, sir.
And all of this was in the open in your room, correct?
Yes, sir.
But none of your property was missing from the home, and everything looked exactly how you left it.
I did not go to the house, but yes, everything was still there.
Yes, ma'am. Based on none of your valuables in your room being stolen, is it fair to say that it seems that the person that killed Miss Baker came there specifically for her?
Yeah, speculation.
Sustained.
But nothing was taken from anyone in the home?
No, sir. Or not from my room. I can only speak to myself.
Yes, ma'am, that's fair. I have no other questions for you. Thank you so much, Dr. Low.
Any redirect, Mr. Bolden?
Dr. Low, you mentioned that in the fall semester, Tara had been spending a good bit of time over at Chris's. Were you aware of where that apartment was?
Yes, sir. I believe I remember.
Where was it?
I believe it was off Millage.
Is that here in Athens?
Yes.
In January, do you have any knowledge as to where Chris was living at that time?
I think he was living in the same place, but I don't fully remember, but I think he was.
Do you have any knowledge of him spending more time at his parents' house?
I remember times that there were, if he had work, in that area, yes.
And then lastly, Dr. Low, I for some reason can't remember to ask this question. In the days subsequent to Tara's murder, do you remember being asked to submit samples of your hair in connection with the investigation in the case?
Yes, sir.
And did you provide those?
Yes, sir.
That's all I have, ma'am.
Any recross, Mr. Cruz?
No, ma'am.
May this witness be excused.
They would ask that she be excused.
Any objection, Mr. Cruz?
If she's under subpoena from our office, I just ask that she stays on call status.
Is she under subpoena from your office?
Abigail would know. Wilson would know. He'll be here Friday. But I believe she is. I believe all of Miss Baker's roommates and family members are under subpoena from our office. I just don't want to say it certainly without.
All right. You are free to go for today if you are under subpoena. It's unclear to the court whether you are. You are? Okay, thank you. You are still under that subpoena, but you are free to go.
Thank you.
Thank you. You may call your next witness.
Do we ask the witness if she has been? I mean, she would know.
She just stated she was.
Okay, I didn't
She
hear
did
that,
just,
Your Honor.
sorry.
I'm sorry.
She did. You are free to go, ma'am. You may call your next witness.
Reynolds McLean?
Could you get Reynolds McLean?
Your Honor, I am going to use the Elmo.
All right.
Trying to save us a little bit of time. Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. You can put your hand down, sir. If you could state and spell your name for the court reporter, please.
Reynolds McLean, Reynolds McLean.
And Mr. McLean, I want to take you back to January of 2001. What were you doing at that time, sir?
I was here in college, University of Georgia.
Okay. And where were you living that year, that school year, August 2000 through 2001?
Yes, I lived in 147 Fawn Drive in neighborhood Deer Park.
And who were your roommates?
Jay Anderson, Matt Owens, John Roberts, and Richard Kevin Ford.
Kind of a full house, I guess. Okay. So I'm going to show you, and hopefully you can see this on the screen down to your right, sir. This has been previously admitted as State's Exhibit 37. Do you recognize that to be kind of an aerial shot of Deer Park as it existed in 2001?
Yes, I do.
And so the screen, you can actually touch it and circle the residence where you were living at the time, if you recognize it. Okay.
That one right there.
And we're going to leave that circle there for just a minute. And so on January the 19th of 2001, were you aware of a fire and a murder that had also taken place in Deer Park?
Yes. It was a class. I came back around 11 or 12 o'clock that day, and fire trucks and all kind of craziness.
So again, I'm just going to ask you to circle on that map. What house was that? Gotcha. So was that basically directly across the street?
Yes, sir.
Do you recall anything out of the ordinary occurring in the early morning hours of January 19th, 2001?
Yes. That morning, I remember waking up. It was oddly hot in my room that morning in the house. I lived on the second story. Went over to the window to get some fresh air, and I saw someone walking down the road.
And I'm going to stop you right there. Do you remember about what time this was?
Around 8 o'clock in the morning.
Okay. So 8 o'clock in the morning, you look out the window, you see somebody. Describe exactly what you saw.
I remember seeing somebody walking. If you're looking out my window down at the house across the street, they were walking left or right to left, so sort of east.
And let's just clarify. So would that have been, again, you can kind of use your finger to draw a line in the direction that you saw the person walking. So would that have been away from Cooper Road towards the back of the neighborhood?
That's correct.
All right, I'm going to stop, let you pick back up on this individual that you saw.
So yeah, they were just walking down the road. They were on the closer side of the road, the opposite side of the road, closer to the house across the street side of the road. I remember them walking at a normal pace. The person had on an orange shirt of some sort. It's the memory that stands out.
Male, female?
Yeah, male, young male.
White, African American?
African American.
You remember anything else about that person's description?
No, I think they had on some sort of brownish khaki colored type of pants. They looked to the left and the right. They were walking, and that was it.
I'm going to try and, Your Honor, if you could maybe clear
Yes.
the screen. I'm going to zoom in, Mr. McLean, just because I think this is important. Maybe a little too much. Okay. So I think we've already established that the house with the tarp on it is 160 Fawn Drive. I think that. So, again, maybe just with a little dot or something, where was this individual when you first saw them?
Right about here.
Okay. I'm sorry. Am I seeing? Okay. I see it now. And after you first saw that individual, what did you do next?
I saw them walking for a second. It stood out because it was just early in the morning. They clearly weren't trying to exercise or anything like that. They weren't wearing exercise clothes. It just looked, stood out to me. So then I went in my bedroom 2-3 steps away. I had, it was in college, so I had milk cartons as I was using to hold my clothes, and I grabbed some boxers and a T-shirt, took 2 steps back, looked back out the window to sort of see what was going on, and then the individual's gone. And so I looked down. I was on the. If you're facing the house that I lived in, sort of the opposite direction, I was on the right side of the house, and so I looked out my window and looked down to the left as far as I could, down to the right as far as I could. Just looked down the road, couldn't see anybody, and so then they were gone.
When you say you look to the left and the right, you mean up and down Fawn
Yes.
Drive?
Yes. Yes.
Okay. And to be clear, you didn't see that individual the second time?
No, they were gone.
Based on your observations, what, if any, explanation did you have as to where that person may have gone?
Well, I think the only explanation is, if they were walking, they had to have gone between the houses. I mean, take a left or a right off of Fawn Drive, going between the houses.
Sir, those are all the questions that I had for you. Mr. Cruz may have some questions. Thank you.
Cross-examination.
Good morning, Mr. McClain.
Good morning.
My name is Ahmad Cruz. I have the privilege and honor of representing Mr. Faust. I just have a couple of questions for you. Is it okay if I ask them?
Yeah, absolutely.
All right, thank you. I believe we established that you lived across the street from Miss Baker at the time of the fire at her home. Is that correct?
Yes, sir.
Okay. And you also spoke with law enforcement on January 19, 2001 as well, correct?
Yes, sir.
Okay. So this is the same date that you saw the individual walking?
Yes,
So that would have been fresh in your memory at the time that you spoke to law enforcement?
I believe so.
And I believe I heard you correctly. You stated it was around 8 a.m. when you saw this individual?
I believe so, yes.
And he was walking east on Fawn Drive?
That's correct.
And I think you're saying he was going down this way? Or going towards the back of the neighborhood?
Yes, that's a good description. If east is the back of the neighborhood, that's the direction he was going.
Yes, sir. And you described the black male as wearing a bright orange short sleeve T-shirt, khaki type pants, maybe dark brown, unknown shoes, and no hat. Is that accurate?
I mean, that's it. That's what I remember, yes.
You stated that this individual appeared to be between the ages of 17 through 23, correct?
Correct.
This individual has short hair. Is that correct?
If that's what I said at the time, but yes, that would be correct.
I ask you this. Do you remember what you said at the time? You don't have to take my word for it. Do you remember?
I don't remember hair. But there are other things that I remember, but if at the time I said that was the type of hair they had, then I was truthful with that statement.
Yes, sir. Court's indulgence, Your Honor. Was seeing a summary of your statement refresh your recollection?
I'm sorry, could you repeat that?
Yes, sir. Please forgive me. Would seeing a summary of your statement regarding the description of the individual you saw refresh your memory?
Yes.
If you look at page 4 of 7, paragraph 2, sentence number 4. Okay.
I haven't seen what Mr. Cruz just handed the witness. No, I know what that is. Okay, you seen it?
May I, Your Honor?
You may.
Okay.
And read that sentence, and once you've had opportunity to read it and your recollection is refreshed, just look up.
McLean described the black male wearing a bright.
You don't have to read it aloud.
Oh, okay. I'm sorry.
I'll ask you some questions on that.
Okay. Yeah. Yes. Yes.
Would you agree that you described the black male who appeared to be between the ages of 17 through 23?
Yes.
Okay. Short hair.
Yes.
Okay. And a medium dark complexion.
Yes.
Now, we would agree that the individual was not wearing a hat. Is that correct?
Yes.
So it's fair to say that his face was fully visible?
Yes.
And you said that he was walking at a normal pace.
Yes.
And when you saw him, he was walking in the roadway. Is that right?
That's correct.
And the roadway was open and visible.
That's correct.
You would agree that he was also wearing a bright red or orange shirt, which made him easily observable. Is that correct?
Yes.
And there was nothing that you can recall about his appearance that would prevent recognition.
No.
And there's a Walmart on the opposite side of Deer Park. Do you remember that?
Yes.
Okay. Was it common for people to walk through Deer Park to cut through to go to that Walmart in your memory?
I don't feel like I could answer that statement. I never walked to the Walmart.
That is fair. Thank you so much for your time. Those are my questions.
Okay.
Any redirect?
Very, very briefly, Your Honor. Mr. Cruz just asked you a question about this individual wearing a red or orange shirt. What is your recollection as to the color of the shirt?
It was orange.
Mr. Cruz, anything else, sir?
No, ma'am. Thank you for your time.
May this witness be excused.
Ask that he be excused, Your Honor.
All right, you are free to go, sir. Any objection, Mr. Cruz, sir?
No, ma'am.
All right, you're free to go.
Can we have 10 minutes? Your Honor?
We may have a 10-minute recess, yes. We'll be back on the record at 10 to 11. I'll let you all have a restroom break. If you'll go into the jury room, of course, don't discuss the case. We will be with you shortly. Thank you. We'll be in recess for 10 minutes.
Judge. Just briefly, after Ms. P.V. Hall stepped down from the witness stand, she indicated to our office that she had not, in fact, received a subpoena from the defense.
Okay.
And was asking if she would be able to come into the courtroom to observe things. Told her we'd have to talk with the court about that.
Okay. Any response? Did you think you subpoenaed her, or do you have any other information?
Sure. Well, I do want to be candid with the court. If I could call the office, I would have known I would have called the office to confirm. But if I could call the office, I could let you know. We have tracking on all this.
Okay, that would be great. Can you do that right now?
Absolutely.
All right, thank you.
And there's one other thing, Your Honor.
Hold on, Mr. Cruz. Don't go anywhere. Yes.
Sorry. Our next witness is in a wheelchair.
Okay.
We're going to get her. She's confident she can get up in that witness stand, but I would ask that we do that before the jury comes out. I think it would just be better.
Well, sure. I don't have any problem with that, but I do want to make sure that this is a person that can't. Are you suggesting that this person can get out of the wheelchair and climb up the steps?
She told me she can.
Well, I don't know that that's necessarily necessary. I mean, she can certainly testify in front of the witness stand and things of that nature. I mean, I really don't want anyone to risk getting hurt.
100% agreed, Your Honor. Again, I also asked her if she would be willing to testify from the floor or not.
Okay.
She said she could do it.
I'll let you handle that, but I have no problem with her being next to the bench with the microphone.
Thank you, Your Honor.
All right. Go ahead, sir. If you'll make that call, that'd be great. Thank you. All right, we're going to go back on the record. Mr. Cruz?
So we, so for certain witnesses, the state asked us to send the subpoenas to them based on witnesses saying, or they're exercising the statutory right not to be contacted by the defense. I had a different interpretation of the statute, but I also wanted to fall in line just in case, just to err on the side of caution. So what we did, we sent a subpoena to Ms. Ashley P.B. Hall. We sent it to 3467 Ridge Mill Circle, Dacula, Georgia. I believe that's the information that we have. But also, just to cover both bases, we also sent a copy to the state, and the state said that.
Since those two individuals have elected not to be contacted by the defense and are victims in this case, or family members of the victim who are entitled to protection under Marcy's law, that we would accept service on their behalf. We never said that about Ms. P.V. Hall or Dr. Low.
Okay. And Mr. Yalmanchili, can you tell the court what it is that Ms. P.V. Hall said to you about the subpoena?
This is second-hand, Your Honor. I'll just preface it by saying that. But she, after she left the courtroom or on her way out of the courtroom talking with some of the members of our victim witness assistance team, that she had not received a subpoena from the defense, and therefore she was wondering if she was able to come into the courtroom to view the proceedings.
All right. Thank you. Mr. Cruz, anything else, sir?
We could send down a court the tracking information if the court would like, just to perfect the record.
All right. Thank you. Mr. Yalmanchili, I'm going to ask you to ask your victim witness advocates to get the information from Ms. P.V. Hall as exactly what she understands about this whole subpoena issue. If she relays to your staff and then relays to you, which will relay to the court, that she has not received a subpoena from the defense, she may be in the courtroom. So that'll be the order. All right. You may go ahead and call your next witness. Yes, sir. All right, and Mr. Bolden, are you ready for the jury? I know you're working on the microphone, but ready for the jury?
Yes, Your Honor.
All right, Mr. Cruz, are you ready for the jury? All right, thank you. You may bring the jury in. You can go ahead, Mr. Bolden. You all may be seated. Thank you. All right, welcome back, ladies and gentlemen. We are back on the record. Mr. Bolden, you may call your next witness.
Thank you, Your Honor. Ma'am, I'm going to ask you, well, you got a battery pack in your right hand. Maybe, can you raise your right hand?
Yeah.
Okay, there we go. Ma'am, do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. And I'm going to ask you, please, to state your name and spell it for the court reporter, please.
Marla Lawson, Marla Lawson.
And Ms. Lawson, I want to talk to you a little bit about your career. Can you tell this jury what you have done for a living, ma'am?
Oh, gosh. Well, I started out in 1970s at the Atlanta Police, at Underground Atlanta, and was a street artist, and they hired me on the Atlanta Police Department as a typist. So I typed reports mostly, and then word got out around the bureau that there's a girl downstairs who can draw a face. So, I mean, that's about the way it went. I started drawing the faces of perps and everything else for the detectives. And stayed there for about, 20 years.
Okay. Did you then go on to draw faces for Coweta County?
Yes, sir. I drew them for Coweta. Well, heck, I drew for everybody. The whole time I'm, just working. Coweta County, Cobb County, most of the cities.
Did you spend about 16 years as I'm sorry, I didn't mean to do that. Doing forensic sketches of. Did you spend about 16 years doing forensic sketches or for the Georgia Bureau of Investigation?
Yes, sir.
Can you talk a little bit about your training and background as it relates to forensic sketch artistry?
Well, I don't really have any background or any training. I just kind of picked up a pencil and went to town. And after I did that, I wound up doing it for almost 20 years. I don't know. I just always have fallen into the right job for whatever somebody needed.
Your Honor, can you turn the Elmo off? Thank you. While you were working as a sketch artist, did you attend courses
Yes, sir.
related to that?
Yeah, I took all the courses that there were at the, trying to think where. All the courses that they offered, at the.
I tell you what, Ms. Lawson, I'll move on. Did you ever win any awards for your forensic sketches?
Yes, sir. But the most public display of awards was for Eric Robert Rudolph, because when the Olympic Park bombs went off, they called me, and I go over there to draw his face, and he was relatively famous, I guess you'd say.
So I understand, did you draw a forensic sketch related to the 1996 Atlanta Olympic
Yes, sir.
bombing?
And most high-profile cases in between, they would call me. I mean, I was at GBI, but
You would work for other agencies?
yes.
I got you. Okay. Over the course of your career, do you have any idea how many forensic drawings you would have completed?
Good Lord. No, I would estimate 1,000.
Have you ever been asked to come into court and testify about your sketches before?
Yes, sir.
Yeah, have any idea how many times?
Probably no.
Ms. Lawson, I want to talk a little bit about the process of creating a composite drawing.
Okay.
And so kind of walk through that with me. How do you first meet with the individual that you're questioning and then go through that process if you can?
Okay. The detectives interview the witnesses and the victims and everybody, and they bring them to me, and I would show them a big, huge stack of old mugshots and photos of suspects and just old photos that I have in a big case that I dragged from pillar to post way back when. And I would tell them as they're looking at the photos, pick out anything that reminds them of the person, eyes, nose, shape of the face, teeth, hair, anything, pull it to the side and we would talk about it. And the average person would probably pull out 15 photos, and I would just draw it together into one face and hold it up, and they would help me change everything on it until we get it as far looking like the person that they remember, as they could. And I get them to rate it when we're done on a scale of 1 to 10. And as far as 10 being him and 1 not. So we just make corrections along the way, and
How long does this process take on average?
it probably takes 45 minutes per person.
And you mentioned kind of the ranking at the end. Is there a number by which you say, okay, like we're going to stop, or can you kind of describe that for me?
Yeah, I tell them to pick out a number between 1 and 10 as far as it looking like the person that we sketched. And they usually pull out, I guess, 3 photos for that too, By this time, I've got them accustomed to digging through the photos. And we try not to quit working on the sketch until at least we get an 8 on a scale of 1 to 10.
That mean if the person were to give you a impression or a number that was less than 8, you would keep working. Is that fair to say?
Yeah, because in my opinion, anything below an 8, it's not worth circulating. But anything above an 8 or an 8 is a pretty good recollection of their memory.
Ms. Lawson, as you sit here today, do you have any recollection about coming to Athens, Clark County to assist in an investigation back in January of 2001?
No. Yes, I do. I don't remember drawing the 3 composites that I supposedly had to draw, but
Have you had a chance to look at them, though?
I haven't even seen them.
Okay. Well, I'm just going to, if I can approach you.
Okay.
Ms. Lawson, we've got States 99 and States 100. States 99.
Uh-huh.
And what I want to point out there, ma'am, is do you recognize what's on the lapel of this individual?
Yes, sir.
What's
That's
that?
my
I
name.
got you. And then on States 100, I didn't see one there.
Well, you get busy and you get in a hurry and
Okay.
you might not get them signed or you might get them signed. I mean, you know, I'm kind of haphazard.
All right, give me just 1 second, Ms. Lawson. I want to make sure I didn't miss anything. Ma'am, I don't have any further questions for you. Defense counsel may have some questions. Thank you, ma'am.
Mr. Cruz, cross-examination.
Good morning, Ms. Lawson. How are you? I'm doing okay, Ms. Lawson. I'm maintaining. I thank you for being here today. I just have a couple of questions for you, if that's okay. All right. I'd like to show you a couple of composite sketches that you did in relation to sightings in this case. I'm going to mark those exhibits as Defense Exhibit 23 and Defense Exhibit 24.
I do have an objection to these exhibits, Your Honor. It's under 401 and 403.
All right. Let me ask you this question, Mr. Bolden. Do you have an objection to the admission of those exhibits? Okay. All right. I'm going to let you get started, and if you choose to try to tender them, I will hear your objection.
Yes, ma'am. Thank you. Ms. Lawson, do you recall completing sketches on Friday, January 26, 2001? Yes. Okay. I'd like to show you, and would you recognize those sketches if you saw them? Yes. Okay. I'd like to show you two sketches. And let the record reflect that I've shown Ms. Lawson Defense Exhibit 23 and Defense Exhibit 24. Do you recognize Defense Exhibit 23 and Defense Exhibit 24?
Yes, sir.
Okay, and these are sketches that you did for Athens, Clarke County on January 26, 2001?
They appear to be.
Yes, ma'am. Do they appear to be altered in any way?
They don't look like it, do they?
No, ma'am, not to my knowledge. Your Honor, I would move to admit Defense Exhibit 23 and 24, and I can respond to the state's relevance objection.
Right.
I do have an objection under both 401 and 403.
All right. Do you care to elaborate?
Yes, Your Honor. Well, one, none of the witnesses that would have potentially given a description to Ms. Lawson have been in court and testified. I do think we need to address some of this outside the presence of the jury.
All right, we will do that then. Ladies and gentlemen, I'll have you go sit in the jury room. Don't discuss the case. We'll be with you shortly. While the jury is leaving, I'm just going to say for the audience, there are a number of people in here who may not have been here yesterday, so I want to make sure everybody understands the court's rule about cell phones. With the exception of the media, who has permission to have cell phones, with the exception, of course, of counsel and their staff, and with the exception of law enforcement and attorneys who are working in this building today, with those exceptions, everyone else is not permitted to have their cell phone out and in use. So if you have a cell phone, just make sure it's tucked away and turned off. Obviously, we don't want it going off. Thank you very much. All right, you all may be seated. Go ahead, Mr. Bolden.
Your Honor, what Mr. Cruz is attempting to introduce through Ms. Lawson, she did provide, I'm not denying that those are sketches that she made at Athens Clarke County Police Department back in January of 2001 in relation to this case. What I would say, Your Honor, is that those sketches are from witnesses who describe seeing an individual in Deer Park days before January the 19th. I mean, that is, like, if Mr. Cruz asserts otherwise, he's mistaken. So these are not relevant. And so not only are they not relevant, any potential, just, the fact that there were people that came to the police department and that gave descriptions to Ms. Lawson on that day in connection with this case is relevant under 401. And I think that the state's argument would really stop there. But even if there was some sort of probative value of that evidence, that it would be substantially outweighed by the risk of confusing the jury, because at this point we don't know who gave those descriptions and things like that. So these are not admissible in the state's view under both 401 and 403.
All right, Mr. Cruz, any response?
Yes, ma'am. Under OCGA section 24-4-401, the term relevant evidence means evidence having, and I emphasize the language any, or the word any, but any tendency to make the existence of a fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And as the Honorable Court is aware, the threshold for relevant evidence is extremely low. The relevance of these photographs is that law enforcement, when they were speaking to individuals in the neighborhood, the individuals that they requested sketches of, as the Honorable Court is aware from the other state's exhibits, are any African American individuals that were seen either the day of the crime or the day before the crime. I believe, I'll say this, and Mr. Bowden has something to counter that, but one was December 18th, which I believe is, not December, please forgive me, January 18th, which was the day before the murder, but law enforcement found it relevant, and Ms. Lawson completed a sketch. The other one was an individual they did see in this one on January 19th. So the evidence is relevant to the issue of, on one hand, we have a young lady saying, hey, I see a guy running. She tells law enforcement that. No sketches requested of that individual. However, law enforcement did request sketches of African American individuals that were seen the day before, as well as African American individuals that were seen not even at the scene, but the day of the fire taking place. Those are the individuals that they chose. So that's in response to the relevance objection by the state. And I know sometimes I confuse my words. Did I explain that wrong to the Honorable Court? Did I confuse the Honorable Court in any way?
I'm not confused.
Yes, ma'am. In regards to confusing the jury, I made it clear in my opening that law enforcement dropped the ball a couple of times, and this is a part of that. We have law enforcement getting sketches from January 18th. We have law enforcement getting sketches from a person, I think he was at the corner of Cooper Road, which is this individual, and Fawn Drive. But yet we have a young lady who explained to law enforcement that, hey, I saw this guy running, and law enforcement did not ask Ms. Lawson or that individual to complete a sketch. So that would be my response to the 401 objection, as well as the 403 objection, Your Honor.
All right, thank you, Mr. Cruz. Yes, sir.
So I would also point out, Your Honor, that the state did file a motion. Soddy motion is what we've been referring to it as throughout all the pretrial hearings and as we've gotten into the case. And, the law is very clear that Mr. Cruz has to proffer that in advance for exactly this moment. The only person he identified in that Soddy motion was Chris Melton. So, and the whole purpose of that is for the court to be able to undergo a preliminary 403 analysis. I cited the cases to the court. I just remind Your Honor, among those being the Crumpton case out of the 11th Circuit. And so there is a substantial risk. Any probative value is substantially outweighed. And I'm not saying that there isn't probative value, to be very clear, Your Honor. But any arguable probative value is substantially outweighed by the risk of confusing this jury, and I just don't think it's admissible.
All right, thank you. Anything further, Mr. Cruz?
No, ma'am. I stand by my argument in regards to the 401 objection as well as the 403 objection.
Thank you. All right. With regard to this offer of these two sketches, at this moment in time, I don't find them to be relevant.
Yes, ma'am.
The evidence has been described as being related to a sighting of someone not on the date in question, and also the other one not in the vicinity of the incident in question. So I'm going to grant your motion. I will say this. Should the evidence, as it goes forward, tend to establish relevancy, we can revisit this issue. But for now, I'm going to grant your motion. I do also find, in granting your motion, Mr. Bolden, that you have made a proper argument over 403. I think at this point, given the description, Mr. Cruz, that you have provided about where those two sketches came from, it is certainly falls under the description in 403 of confusion of the issues. And so I'm going to grant your motion at this time.
May I ask the Honorable Court, I know we have Court's Exhibit 1, which was the PowerPoint. I don't know if the Honorable Court issued a ruling on that, but which was the PowerPoint from the state. I asked the Honorable Court to admit as Court's Exhibit 1. Can we admit Defense 23 and 24 as Court's Exhibit 2 and Court's Exhibit 3 for the purposes of the record?
No.
Yes, ma'am.
All right. You may bring the jury out. Thank you.
I'm sorry.
Yes.
I just thought maybe the issue with Ms. Peavy Hall, we could address it now. Or do you
Go ahead. No, go ahead, since the jury's not here.
I'm not going to say the address again.
Sure.
On the record, and I don't think it went out on the broadcast, but I do want to let the court know that my understanding, after having spoken with our Director of Victim Services, is that that is the correct address for Ms. Peavy Hall, that she has not received a subpoena.
Right.
She began checking because she was notified by Dr. Low when Dr. Low received hers, but she is unaware of any subpoena that was mailed via, I guess, certified mail.
All right. Thank you. Mr. Cruz, any comment? Do you want to speak to the staff that Mr. Yalamanchili talked about?
I do not. As I mentioned to the Honorable Court, I think you made your ruling on the subpoena issue, which I would abide by, of course. I'll just I'll perfect the record with a copy of the certified tracking and return receipt information.
All right. Thank you, sir. You may certainly do that. I'm going to allow Ms. Ashley Peavy to remain in the courtroom if she chooses. All right. Will you bring the jury in, please? Thank you. You all may be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. Ms. Lawson, please forgive me. In regards to your process, I understand that you have them look at photographs, and from there they pick the shapes and different portions, eyes, things of that nature that fit the individual that they see. Is that correct? Okay, and I've had opportunity to look at the Eric Rudolph sketch. I'm sure you have because you've completed it. Typically when you complete sketches and they're on the 8 scale, as you mentioned, are they pretty much similar to the person's description, accurate to the description that you received? Okay, excellent. Do you keep any notes in regards to those pertinent, or at that time, would you keep any notes in regards to the pertinent facial features that an individual described?
I fill out incident reports on each composite drawing that I do, and will sometimes, state whether or not I had any problems or anything was said about, when we were complete, and should they circulate it or whatever. Did they feel good about it? And that's why how we determine the completed, thing, sketch.
Absolutely. So there's well, I'd like to show you a document. I ask for your patience for a second. I'd like to show you a document that I am going to mark as Defense Exhibit 25. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 25. Okay if I approach you, Ms. Lawson?
Yeah, come on. Okay. Yeah.
All right, in regards to Defense Exhibit 25, is that the document that you're speaking of when you say report, or is it a separate document?
That's the document.
This is the document. Okay, excellent. Your Honor, please forgive me. You recognize this document, correct?
Yes, sir.
Okay, and is it a fair and accurate depiction of the document as you remember creating it?
Yes, sir.
Okay, and does it appear, outside of the defendant's exhibit sticker, does it appear to be altered in any way?
No.
Okay. Your Honor, I would move to admit Defense Exhibit 25 into evidence.
Any objection?
Generally, no. I think that based on the court's ruling just a few minutes ago, parts of it would have to be redacted. So
All right.
subject to that redaction, I don't have any objection.
All right, Mr. Cruz, you want to be heard on Mr. Bolden's comment on the redaction?
Yes, I do. Well, court's indulgence. Let me make sure I'm 100% clear on
Sure.
that. In regards to the state's objection, I do believe, based on your prior ruling, I would not be able to admit that evidence. So I don't have any objection.
All right, so I just want to make sure we're clear that the state doesn't have any objection over the admission except for certain portions that need to be redacted based on my ruling, and you agree with that?
I don't agree, but I respect
You're not objecting to that?
position. Correct, yes,
Okay.
ma'am.
All right.
And I just want to be clear because what I think I heard, and correct me if I'm wrong, is that he's now not intending to tender the document?
No, that's incorrect. I do intend to tender the document, Your Honor.
But you're not objecting to the comment, the argument that Mr. Bolden made about certain portions need to be redacted according to the ruling the court has made?
Correct.
All right, then I will admit it with that understanding, and it can't be certainly circulated to the jury until I take a look at that document. We all agree what needs to be redacted, but I will admit it. Go ahead.
So in regards to, and I may need to give you this, in regards to suspect number 1, the composite reconstruction notes, would you agree that you put that the male was black? Is that fair? He was 18 through 21 years of age.
If you could just answer with your voice, yes or no?
Yes.
Thank you very much.
Thank you. He has an orange shirt. Is that correct?
Yes,
Medium brown complexion. Is that right?
yes,
Short 2-inch afro. Is that correct?
yes.
I need to ask you a question about something personal, John.
Nay.
Yes,
And slight mustache. Is that correct?
that's right.
Okay. And I'd like to show you what has been marked as defense, state exhibit 99. Give you both of these Friday. I might have to share that mic. With the description that we put in our report, which exhibit does that description apply to?
You know, I don't know.
That's fair.
Either the suspect 1 or 2, but I should have wrote it legibly across the top maybe, so we, this long gone of a time period, could have figured out who was who.
Yes, ma'am. In regards to Ms. Tiffany Riker, and I'm going to show you what's been marked as defense exhibit 25, okay?
Okay.
In regards to Ms. Tiffany Riker, we don't have a description that she provided. Is that correct?
Let me see if I wrote anything down. No, but the suspect 2 was listed.
Your Honor, this is what we're getting into. Like, state's objection was sustained as to portions of that document needing to be redacted, and now Ms. Lawson's being questioned about the parts to be redacted.
All right, let me see counsel to the bench with the exhibit, please. I didn't hear a question. I mean, she may have started talking about what is it that you're asking. All right. Okay, so what was your objection based on? Three of you confer, four of you confer.
Exhibit 25 into evidence.
Well, it has actually been admitted, but 25 has been admitted. Yes, Mr. Bolden. It's been admitted. I'll certainly let you now use the redacted, according to the court's ruling, Exhibit 25. You may proceed.
Ms. Lawson, please forgive me. All right. Excluding the redacted portion. In regards to this Tiffany Riker, in regards to your description of Ms. Tiffany Riker, would you agree that we don't have a description of the composite sketch completed for Ms. Riker?
I don't see it, but yeah.
Yes, ma'am. And in regards to the 1 through 10 scale, on the document, Defense Exhibit 25, we don't have a notation of whether it was a 8, 9, or 10.
No. Sometimes I just don't write it on the originals because nobody knows what it means.
That's fair.
I guess I should have written it on there. I'm just accustomed to being fly by night, I guess.
That's okay. Would you like to take that back?
Yeah.
I'd also like to show you what I am marking as Defense Exhibit 27. And let the record reflect that I am showing the state what has been marked as Defense Exhibit 27. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit 27. May I ask you some questions about Defense Exhibit 27? Do you recognize Defense Exhibit 27?
Yeah. That's one of my old forms.
And what do you recognize Defense Exhibit 27 as?
Well, homicide, arson, and what would Giroux
Is it?
posits, you know.
Yes, ma'am. Is it fair that is it fair to label it as a summary of the work that you were doing in regards to the date and who asked you to come in.
Yes.
Okay. Outside of the defendant's exhibit sticker, has it been altered in any way? And that is a fair and accurate description of the document as you remember it.
Yeah.
Thank you. I would move to admit defense exhibit 27 into evidence.
I do have an objection under 401 and 403 to the entirety of that document.
All right. You want to be heard outside the presence of the jury.
I think it's probably necessary, Your Honor.
All right, ladies and gentlemen, if you'll go into the jury room, don't discuss the case. We'll be with you shortly. And we are taking a lunch break relatively soon. Please be seated. Your objection, Mr. Bowler?
Yes, Your Honor. So what Mr. Cruz is attempting to introduce here is basically just a cover sheet of Ms. Lawson's report. And I don't see how that has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable. She's already testified to her kind of notes relating to how she generated the sketch. And I with the relevant or irrelevant portions redacted, I don't see any issue there. But now we're getting into the cover sheet of that report, and I just fail to see how that makes the determination of anything more or less probable. The witnesses have both testified that they recognize the sketch. They have been admitted. And I just, again, I don't see why that would pass 401 muster. I would also say that whatever conceivable relevant probative value that Mr. Cruz might argue is once again substantially outweighed by the risk of confusing the jury, because there's reference to these other suspects, which we all agree, or he doesn't agree, but which I have asked the court, and the court sustained my objection relevant to that, is also on that cover sheet as well. So again, first of all, under 401, it's not relevant. Second of all, under 403, whatever relevance it has is substantially outweighed by the risk of confusing the jury.
All right, thank you. Mr. Cruz.
Sure. So in regards to the state's 401 argument, relevance, the relevance of this document is twofold. One, the testimony has shown that these individuals saw 3 different people walking through the Deer Park neighborhood. Okay. Ms. Lawson stated during her testimony that the date that she spoke with these individuals was January 26, 2001. So that testimony has been elicited. It's also in this document as well, just stating on Friday, January 26, forensic artist Lawson traveled to the Athens Clark County Police Department, so on and so forth. So that's one. Secondly, Your Honor, I believe based on, and this is not an evidence, but just for the purposes of speaking to the Honorable Court, I believe her sketches are very accurate. I looked at the Eric Rudolph sketch. I believe the individuals in those sketches are the individuals that gave the information saw. So I'm just putting in place that she did it on February 26th, and to bolster and I know it may be the wrong word, but to bolster the accuracy of the sketches. That's all, Your Honor.
Okay, well, that's an improper use of, evidence. First of all, bolster is probably not the word you needed to use.
Correct.
I agree with you on that.
Support the
I know what
accuracy.
you're saying, but
Yes, ma'am.
bolstering is not
Inadmissible.
proper use of it. But I guess, can I see the exhibit? I'm
Yes,
not
ma'am.
really sure what we're talking about.
May I approach?
Yes, of course. Thank you.
And if I could add, it's a memorialization of the date that she conducted those sketches.
Thank you. Mr. Cruz, can you respond to Mr. Bolden's argument that the reason that 403 is implicated is
Sure.
the reference to, I'm assuming you're saying, the phrase composite sketches of 3 suspects. Is that what you're referring to, Mr. Bolden?
Yes, and I think it is, I'm sorry, Your Honor.
And composite sketches of the suspects. I mean,
3
is that what you're saying?
suspects.
Okay.
Says,
Okay.
word suspects, plural, is mentioned twice in this document.
Okay. And you're saying because there were only 2 witnesses who have been identified as producing testimony to this witness to produce sketches, that the 3 suspects violates 403.
Correct.
All right. Okay. I just want to make sure I understood your argument. Can you respond to that, Mr. Cruz?
Sure. Which portion of 403 are we? Do I need to address?
Well, I would say in general, certainly, but I mean, the state's argument to the court was that it was confusion of the issues.
Sure.
And that was substantially outweighed by.
Sure. Goes without, as the number court is aware, the issue that the jury has to decide is whether or not Mr. Faust is guilty of the charges in the indictment.
I know that, but with regard to that specific argument on this document about the 3 suspects, can you tailor your argument to that?
Sure.
Right.
It's general. We have stated that there were 3 different individuals, actually 4. The state's evidence, they introduced Mr. Matt Owens yesterday. He said he saw a black male with a white shirt and jeans. They introduced evidence from Miss Tiffany Schroeder. She gave a description of the individual that she saw as well. They also introduced evidence from Miss Karen Williams. She gave a description of the individual that she saw. So we do actually have 3. We have 4, but I'll stop at those 3. We do have 3 individuals that have stated that they saw a black male walking in the neighborhood. And we can also add 4 with the witness that came in today and mentioned the individual that he saw walking down the street as well. So I don't think it would confuse the jury because they've already heard evidence of multiple individuals in the neighborhood, Your Honor.
All right, thank you. All right, so that gives me a better explanation of where you are coming from, Mr. Cruz. So this is sort of a 2-part moment. The state's argument that this violates 403, I think, is accurate. I'm going to grant your motion because it's in relation to this witness. Regardless of what you've just mentioned, and I will talk about that because
Yes,
I don't mean to suggest that is, I don't mean to be flippant in that way, but
Yes,
I want to talk about your specific argument. With regard to this witness has been identified as the person who made the 2 sketches that are in evidence, And so the state's argument that this cover letter, and I don't find it to be relevant, but regarding 403, the state's argument that this cover letter violates 403 is appropriate because it refers to 3 different sketches. It, in this particular moment with this witness, does certainly create confusion of the issues.
Yes, ma'am.
I am not prohibiting you from discussing the testimony in the way that you have just described it. You have described the 4 witnesses that the state has presented talking about a person they saw in the neighborhood as being 4 different suspects. The state may choose to refer to those witnesses' testimony differently. But I'm not prohibiting you from talking about those, the comments that the witnesses have made in court about the person that they saw in the way that you've just described.
Yes, ma'am.
But with regard to this witness and this exhibit, I am going to sustain your objection.
Your Honor,
I'm going to grant your motion, sustain your objection.
Yes, ma'am.
Those reasons.
Your Honor, for the purpose of the appellate record, would the Honorable Court be willing to admit this as court's exhibit? I believe that would be 4.
I don't think that's appropriate, Mr. Cruz. I'm not
Yes,
going to do
ma'am.
that. All right, but I'm going to give this back to you. All right. Anything else before we bring the jury back in?
No, Your Honor.
All right. Mr. Cruz, you ready for the jury?
Yes, ma'am.
All right. Thank you. You may bring the jury back in. You all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Ms. Lawson, I want to thank you so much for your time. Those are all my questions.
Oh, thank you.
Thank you.
Any redirect, Mr. Bolden? May this witness be excused. Mr. Cruz, any objection?
No, ma'am.
All right, thank you. You are excused from any further service. Mr. Bolden, did you care to call the next witness? Is this a witness that we can call and then take a lunch break?
We could, Your Honor.
All right, very good.
Well,
Wait, just,
yeah, we can.
all right, we're going to do that. And who is your next witness that you care to call?
Kylie Trob?
Could you please get Kylie Trob?
Just make sure I'm right. Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay. You can have a seat. Ma'am, if you could state your name and spell it for the record, please.
My name is Kylie Trob, Kylleetraub.
Ma'am, how are you employed?
I am employed as a latent print examiner at the Georgia Bureau of Investigation in the Division of Forensic Sciences, and this is commonly referred to as the State Crime Laboratory.
What are your responsibilities at the crime lab?
My responsibilities include, but are not limited to, processing evidence for the presence of latent prints, photographing any latent prints that are developed on these items, conducting comparisons of latent fingerprints to known fingerprints, running searches on the FBI NGI database as well as the Georgia APHIS database, and writing all of my conclusions in a report that I can testify to in court.
Can you tell us a little bit about your education, training, and experience as it relates to that job responsibility?
I received my Bachelor of Science degree in chemistry from the University of Wisconsin-Green Bay. I then completed the 20-week National Latent Print Examiner Training Academy in Meridian, Mississippi, as well as the latent print processing and latent print examination training programs at the GBI.
And can you testify generally about how one might search for fingerprints on items of evidence?
So for items of evidence, they are typically processed based on what type of evidence they are. So a non-porous item such as glass, metal, or plastic would be processed one way, whereas porous items such as paper, cardboard, or things like that would be processed in another manner.
Okay. And why would that be the case? Why would there be a difference in the way that they're tested?
The difference is due to the non-porous items, your glass, metals, and plastics. These items are normally smooth and shiny surfaces, so a fingerprint could be easily wiped off. It's not going to be absorbed into that surface. So we are trying to preserve those as best as possible. And then a porous item, paper, cardboard, these items are going to more absorb the fingerprint residue. So we are going to apply different chemicals to be able to make those visible to the naked eye.
Have you had the opportunity to come to court to testify before about latent print processing at the GBI Crime Lab?
Yes, I have.
Approximately how many times?
Approximately, I believe, 7 times.
And during those times that you previously testified, have you been qualified as an expert?
Yes, I have.
In what areas?
In the area of latent print processing and examination.
At this time, Your Honor, I would move to tender Ms. Trob as an expert in latent print processing.
Any objection, Mr. Cruz?
No, ma'am.
This witness is admitted as an expert in latent print processing. Go ahead.
Thank you, Your Honor. Ms. Trob, did you have the opportunity to test certain items of evidence for the presence of or lack of presence of latent prints in connection with the case involving a victim by the name of Tara Baker?
Yes, I did.
Okay. And if you are aware, were certain items tested back in 2001?
Yes, some of the items that I tested were previously tested.
And what would be your reason for then going back and retesting them?
We have some new chemicals that we did not have in the past that we have access to now to conduct more testing.
Are you aware of what the results were back in 2001?
I do not know exactly what processes were applied, but I do know what the results were, yes.
What were those?
Those were negative results.
Does that mean there were no prints?
That means there were either no prints that were potentially suitable for a comparison or, yes, no prints at all.
May?
This has been marked in States 107. I'm just going to ask you to hold on to that for the time being, okay? So you mentioned testing some items of evidence as it relates to this case. Was one of those things a power transformer?
Yes.
And you said that was 96. All right. So do you recall what testing procedures you performed on that piece of evidence, ma'am?
If I'm able to refer to my notes, I do.
Absolutely.
For the power transformer, I would have conducted a visual examination where I look at the item of evidence as it was received to see if there are any visible latent prints. I then applied a chemical known as lumicyano. This is a fluorescent superglue, so any latent prints that are developed would also fluoresce so that I could look at them under a light source. And then I also applied what is known as powder in suspension. This was a white in color chemical, and this can render any fingerprints that might be in blood visible to the eye.
Moving along to the next piece of evidence, the knife set. The knife block, referred to as, I'm going to use the crime lab's number, item 13.
Yes.
Do you recall performing testing on that piece of evidence?
Yes, I do.
And what testing did you perform on it?
For the knife block, I also started with a visual examination. This was followed by lumicyano again, the fluorescent superglue. I then applied DFO and anhydrine. These are chemicals that are used for porous processing. Since the knife block was made of wood, it would absorb fingerprint residue, so I applied those chemicals to look for that type of evidence.
Okay. Next, I want to talk about item 14, and using the crime lab number. Is that some stove knobs?
That is correct.
Can you describe the testing you conducted on the stove knobs?
On the stove knobs, I conducted my visual examination followed by the Lumi-Cyano.
Okay. And then lastly, on states 15. I'm sorry. Crime lab 15.
Yes.
States 94. Excuse me. What item of evidence was that?
This item of evidence was a knife.
What testing did you perform on the knife?
On this knife, I performed my visual examination, followed by Lumi-Cyano and the white powder in suspension.
As it relates to all four of those pieces of evidence, can you testify as to the results of your search for fingerprints?
For all of those items, the results were negative for fingerprints.
And is States 107 a report that fairly and accurately summarizes the testing that you performed and the conclusions that you reached?
Yes.
And is it signed and dated by you? Or signed with a date on it, I guess?
It is signed with the date that the report was released, yes.
Good to tender States 107 at this time.
Any objection?
Yes, you're saying.
Any response to the hearsay objection, Mr. Bolden?
No, Your Honor.
Okay, I will admit it over objection.
Ma'am, those are all the questions I have. Defense counsel may have some questions. Thank you.
Mr. Cruz,
I don't have any questions for you. Thank you for your service.
Thank you.
may this witness be excused, Mr. Bolden?
Yes.
Any objection by the defense?
No, ma'am.
You are free to go.
Thank you.
You may call your next witness.
Your Honor, now might be, I think we're going to get into.
Well, we're waiting for lunch to arrive for the jury, so we're going to keep going.
Bear with me just a second.
All right? I gotta find out.
Judge, could I step into the hallway for just a minute?
Sir.
To make sure that witness is out there?
Yes.
We will have another witness.
All right? Okay. Yes.
While Mr. Yalamanchili is tracking down that witness, I did just get a text from another witness that the state could put up, and I'm comfortable doing that while he tries to run that person down. Just
That's
follow
perfectly
it.
fine with the court. I mean, it's your case.
John Newton?
Could you get John Newton? Thank you.
Sir, if you could raise your right hand, do you swear or affirm that your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. If you could state your name and spell it for our court reporter, please.
My name is John Newton, John Newton.
And Mr. Newton, going to refer you back to 2001. Where were you employed at that time, sir?
I worked for the Athens Clarke County Police Department.
How long did you work for the Athens Clarke County Police Department?
12 years.
Okay. And during that time, were you a post-certified peace officer in the state of Georgia?
Yes, sir.
And what is that? What does post-certification mean?
Post is the standards council that creates the standards for police officers for what it means to be, I guess, to be an accredited police officer in good standing.
Basically, a sworn officer, is that fair to say?
Yes, sir.
And did you work anywhere else in law enforcement after Athens Clarke County?
After? No, sir.
Okay. Back in 2001, did you help with other officers in the investigation into the sexual assault and murder of Tara Baker at 160 Fawn Drive?
Yes, sir.
And are you familiar with that, where that address is?
I'm familiar with the general area. I don't think I could drive you to right where it is, but right off of Lexington Road, near the church and that neighborhood back in there.
Is that in Clarke County?
Yes, sir.
Now, I know you had a lot of involvement in that case, but I want to focus on just a few very specific things. In the days immediately following Ms. Baker's death, did you have an opportunity to collect head hair samples from certain persons in Tara's orbit?
Yes, sir.
Okay, did that include known hair samples of her roommates, Ashley Peavy and Valerie Lang?
I believe so, but off the top of my head, I couldn't tell you. Like, I would have to look at my report.
Would that help refresh your recollection?
Yes, sir. That would be wonderful.
May I approach the witness, Your Honor?
You may.
Thank you. Yes, sir.
I asked you the same question. Did that include collecting known head hairs from her roommates, Ashley Peavy and Valerie Hall?
Yes, sir.
Did it also include collecting head hairs from Chris Melton?
Yes, sir.
Let's see.
You may.
Then I'm going to hand you what I marked as states 108, 109, and 110. Do you recognize those items, sir?
I recognize what they are. I can't say like off the top of my head,
Sure.
this is it, but yes, this is my handwriting on these, and these would be evidence bags.
And do you take your time to review those items in their entirety? On each of those items, do you see your name or initials on a piece of evidence tape?
Yes, sir. My initial is on, or my signature and or my initial and my handwriting is on each of these.
And what do they appear to be?
One is the known head hair of Ashley Peavy.
Is that 108? With the evidence stickers?
Yes, sir.
States 109, what is that?
Known head hair of Valerie Low
And then 110?
is the known head hair of Chris Melton.
And again, just to be clear, when you collected each of those items, 108, 109, 110, what would you have then done with them?
Put them in the bag, sealed them, put my initials on them, and placed in an evidence locker.
Okay. And from that point on, would you have any idea what may have happened to those pieces of evidence?
I would have an idea, but I wouldn't do anything with them.
Okay.
I mean, I put them in there for the purpose of, further examination, but I wouldn't be involved in that.
I would move to tender states 108 through 110 at this time.
Any objection?
Yes, ma'am. Lack of foundation, one, we don't, excuse me. First, lack of foundation. We don't know if anything is in the bag. I would ask that the witness is allowed to identify what's in the bag. Two, if the bag is what the state seeks to introduce with the writing of whose name it is, I would object to relevance, as the bag is irrelevant to any issue in this case. It's what's inside of the envelopes. So those are my two objections, Your Honor.
Thank you, Mr. Cruz. Mr. Bowling, you care to respond before I make a ruling?
No, Your Honor.
All right. The foundation has been laid for the purpose of admission of evidence. I'm going to admit them over objection.
I'll take those back from you. And then at some point later, in your participation, that's hard to say, in this investigation, did you have the opportunity to once again meet with Chris Melton in an attempt to obtain his pubic hair samples?
Yes, sir.
Okay. And as you sit here today, 25 years later, do you remember exactly when that might have been?
Not without looking at my report, sir.
You may.
Take a minute and see if that helps refresh your recollection.
Yes, sir.
Having had the chance to review what I just handed, does that help refresh your recollection as to when you would have or when you would have collected known pubic hairs, Chris Melton?
Yes, sir. It was on February 27th of 2001.
Where did that take place?
This is the GBI office in Gainesville.
right, Your Honor.
May?
One last thing, states 111, actually take a look at that.
Yes, sir.
And do you recognize that?
Again, I recognize my handwriting and everything that's on it. Right. It's a evidence bag with my handwriting and my initials and the date of February 27, 2001.
Does it have markings that would indicate what?
Oh, I'm sorry. It's the known pubic hair of Chris Melton.
I move to tender states 111.
Any objection, Mr. Cruz?
Yes, ma'am. Lack of foundation to the item that's in the bag, and Rule 401 is relevant. The state is intending to just introduce the bag itself.
Mr. Bolden, any response?
Your Honor, it is relevant. Mr. Cruz has made chain of custody an issue in this case, so we're attempting to introduce the bag. The state will then go on to introduce what the contents of the bag, and so this is the necessary first step. So I think it is relevant.
I'm going to admit it over objection.
Yes, ma'am. And again, kind of like before, Mr. Newton, when you collected those, how would you have them packaged them in item States Exhibit 111?
Right. We would take the evidence, put it in the bag, seal the bag, and put it in an evidence locker.
And understanding, as before, you might have some idea about what happens from that point forward. Did you have any further involvement with States Exhibit 111?
I did not.
Sir, those are all the questions that I have at this time. Defense counsel may have some questions.
Mr. Cruz, cross-examination.
Good afternoon, Mr. Newton.
Good afternoon, Mr. Cruz.
I did not know you would be testifying this fast, so forgive me.
I did not know that either.
I have a couple of questions for you. Is it okay?
Yes, sir.
Thank you. On January 21st, 2001, do you recall capturing pictures of Mr. Chris Melton's hands?
I apologize, Mr. Cruz, but I do not. I probably wrote a report, and if I could look at the report, I could tell you. But this long afterwards, I can't say that I have an independent recollection of what happened.
Yes, sir. That is fair. So what I would do, I'm going to provide you a copy of the report as well as the photographs to give you a
Yes, sir.
look over them. Is that okay?
That's great, sir. Thank you.
Perfect.
I haven't seen them, Your Honor. Mr. Cruz.
Yes, sir.
Thank you. Yes, sir.
Do you recognize those photographs?
I'm not sure the appropriate way to answer this. I recognize what they're photographs of and what this says. Do you by any chance have a report that I wrote with this?
I may. Court's indulgence.
But I mean, I recognize the photo log and what's listed here, and what the pictures are of.
What are those pictures of?
These are pictures of hands along with a ruler showing injuries to a hand.
And can you?
To fingers, back of the hand, those sort of things.
That's fair. And do you recognize that property sheet?
This is my handwriting on this property sheet, and it's a property sheet that I filled out on January 21st, 2001.
Okay. And it states photographs of Chris Melton's hands?
The photo log states that, and then the sheet that says it, and then the evidence sheet says are pictures of Chris Melton. But you're right, the photo log shows the specific, what each specific photo was of.
Sure. And that's the report I was looking for. I realized I gave it to you. So yes, that is the cover sheet, and the following photos would be what was included in the discovery.
Yes, sir.
But that's that. Do those photos appear to be a fair and accurate depiction of the photographs that you took of Mr. Melton's hands?
Yes, sr.
Okay. Do those photographs appear to be altered in any way?
They do not appear to be altered to me, no, sir.
Let the record reflect that I am marking Detective Newton's property and evidence record sheet of pictures of Chris Melton as defense exhibit 28.
That's what I have. I think that's right, Mr. Cruz.
Yes, ma'am. Thank you, Your Honor. And let the record reflect that I am marking photographs of Chris Melton's hands as defense exhibit 29. And Detective Newton, I have a few more questions for you in regards to the property form. I want to ensure I lay the proper foundation for that form.
Yes, sir. Yes, sir. Thank you.
Now, you testified that you recognize the document. Has that document, does it appear to have been altered in any way?
No, sir. It does not appear to have been altered.
And is it a fair and accurate, or is the document a fair and accurate copy of the document as you would remember it?
Yes, sir.
Okay, thank you. Your Honor, I would move to admit defense exhibit 28 and 29 into evidence.
Any objection? They are admitted.
I would ask for permission to publish defense exhibit 29 to the jury.
Granted.
And Detective Newton, you would agree that those photographs were taken 2 days after Ms. Baker's death?
Okay. I would agree they're taken on that date. I apologize. I don't remember the exact date of the incident, but on the date that's listed there, I would agree, yes, sir.
Okay, January.
And being that that's probably 2 days, an answer yes, but I apologize. I didn't review
That's fine.
very few things before coming here.
That's on me. So I'll say this.
But the date on that would be the date that all that would have taken place. Yes, sir.
That is January 21st, 2001.
Yes, sir.
Thank you. Do you recall obtaining phone records from Miss Tara Baker?
I don't recall that specifically, but I would be surprised, if that's not something we did.
Would seeing and for purposes of the record, it is a copy of Detective Newton's affidavit in reference to phone records, court order for the phone number 706-316-9760.
Your Honor, I would again ask that Mr. Cruz show me something before he tries to hand it to a witness.
That's correct.
I apologize. I'm just moving too fast. I'm sorry. Is it okay if I approach?
Yes, sir. Thank you.
And after you've had opportunity to review those records, just look up. I'm going to have a couple of questions for you about those records.
Yes, sir.
All right. Have you had opportunity to look at the documents provided to you?
Yes, sir.
Okay. What would you describe those documents as?
Phone records for the phone number 706-316-9760. So they show phone calls, time of duration, whether it was answered or not, carriers involved in some instances, and it has dates and times of the calls.
Yes, sir. And Would you have any reason to agree that those are Ms. Tara Baker phone records?
That's certainly what they appear to be.
And may I approach you?
Yes, sir. Thank you, sir.
Let the record reflect that I provided you with a pen and a sheet of paper. Is that correct?
Yes, sir. Blank piece of paper with lines on it, blue
Okay.
pen.
And a pen. You're actually going to need these two, so let me give you these.
Yes, sir.
We've already agreed that those records that you have are Ms. Baker's records, correct?
Yes, sir.
Would you mind writing on that sheet of paper Ms. Baker's phone number based on those records?
I would object. He is asking the witness to testify about an item that is not in evidence.
Any response, Mr. Cruz, to the objection?
No, ma'am. This witness has personal knowledge of those items, so I would just ask that I have no response other than this witness has personal knowledge of.
I mean, with regard to the evidentiary objection, Mr. Bolton made, he is correct. I'm going to sustain the objection.
Yes, ma'am. Court's indulgence.
Yes, sir.
Let the record reflect that I am marking the items identified. I know I've been calling you Mr. Newton. It just feels so natural to call you Detective Newton. Can I call you Detective Newton?
Sure.
Okay. The items, let the record reflect that I am marking as Defense Exhibit 29.
You've done 29. I think you're on 30.
30.
I think that's right. Do you have that, Ms. Satterfield? Thank you. Yes, number 30.
Let the record reflect that the items that Detective John Newton has identified as Ms. Baker's phone records have been marked as Defense Exhibit 30, and that's in regards to number 706-316-9760. Let the record reflect that I am showing the state what has been marked as number, Tara Baker phone records, Defense Exhibit 30. And did these phone records appear to be altered in any way?
No, sir, they do not.
And is this a fair and accurate depiction of the phone records as you remember seeing them 20 plus years ago?
It's a fair and accurate representation of what we would receive as phone numbers.
Yes.
Again, I don't know that I have any independent recollection, but to the best of my knowledge and ability, those would be the phone records.
Yes, sir. Thank you. Your Honor, I would move to admit into evidence Defense Exhibit 30.
Any objection?
I don't think that's a proper foundation for the admission of business records. So I do object to Mr. Cruz attempting to tender those records through this witness.
All right, Mr. Cruz, any objection before I make a ruling?
Any
Any response before I make a ruling about the objection?
Sure. So Detective Newton obtained these records via a court order. So I do believe there's, to respond to their objection, he received these records via a court order, Your Honor.
I don't think that overcomes, though, the objection that the state has produced, which is that it's not a proper way to introduce business records. So I'm going to sustain the objection.
Yes, ma'am. Court's indulgence. May we take a 5-minute break, Your Honor?
Well, I think this would, yes, we can. The answer is yes, but it may be more than 5 minutes. So can I see counsel at the bench about timing issues? Thank you. Yeah. All right, ladies and gentlemen, we're going to take a lunch break. Lunch has arrived for all of you. I'm going to send you to the jury room. We're going to bring the lunch for you. Please don't discuss the case, of course. Do any independent research and things of that nature, as we have discussed. I do know there are several of you, or maybe one of you, that needs to run an errand, and certainly that's fine. We're doing lunch in because I'm not going to have a long lunch break. We're going to be back on the record at 1:30. But if you need, I know there's somebody that needed to do an errand here in town, and that's absolutely fine. Same instructions apply, right? You can't talk about the case, do any independent research, or go anywhere you may have heard about. But I am going to ask you to have lunch inside the jury room. When you are ready to come out, if you would just knock on the door and alert the bailiff that somebody is going to come out of the room, that would be very helpful. We need to do that. But other than that, enjoy your lunch. We're going to bring it in just a moment. We'll see you all at 1:30. Counsel, as soon as the jury is back there, I'm going to release all of you for lunch. And you are still under oath, and if you'll come back at 1:30. Thank you.
Just left here, Your Honor.
Yes, sir. Well, do we have the ones? Okay. All right, court is in, we are adjourned. We'll see you all at 1:30. Counsel, you may go certainly enjoy a break. Yes, ma'am. that person outside?
Mr. Newton is outside.
Newton. All right, you'll bring him in.
Mr. Newton. Your Honor, if we could address scheduling for the afternoon, just really quickly,
Okay.
Judge.
Hang on one second. Mr. Newton, if you'll have a seat back at the witness stand. Thank you, sir. All right, go ahead.
And, Your Honor, I'll preface this by saying, first, I apologize because I think that, we try to make reasonable estimations of how long each witness will take. And so we have Mr. Newton, we have Ms. Brown from the Clark County Sheriff's Office, we have Annie Kistler-Rao from the GBI Crime Lab, and then we have David Griffith, who is a longtime crime analyst at ACC PD. But that's all of the witnesses we have lined up for the remainder of today. We thought that was going to get us to the end of the day. I don't know that it will get us all the way to the end of the day. However, as we stated before, we're ready to proceed whenever we conclude with our fact witnesses for the jury with Ms. Lycon's Daubert hearing. But I do apologize, Your Honor. I know we want to use every minute of the jury's time that we can. It's just some of the witnesses this morning went much faster than we anticipated by a significant amount. And so I do apologize, but I would ask that after we conclude Mr. Griffith's testimony, if that could conclude the fact testimony before the jury for the day.
All right, thank you. And I'll respond to that. Ms. Cruz, you want to say anything about that announcement?
No, ma'am.
All right, thank you. I mean, that sounds fine. I mean, it is almost 1:45. You may be surprised that we may not be finished until 5. It's not really that much longer. But that's fine. As soon as we're finished with your fact witnesses, we will go into the Daubert hearing. I think that makes sense. All right, anything else before we bring the jury up from the state?
No, Your Honor.
All right, Mr. Cruz, anything before we bring the jury out?
No, ma'am.
All right, thank you. You may bring the jury out. Everyone, you may be seated. Thank you. Mr. Cruz, you have the floor. We're back on the record.
Sure, and I think before we broke, the state had an objection to the introduction of phone records. I responded and asked for a short recess to look over the law regarding those records. The question I have, I don't think Mr. Bowden was specific with his grounds for objection. If I remember correctly, he said that it was inadequate or inappropriate foundation for business records.
Are you talking about Exhibit 30?
Yes, ma'am.
I've already sustained the objection. If you would like to put some case law on the record, you may, but I've sustained the objection.
Yes, ma'am. Understood. What was the specific objection, just so I could put...
I actually don't remember. I don't write that down. We'd have to go back in the records. If you don't remember and not prepared to present some case law, and I'll let you put case law on the record if you want to. But we need to move forward. So.
I'll ask this. Can I be heard in regards to his objection? I can't. What I'm asking is, I don't know what the specific legal ground of the objection. I remember he said something that the court agreed to and granted. But in order for me to perfect the record, I would just need to know the specific legal ground. If he's...
Well, I will just say this, counsel. I'm going to ask you to move on with this witness. I already gave both parties the opportunity to respond, and so I'm going to ask you to move on.
Yes, ma'am.
Thank you.
On March 12, 2001, do you recall receiving a message from a female inmate at the Clark County Jail? No.
No, sir, I do not.
Mr. Cruz, if you'll go ahead and show Mr. Bolden what you're going to be working with. Thank you.
Thank you, sir.
And of that document that I provided you, the specific portion to read is paragraph 1, sentence 1.
I object, Your Honor. I don't know that there was a question. I don't know that the witness has said that there was something that you could. Oh, maybe I'm mistaken, but that was.
I think that's right, actually. I think you need to sort of start over and lay whatever foundation you need to with regard to this document.
Yes, ma'am.
All right, go ahead.
On March 12th, do you recall receiving a message from a female inmate at a Clark County jail?
Yes, sir.
Okay. And what did she, she messaged you because she wanted to speak with you about the Tara Baker murder, is that correct?
Yes, sir.
Okay. And you met with her upon receiving the message from her, is that correct?
Yes, sir.
You went to the jail and spoke with her, correct?
Yes, sir.
And she provided you information about who she believed committed Miss Baker's murder. Is that correct? And it would be paragraph 3, if you're looking at the report, sentence 1, 7, and 9.
I do have an objection on the motion that the state previously filed, and
Can you bring that microphone towards you, Mr.?
403, same as before, Your Honor.
Okay, Mr. Bolden, will you bring that microphone towards you and just repeat your, I can't really hear you.
Same objection as before. This state's previously filed a motion. I don't think this is relevant under 401. I think it's 403. So I do object to this line of question.
What previously filed motion are you referring to?
The Sadi motion, Your Honor.
Okay. All right. Based on our prior discussion of those kinds of objections, I'm going to send the jury out again. So if you'll go back into the jury room, please don't discuss the case. Thank you. Thank you. All right, y'all may be seated. Mr. Cruz, do you want to make any more of an objection? Let Mr. Cruz respond.
No, Your Honor.
All right, Mr. Cruz.
Okay. To make sure I understand the legal basis for the objection, Mr. Bolden has stated Rule 401, which is relevant, Rule 403. I would ask the specific grounds under 403 that wasn't stated, and the Sadi motion. But if I could get the specific grounds for 403, I could address all three, Your Honor.
All right, Mr. Bolden, specific grounds that you are referring to.
403, Your Honor. I think that what I expect the line of questioning that Mr. Cruz intends to ask of the witness would go to potential alternate suspects, alternate perpetrators. The state did file its motion back in October, specifically related to these types of issues. We, at our hearing on January the 21st of this year, Mr. Cruz indicated that the only alternate perpetrator that he intended to identify was Mr. Melton. I think that's been very clear throughout this trial to this point. And so what I suspect he's attempting to do here is to run through every tip or piece of information that the police got relative to anybody over the course of this 25-year investigation, not all of them through this witness. But one, my first point is that the motion that the state filed back in November and that we heard arguments on the 21st, the court granted my motion, granted the state's motion, and except with respect to Mr. Melton. So, to the extent that Mr. Cruz may now be trying to assert that they're alternate perpetrators, that's the whole point of the motion. There has to be evidence proffered to the court before he can ask that type of information in front of the jury, so that the court can make a determination about whether or not any probative value is substantially outweighed, and I will be specific here, confusion of the issues, and waste of time. So that is the state's objection.
Thank you. Mr. Cruz.
If I may, I don't quite understand. It was a lot of information, forgive me. I understand he mentioned something about Saudi. Can I get clarity on that, Your Honor? If you understood what Mr. Bowden was mentioning in regards to...
Well, he was just, again, mentioning the hearings that we had about the 412 motion and the rulings.
The rape shield statute?
I'm sorry, not rape shield, Your Honor. The one that I'm specifically referring to, and it was captioned...
That was also on the 21st.
Right, and it was also filed by the state on the same day, which is state's motion in limine to require the defendant to proffer evidence linking other persons to the crime charged. That's the one I'm referring to.
Okay. Go ahead, Mr. Cruz.
So I address each objection piecemeal.
All right.
So in regards to the Rule 401 objection, which is relevant, the relevance of this line of questioning is just simply to show that a individual that's in custody calling law enforcement and saying, hey, I have information on this case, it isn't something unique to this case. Throughout the history of this case, multiple detectives have spoken with individuals in custody, and they'll call and say, hey, I know who committed this crime, and the information would turn out not to be credible. The specific line of questioning that I was going down with Detective Newton was simply to get to the point that this individual offered information to get leniency, which we believe to the jury would be relevant in determining Mr. Cedric Jeffries' testimony. In regards to Rule 403, and I believe he said waste of time, as well as, if you don't mind, Your Honor, I have waste of time. There was one more that he mentioned.
Confusion of the issue.
Confusion of the
issues.
Right.
Okay.
And I'm listening. I'm looking for the motion while you're talking.
Absolutely. That is fine, Your Honor. Do whatever you need to do. In regards to the waste of time, Your Honor, this evidence directly rebuts the state's evidence. They want to present to the jury Mr. Cedric Jeffries as a unique individual that's in custody, and they would like it to appear to the jury that he's the first in-custody individual to come forward with tips on this case. This evidence would rebut that image that the state would portray to the jury if Mr. Jeffries is simply allowed to testify. So it isn't a waste of time, Your Honor. And as far as confusion of the issues, I'm not sure of an issue that could be confused by the Honorable Detective Newton simply stating, yes, someone in custody reached out to me 20-something years ago with information on the case. So that would be my proffer in regards to 403, or my response in regards to 403. In regards to the Saudi motion, just for purposes of the record, I believe the appropriate term for that is third-party perpetrator or alternative suspect theory under Georgia law. That is not the purpose of this evidence. This individual if I would have been allowed to go down, or if I'm allowed to go down that question with Honorable Detective Newton. The information turned out not to be credible, so it wouldn't implicate the alternative party theory or third-party perpetrator theory.
Okay, so let me just ask you this question, and Mr. Bolden, I'll let you respond, and then I'll let Mr. Cruz respond if you wanted to say something. But given what you've just stated, then why is this testimony relevant?
Absolutely, Your Honor. Thank you for the opportunity to respond to that. So the reason this testimony is relevant is because the state intends to bring in an individual by the name of Mr. Cedric Jeffries, who is an individual that is currently serving a 105-month federal prison sentence.
Right.
The state intends to depict to the jury, which is their right because it's their case that they have the opportunity to present, that Mr. Jeffries is a uniquely situated inmate. So when Mr. Jeffries comes in, he'll testify, hey, I'm in custody, so forth and so on. Mr. Faust admitted this to me, and I'm hoping to get a benefit from the state. The reason this is relevant is because we're showing the jury also that Mr. Jeffries is not uniquely situated. Throughout the history of this case, individuals that are incarcerated have called seeking leniency. Excuse me, let me make that clear for the record. Have called law enforcement offering information in order to receive leniency. So that's the relevance of the questioning, Your Honor.
Mr. Cruz, who is the person that this witness went and talked to at the jail in Clark County?
So, Your Honor, I did not intend to get into any names. I don't believe the name of the person is relevant.
So it's not Cedric Jeffries?
No, it is not Cedric Jeffries. This is a separate inmate. And I'll say this, Your Honor, I know sometimes I mince up my words, so I may have explained that the wrong way.
Okay.
So in this instance, what I'm saying is that there is a separate individual from years ago when Detective Newton, the Honorable Detective Newton, was working this case. That individual reached out to Detective Newton and said they had information on this case. Okay, that information turned out not to be credible. And that evidence that we're seeking to admit before the jury is to rebut any type of visual or image or piece of evidence that the state may attempt to introduce Mr. Jeffries as an individual that is uniquely situated. And what I mean by that, Your Honor, is Mr. Jeffries is in custody. He's the only person that's ever come forward as someone in custody saying they have information about this case, and his information is, of course, as the jury would learn, is that Mr. Faust confessed to him. Does that make sense? And if I explained it wrong, Your Honor, please forgive me.
Well, I mean, I understand what you're saying.
Yes, ma'am.
The words that you're saying.
Yes, ma'am.
But I still do not understand how this particular testimony is relevant and how it relates to Mr. Jeffries, other than the statement that you just made, and to let me know if this is what you meant, other than your statement that the state would produce testimony that said the only person in custody that ever reached out was Mr. Jeffries. Is that what you're saying?
No, I probably used too many words.
Okay.
Credibility, Mr. Jeffries' credibility. That's why this evidence.
How does this testimony that you're seeking to elicit impact Mr. Jeffries' credibility at all?
I think that's an excellent question, Your Honor. So what we intend to show is that multiple individuals that were in custody reached out to law enforcement offering information. Throughout the history of this case, all of that information has turned out to be unreliable. And what we're creating for the jury in regards to Mr. Jeffries' credibility is it's consistent with the information that Mr. Jeffries is providing as well.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, anything else, sir?
Not unless the court has any specific questions about the way that I made the objection, I do not.
Okay, I'm making a finding that this information is not relevant.
Yes, ma'am.
And that under 403, it would absolutely lead to confusion of the issues and misleading the jury. I'm not going to allow it. I'm going to ask you to move on.
Yes, ma'am.
Could you bring the jury in, please? All right, you all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Detective Newton, on May 6, 2001, you spoke with Mr. Chris Melton over the phone. Is that correct?
I don't remember doing that, but I'm sure I spoke with him over the phone several times.
Yes, sir. Would seeing your report refresh your recollection in regards to May 6, 2001?
Yes, sir. Thank you.
Thank you. And let the record reflect that I'm showing the Honorable Detective Newton a copy of his May 6, 2001 report to refresh his recollection.
Yes, sir.
Okay. Is your memory refreshed in regards to May 6, 2001?
Yes, sir.
Is it okay if I grab that document?
Yes, sir.
All right, thank you.
You don't have to. Just have it.
Now, this is May 6, 2001, correct?
Yes, sir.
And when you spoke to, well, you understood that Chris Melton, at the time of this investigation, that Chris Melton was Miss Baker's boyfriend.
Yes, sir.
And I believe it was, he described it as he was her borderline fiance. Is that fair to say?
Yes, sir.
Okay. But when you spoke to him on May 6, 2001, and asked him about the Thursday before his death, he didn't have any memory of it. Is that correct?
If I recall, he didn't have a clear memory of it. I think that would be an accurate way to put it, right? There was a lot of confusion in his mind.
Yes, yes, sir. Thank you for that. There was a discussion about going over Chris Melton's finances. Is that correct?
Yes, sir.
Okay. And were you aware that Chris Melton told law enforcement that he had received a check from a place called Nash Plumbing?
He worked at Nash Plumbing, as I recall from that report.
Excellent.
Yes, sir.
And the bank records would have shown whether or not he worked at Nash Plumbing, correct?
That sounds very logical. Yes, sir.
Okay. But Mr. Melton was not comfortable with you going over his finances, was he?
That is correct.
Okay. So based on your time in this investigation, you were never able to confirm whether or not Mr. Melton actually worked for Nash Plumbing?
It's not in that report. I don't recall us doing that, sir.
Thank you. Now, during your conversation with Chris, you asked him for the phone number to Nash Plumbing. Do you recall that?
Yes, sir.
And Chris told you he didn't have the number to Nash Plumbing. Is that correct?
That is correct.
Did you find that odd, considering that he said Nash Plumbing was his employer?
I apologize. I don't remember finding it odd or not finding it
Cause
odd.
for speculation, Your Honor.
Overruled.
I don't remember finding it odd or not finding it odd at the time.
You just have an opinion.
But I asked the question. I would assume I would have expected to get an answer.
Yes, sir. Chris Melton also could not provide an exact address for Nash Plumbing, could he?
That is correct.
The only information he could provide is that it is on 78 near Loganville and that it is a hole in the wall. Is that correct?
That is correct.
Do you ever recall going to Nash Plumbing?
I do not recall, sir.
Thank you so much, Honorable Detective Newton. I do not have any other questions for you.
Thank you.
Any redirect, Mr. Bolden?
Your Honor.
May this witness be excused.
Ask that he be excused.
Mr. Cruz, any objection?
I still have him under subpoena, so I would just ask that, and for the witnesses, please forgive me for not bringing this up earlier. Mr. Yalamachili brought it to my attention. For the witnesses that are under subpoena, just to be respectful of their time, if I could give them 48 hours notice instead of 24 hours notice. Is that okay with the Honorable Court?
I don't have any problem with that. I certainly think that's fair.
Okay, as long as I'm aware, I'll give them 48 hours notice. Thank you.
You're still under subpoena, sir, but you are free to go.
Thank you.
You may call your next witness.
State calls Shannon Brown. What's that? No, you didn't say anything about that. Will you raise your right hand, ma'am? Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
All right. Would you please just state and spell your name for the record?
It's Shannon Brown, SHANNON BROWN,
And ma'am, where are you currently employed?
at the Athens Clark County Sheriff's Office.
All right. And what, well, let me ask you this. Does the Athens Clark County Sheriff's Office keep known photos of individuals from certain times?
We do.
Yes, sir.
I would object to this line of questioning, Your Honor.
Okay.
In regards, I would object under Rule 403. The evidence that the state is attempting to introduce, its probative value is substantially outweighed by its prejudicial impact or its undue prejudice. And I would also object under Rule 404B, OCGA 24-4-404B, as it gets into improper character evidence.
All right, thank you. And anything specific with regard to 403, other than probative value outweighs?
Probative value is outweighed.
That's just, okay. All right, thank you. Mr. Yalman, any response?
Excuse me, substantially outweighed.
I understood, thank you.
I think it would probably be helpful for the court to see the exhibit.
Okay. You know what? We're going to do it again this way. Ladies and gentlemen, I'm going to ask you to go into the jury room. Please don't discuss the case. I think it's best we do it that way, counsel. Y'all may be seated. Thank you. All right. Mr. Yalman, one of the reasons I want to send the jury out is I don't really know what you all are going to start talking about. Secondly, could you repeat the question that there was an objection to and give me more context?
The question, Your Honor, was whether or not the Clark County Sheriff's Office keeps known pictures of individuals from certain dates and times.
Okay, all right, thank you. And so you were going to show me the exhibit. You thought that was best for, I need to get a context of what you're asking.
I'm sorry. 112 Reynolds?
Yes, 112.
I'm marking State's Exhibit 112, Your Honor.
And then after I take a look at it, if you can respond to Mr. Cruz's objection to 403, thank you, 412, I'm sorry, 403 and 44B.
And Judge, I just handed the court the exhibit, but for purposes of the record, that would be Mr. Faust's booking photo from early February of 2021, about 2 weeks after the incident. I believe that it is the same or a similar photo to the one that Mr. Cruz showed in openings during his demonstrative aid that he presented to the jury, saying that this was the evidence that he would expect that would come in, showing Mr. Faust's physical appearance, basically as close as we have it, to the date of the crime. It is certainly relevant in aiding the jury in making determinations about the accuracy of the sketches done by Miss Lawson, Miss Marla Lawson, the GBI sketch artist that did work at the time. I've instructed Miss Brown, and I think she understands that we're not going to refer to it as a mugshot, a booking photo, make reference to arrest, or anything regarding charges. I'll also note for the court that a stipulation to the admissibility of the photo as being a known image of Mr. Faust from that date and time that it was taken was offered to the defense prior to us beginning evidence in the case. It was discussed with Mr. Cruz again when I offered to stipulate to that yesterday. Did not receive a response. I offered again to stipulate to that this morning and informed Mr. Cruz that this would be our last opportunity to reach an agreement on a stipulation to the photograph. And he indicated to me that he would give me a response in approximately 5 minutes, and I did not hear again from him about that. So we have Ms. Brown, who's the custodian or a custodian of records at the Clark County Sheriff's Office, to authenticate the photo. It is certainly relevant. And I believe with the limitations on the way that is referred to, I mean, honestly, Judge, even if you referred to it as a booking photo, I still think that the probative value would be not substantially outweighed by any unfair or undue prejudice of the evidence, but certainly with the limitation of not referring to it as a booking photo or arrest photo or anything along those lines, its probative value is not substantially outweighed by danger of unfair prejudice, confusion of the issues, or any of the other reasons that admission would be barred by 403. It is most certainly relevant. I mean, I think that that's established by both parties by the fact that Mr. Cruz used either that image or a very similar one during his opening statement.
So I do have some questions, and we may have to take a recess for me to do some research. So first of all, even if you don't refer to it, if it is admitted as a booking photo, I mean, there's no question that's what it is. I mean, you can look at it and determine that. So how is that not violative of, at the very least, 404B, at the most attempting to put Mr. Faust's character into issue? So,
well, Judge, it would be violative of 404B if we're seeking to introduce evidence of a previous crime or other act, but we're not actually introducing any evidence of the act that was committed that resulted in Mr. Faust getting arrested on February, I believe, 8th of 2021. We're simply showing that as a known image of Mr. Faust from that time period. If the court is concerned with the background of the image, we have a version in which the background was able to be removed. And so, I mean, this is a version that I could hand to Ms. Brown. with the understanding that there wouldn't be an objection to the fact that this image has been altered from the record that was kept by the Clark County Sheriff's Office. We're certainly happy to do that, but I do believe that a known image, even if it is one that is generated as part of an arrest for a different incident than the one that Mr. Faust or any criminal defendant is on trial for, is admissible, especially under these circumstances where we're talking about 25 years later and everyone's appearance has changed substantially. It is especially important to establish Mr. Faust's appearance at the time. If this were a situation where, you know, a year had gone by or 18 months or something along those lines, then you may be in a different position unless there's some kind of special circumstance showing that the defendant's appearance has changed substantially since the time of the crime. But in this case, Judge, just the passage of time has led to a situation where Mr. Faust, Ms. Peavy Hall, Dr. Low, basically everybody that's come to testify in this case looks very different than they did at the time of the incident. So that's why it's relevant and necessary.
Well, and I understand your relevance argument, and I think you've made an appropriate relevance argument, and I'll certainly let you respond, Mr. Cruz, but so don't worry. But my concern is beyond that. My concern is this line of questioning with this witness and this particular photo. So this is what I'm going to do. I'm going to let you make a response, certainly, Mr. Cruz, but I'm going to go do some research. So we'll be in recess until I get back. Hopefully it'll be 15 minutes, but I'm going to give you back your exhibit. If anybody has any case law they want to present the court, they certainly can, but I will be back in hopefully 15 minutes. We'll be in recess. Thank you. Before I say anything, first of all, let me give the state back this exhibit. And it's your motion, Mr. Cruz. Anything further you want to tell the court?
Yes, ma'am.
Go ahead.
As the Honorable Court is aware, within its wisdom, Georgia adopted the federal rules of evidence in 2013. And those rules of evidence were just to be safe, I'll say excluding very few, but were pretty much a replica of the federal rules of evidence. And as the Georgia legislature has explained, that when it comes to interpreting the Georgia rules of evidence, we look to the decisions of the 11th Circuit Court of Appeals. And that's State v. Almaza, and that's A as in apple.
You can just spell it. She can hear you.
Yes, ma'am. That's A-L-M-A-N-Z-A. And that's 304, Georgia, 553. Also State v. Brown, 333, Georgia Appeal, 643. Under our current evidence code, Your Honor, the court's indulgence to pull up the statute. Under our current evidence code, Your Honor, our rule, OCGA 24-404, is similar to the federal statute, language-wise. They're identical statutes. We found a case from the 11th Circuit, which is United States v. Hines, and that's H-I-N-E-S in Sailor. And this is a 1992 case, and I'll wrap it around together with our current evidence code, which states, mugshots carry a clear implication of criminal activity that breaches the rule against admitting evidence of the defendant's bad character or previous brushes with the law. At the time that this case came out, Your Honor, the federal evidence code stated, which is identical to our evidence code. And the reason I'm making this comparison is because that case is from '92, just to avoid any argument that it's inapplicable to the issue we're dealing with here. But the evidence code in 1992 stated, federal evidence code, character evidence generally, and it's the exact same thing that we currently have, evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion, except, and it goes through the same exceptions we have. So those statutes are materially identical to our current statute. So, Your Honor, based on the law, based on the federal rules and the ruling of the 11th Circuit Court of Appeals, as well as our statute, I would present to the court the exact same argument that was part of the Honorable Court's ruling in United States v. Hines, and specifically the mugshot that Mr. Yalamachili would like to introduce. It does carry a clear implication of criminal activity that breaches the rule against admitting evidence of the defendant's bad character or previous brushes with the law. When Mr. Yalamachili spoke to me, just to address our conversations, earlier today, I explained to him it was a tentative yes, but not to that photo. I didn't see this mugshot photo side and front until the witness was called to the was on the bench testifying. What we are willing to stipulate to, and this may resolve the issue, is the photo of just Mr. Faust looking forward. That photo alone, we have no issue with. But as far as the mugshot photos together, that our position is that it does violate OCGA 24-4-404 B as bad character evidence.
All right, thank you, Mr. Cruz. I do have a question for you, since you've sort of proffered an offer, so to speak, for a stipulation. was your objection extended or meant to encompass this witness that the state had testifying about the photograph, the one photograph you're offering to have admitted into evidence? Is that part of your objection, or is it the mugshot itself?
Can you ask me that question again?
Yes, I didn't. That wasn't terribly articulate. So the state has a witness.
Yes, ma'am.
Who they have asked, do you keep certain photos, something to that effect, in your department or your office? I don't remember the exact language. And it sort of stopped there. I'm assuming they were going to ask this witness, do you recognize this photo, or something to that effect. So I guess my question for you is, given the fact that you are offering to not object to the introduction of the photograph you've described,
Correct.
does your objection extend to this witness commenting on it, or?
Just to make sure that I explain it clearly, from what I understand, her testimony would be, from what Mr. Yalamachili explained to me, is just simply to introduce the photo. From what I understand from our conversations, there's been no discussion regarding her making any mention, any descriptions, or talking about the picture. I understand her testimony is for the sole purpose of introducing that mugshot photo.
And you don't have a problem with that?
No, I do have. It's the exact same photo, because we intended to introduce it, that was shown during opening, and what it displayed was just Mr. Faust looking forward. That I have no issue with, but the looking forward and the side profile photo, Your Honor, that is what we're objecting to. Those photos together.
I understand what you're saying. Thank you. Mr. Yalamachili, were you aware of the defense's offer, so to speak, before I walked in?
As far as an offer to stipulate?
Oh, yeah, about that picture.
Well, that's not exactly what was said, Your Honor. At the beginning of the trial, as court knows, the state and defense had been discussing some stipulations for some period of time. Mr. Bolden started those conversations with Mr. Cruz probably 3 weeks before we started jury selection. I sent the written proposed stipulations, tried to follow up a couple of times. I talked to Mr. Cruz, who initially had told us that Mr. Faust did not want to stipulate to anything, and so there would be no stipulations. And then this morning he said, that's a yes from me, but I need to check with him and I'll get you an answer in 5 minutes. And then I never heard anything before we started the evidence in the case. I would state to the court that the offered written stipulation before the start of the trial was that the parties stipulate to the foundation for the admissibility of the defendant's booking photo from February 2001, and that it is a fair and accurate depiction of the defendant on the date it was taken. The state shall refrain from making any reference to the image as a booking photograph or otherwise indicating that the photograph is related to illegal acts committed by the defendant. If Mr. Cruz is willing to stipulate to the foundation, I don't need to put it in through a witness from the Clark County Sheriff's Office, and I won't. It would need to be a stipulation that it is both an accurate image of Mr. Faust and it is an image from February 8th of 2001 at 4:33 p.m. I mean, that would be the stipulation, and I'm fine as it. We've got multiple large copies of it, Your Honor. We're fine doing the front-facing only. There's one, I don't even know that Mr. Cruz did this with the image that they used in opening. Obviously, you've seen 112. They're cinder blocks. We have one with the background washed out to be white.
You showed me that. I mean, I think that's certainly better than cinder blocks.
Okay.
Okay. All right, so let me just say this. I'm going to give you all a couple of minutes to talk about how to go forward with the picture, and here's the reason. Case law is pretty clear that a booking photo just in and of itself is not necessarily inadmissible, just based on the fact it's a booking photo. It is dependent on the circumstances upon which it is being asked to be introduced. This particular case, I'm really not even making a comment on whether the photo is admissible or not. That's not really your issue. Your issue is that you're trying to get that photo in through the sheriff's department. And that moment in and of itself creates the implication that is inadmissible, which is that Mr. Faust at some point in the past had been arrested for something. That's the moment that I think the case law is pretty clear is inadmissible. So the photo itself, even a booking photo in the manner that you have suggested, I'm not making a ruling that it is not inadmissible based on Mr. Cruz's objection. What I'm sustaining your objection, Mr. Cruz, but I'm sustaining it because the manner in which the state was trying to introduce it is inadmissible through the Sheriff's Department. That implication, I think, it's pretty clear, the case law is pretty clear, that implication is violative of 403. And so I'm going to give you all some time to talk about what you can stipulate to. I think the suggestion that both parties have made about that one photo with the background washed out, so to speak, certainly makes sense. The case law is pretty clear that booking photos are typically admissible. It just has to be admitted in the right context. So I'm going to give you a couple of minutes to do that. Tell me when y'all are ready.
Scissors up by the witness.
I certainly hope not.
There are not.
That's kind of good to know. Let me see if I have any up here. I don't, but I have a lot of exhibit stickers. I have a whole drawer of these. So if you need them, okay. I don't have any scissors either. Thank you, Todd. You all want to put something on the record?
Just whenever, Miss.
Okay. All right. Go ahead, Mr. Yellowchili.
Thank you, Judge. We have an agreement, and
Okay.
would you like me to leave the other one labeled 112? Obviously, it wouldn't go with the evidence to the jury, or label the new picture 112.
I think the new picture needs to be 113.
Okay.
I would say.
And I would just state for the record, 112 was never displayed to the jury in any way.
All right, and if you all will put on the record your stipulation.
Yes, Your Honor. State's Exhibit 113 is a picture of Mr. Faust, and the parties stipulate that it is, in fact, an accurate picture of Mr. Faust on February 8th of 2001. As far as how the court wants us to handle that when the jury comes back in, would you like me to move to tender 113 and just state that the parties stipulate or agree that it is an accurate picture of Mr. Faust from February 8th of 2001?
Okay, let me hear from Mr. Cruz first, and then I'll tell you what sort of I'm thinking about. Mr. Cruz, you want to be heard on that? And do you agree with that stipulation? I just want to make sure we're on the same page.
I do.
Okay?
No. From what I understand, just to make sure that we're clear, he's just going to announce the stipulation to the jury. The witness won't be on the witness stand. Is that right?
Well, yes and no. I don't know what your plan is for this witness, but in terms of this photograph, I would answer yes, that it is inadmissible to introduce the photograph you stipulated to through this witness. Yes.
And I don't need the witness on the witness
All right.
stand then, Judge.
The
And
answer is
after
yes.
this, I'm sorry.
Go ahead.
I was just going to say, after we announce the stipulation, I just asked to publish it to the jury, and that's it.
Okay. All right. Thank you. Let me ask you, anything else, Mr. Cruz? Is that?
No, ma'am.
Okay. Mr. Yalamichili, do you need this witness?
I don't. I'd ask that she be excused.
All right. Mr. Cruz, any objection?
No, ma'am.
All right. You are free to go. All right. Anything else before I bring the jury back in?
No, Your Honor.
Mr. Cruz, you ready?
Yes, ma'am.
All right. You can bring the jury in. Thank you. You all may be seated. Ladies and gentlemen, thank you for your patience. We are back on the record. Mr. Yalamichili.
Thank you, Your Honor. The state has marked State's Exhibit 113. There is a stipulation between the parties that State's Exhibit 113 is an accurate picture of Mr. Faust from February 8th of 2001. So I'd move to tender it into evidence.
Mr. Cruz, any response?
No objection, Your Honor.
It is admitted.
And I'd seek to publish it to the jury at this time.
Yes.
Thank you, Your Honor.
All right, you may call your next witness.
State calls Annie Kissler-Rao.
Could you get Annie Kissler-Rao, please?
Ma'am, if you would take an oath, do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, if you could, please state and spell your name for the record.
My name is Ann Kissler Rao, ANNEKISLER -RAO.
Come over to this microphone. Ma'am, where are you currently employed?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab.
How long have you been with the State Crime Lab?
I've been there for 20 years.
And what is your current title and role at the State Crime Lab?
I'm employed as the technical leader of the Trace Evidence Section.
And as far as your educational background, starting with your undergraduate degree, do you mind telling me about what you received your undergraduate degree in?
Yes, I received a degree in biology from the University of Pennsylvania.
Did you receive any other postgraduate degrees?
Yes, I have a master's degree in forensic science from John Jay College.
And once you got to the Georgia Bureau of Investigation, was there any internal training that you went through as part of your GBI employment?
Yes, I have gone through extensive training programs in each of the areas that I am qualified to perform examinations in. So this includes hairs, fibers, glass, paints and polymers, fractured materials.
Okay. And as it relates to hairs, when the GBI receives a hair from law enforcement, wherever that may come from, are there any steps taken to prepare that hair for analysis?
Yes, typically we will mount hairs on microscope slides. So we'll take a microscope slide, put the hair on it with some mounting media, and then put a cover slip on top to hold that hair in place and use it for further examination.
All right. And let me ask you this. Once your examination is done with a piece of hair, is the typical practice to remove that from the mount and place it back in an envelope to go back to the law enforcement agency?
No, typically we will then package those slides in a slide holder, and then we'll put it in a package and preserve it that way.
Okay. So back in February of 2024, so about 2 years ago now, were you working at the GBI at that point?
Yes, I was.
All right. And did you not you personally, but did the Georgia Bureau of Investigations Crime Lab receive communication from Agent Elizabeth Bigham?
Yes.
Okay. And what was that related to?
This was related to a box of slides. It was determined that we needed to look at the box of slides to inventory what was present within that box.
All right. And did somebody at the crime lab look at those slides to conduct that inventory?
Yes.
All right. Who was that person?
One of our lab techs within the trace evidence section, Valencia Johnson.
What was discovered upon the inventory?
Upon inventory, it was discovered that some of these slides were broken.
Okay. And so let me ask you a question about ways that things were packaged back in 2001 or the early 2000s as compared to the way things are packaged now. Okay. How were slides packaged back in the early 2000s?
They might be packaged in various ways, but one of the ways would be to just wrap it in paper towels, or it might be otherwise packaged. Since then, we have acquired plastic slide boxes that are a little more sturdy that can prevent further damage.
And so you mentioned preventing further damage. Have there been situations where the slide, in the old way of packaging things, not without the slide boxes you're talking about, gets damaged?
Yes, that's possible.
Okay. In this particular case, after the inventory was done, was there any damage to the slides?
Yes, some of the slides within the box did have some damage.
Okay. And so when a slide is damaged, what are your options at that point regarding remedying the damage?
It depends on if further examination is going to be done with that slide. So if it was damaged enough so the cover slip was cracked and we couldn't really see anything, then we might have to remount those hairs on a new slide. But if we were just preserving the slide to prevent further damage, like in this case, we just used tape on a lot of the slides to just tape it together to make sure nothing further happened to the slide.
Okay. And were you involved in that process?
Yes.
Okay. Were you the only person involved in that process?
No, 2 other hair examiners were also involved.
In the slides that were related to this case, was there any damage noted that compromised the hairs that had been mounted to the slides?
No, there is no note of damage that compromised any hairs.
All right. I'm going to hand you about 9 different plastic boxes here, so bear with me as we label these and show them to opposing counsel first. is it, last name referred to as Ms. Kissler-Rao? Is that
Yes.
correct? All right. Ms. Kissler-Rao, I'm going to hand you state's exhibits 114, 115, 116, and 117. The exhibit stickers are on the front, there's other markings on the back. Will you look through those and then just let me know when you've had a chance to review all of that?
Okay.
And do you recognize State's Exhibit 114?
Yes, I do.
Okay. And how is it that you recognize State's Exhibit 114?
It has a label on the cover that I wrote with the unique case number and item number on it.
Okay. And so were the case number or item number, would that have been altered at the time that y'all repackaged it or noted in your records in a different way?
No, so it would be the same case number that it originally had. So the slides were originally marked with a case number on them. So we just copied the case number onto the outer container so we would know what's inside that box.
And does that appear to be in the same condition as when y'all repackaged it or repaired it at the GBI?
Yes.
I moved to tender 114 at this time, Your Honor.
Any objection?
Yes, ma'am. I would ask that the state establish an appropriate chain of custody for those three slides, Your Honor. I'm sorry. Please forgive me.
Go ahead.
I do have an objection, Your Honor.
Go ahead.
My objection is I would ask that the state establish an appropriate chain of custody for those items under 221 Georgia Appeal, 472 Southeast 2nd, 461, and the case is Harper v. Dooley. And I'll just ask that the state meets its burden, showing the chain of custody before the Honorable Court admits it into evidence.
All right, thank you. Mr. Yellenchilly, any response to the objection?
Your Honor, I believe what will be borne out is that these are the slides, as Ms. Kissler-Rao has testified to, that were part of that DOFS case number, and that these particular slides are the same hairs that Dr. Falzon submitted as part of the recovery in the autopsy.
All right, thank you. Yes, sir.
If he can establish that chain of custody, that's our objection.
All right, well, in terms of the objection about admissibility, the state has, anything else?
No, I was just
Yeah.
listening. I'm sorry.
Okay. In terms of the objection about admissibility, the state has laid a foundation that is appropriate under the law, and so I'm going to admit them over objection at this point. Certainly, if you all want to argue other things with regard to the admitted evidence, you can. But in terms of the foundation that has been laid by the state, simply for its admissibility at this stage, I'm going to overrule your objection. You may continue.
Yes, Your Honor. As it relates to State's Exhibit 114, are you able to determine where the lab received those hairs from, or the trace evidence section, I guess?
May I refer to my notes?
Lack of personal knowledge, Your Honor.
Mr. Yellenchilly, any response to the objection?
I think that this witness, in reference to her notes about where the items were obtained from in the crime lab in conjunction with Dr. Falzon's testimony, lays the foundation for that.
Yes, sir.
I may have misunderstood his question. I thought he was asking that based on those items themselves, could she tell where they came from? The reason I lodged the hearsay objection is because I took it as, and you correct me if I'm wrong, that she was simply going to read someone else's writing to determine where those items came from. But if she has it in her personal knowledge, the objection is irrelevant.
Okay.
She has to look at somebody else's words to determine. That's what we're lodging our objection.
Is your objection, Mr. Cruz, personal knowledge or hearsay or both?
So it would turn out to be both if she doesn't have personal knowledge.
All right. I'm going to let you ask the question again, Mr. Yellenchilly. If you want to object, Mr. Cruz, I'll hear it, but go ahead and ask the question again, sir.
What is State's number 114? What is that noted as in your notes about what the item is?
It was identified as collected from the victim's left hand and the victim's buttocks.
Okay. State's Exhibit 1 115, do you recognize that item?
Yes.
Okay. And how do you recognize 115?
This also has a label on it with our unique case and item number and that I created.
And where is State's Exhibit 115, where is that item noted as being recovered from?
It is identified as recovered from the torso.
Okay. And is that in substantially the same condition as it was when you repackaged it?
Yes.
Okay. State's move to tender 115, Judge.
Any objection, Mr. Cruz?
Outside our chain of custody, no, ma'am.
All right, I'm going to admit it.
And State's Exhibit 116, do you recognize what that is?
Yes, I do.
Okay. How do you recognize that?
This also has our unique case number and item number on the outside of the box.
And where is that item identified as being recovered from?
This is identified as from the victim's left hand.
And does that appear to be in substantially the same condition it was when you all repackaged it?
Yes.
Move to tender 116 at this time, Your Honor.
Any objection, Mr. Cruz?
Other than our chain of custody objection, no, ma'am.
Okay, I'm going to admit it.
State's Exhibit 117, do you recognize that item?
Yes.
How do you recognize that item?
This item also has our unique crime lab case number and item number on the outside of the package.
And where is 117 identified as having been collected from?
This is identified as from the torso and from a towel.
And is that in substantially the same condition it was when you all repackaged it?
Yes.
Judge, I moved to tender 117 at this time.
Any objection, Mr. Cruz?
Yes, ma'am. And to save the court time, I'll just say to all of the ones we mentioned chain of custody to, I'll just mention that now, but furthermore, no.
All right, thank you. It is admitted. Go ahead, sir.
Thank you, Your Honor. And I'll retrieve those from you now. And Ms. Kissel-Rao, I'm going to hand you State's Exhibits 118 through 123. As it relates to State's Exhibit 118, do you recognize that item?
Yes, I do.
How do you recognize that item?
This item has our unique crime lab case number and item numbers on the label on the outside of the box.
Where is that item identified as having been collected from?
This item is identified as containing the known pubic hair of James Barker and the known pubic hair of Chris Melton.
And does that appear to be in substantially the same condition as it was when you repackaged it?
Yes.
Judge, I moved to tender 118 at this time.
Any objection?
No objection, Your Honor.
It is admitted.
Going forward to State's Exhibit 119, do you recognize that item?
Yes, I do.
And what do you how do you recognize that item?
This item also has the unique crime lab case number and item number on a label on the outside.
And where is that item identified as having been collected from?
This item is identified as being known head hair of Chris Melton and known head hair of Christopher Hall.
All right. And does that appear to be in substantially the same condition it was when you repackaged it?
Yes.
Judge, I'd move to tender 119.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 120. Do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as the known head hair of Ashley Peavy.
Does that appear to be in substantially the same condition as it was when y'all repackaged it?
Yes.
I move to tender 120 at this time.
Any objection, Mr. Cruz? It is admitted.
As it relates to State's Exhibit 121, do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as being known head hair and known pubic hair of Valerie Low.
And does that appear to be in substantially the same condition as when it was repackaged or repaired by the GBI?
Yes.
Judge, I move to tender 121.
Mr. Cruz, any objection? It is admitted.
State's Exhibit 122, ma'am. Do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
And what is it and where is it identified as having been collected from?
This is identified as being known head hair of Valerie Low and known head hair of Ashley Peavy.
And is it in substantially the same condition as it was when it was repackaged by the GBI?
Yes.
Judge, I move to tender 122.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 123. Do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on the outside of the box.
And what is it and where is it identified as having been collected from?
This item is identified as being known head hair of Valerie Low.
And does it appear to be in substantially the same condition as it was when it was repackaged by the GBI?
Yes, it does.
Judge, I move to tender 123 at this time.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Ms. Kissel-Rao, thank you very much, ma'am. That's all the questions I have for you right now.
Mr. Cruz, cross-examination.
Do we have a box of gloves?
Well,
Medium and extra large.
I do just have it.
In court's indulgence, Your Honor.
Here are some of them.
My name is Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. Is it okay if I ask you a couple of questions?
Sure.
Okay. I want to make sure I pronounce your name properly. May I have your last name, please?
Kistler Rao.
Ms. Kistler Rao?
Yes.
Perfect. Do you have the slides with you?
I have some of the slides still up here.
Is it okay if I approach them?
Yes.
Approach them and grab them? Ms. Kistler Rao, you'd agree that the state asked you questions about these hairs here.
Yes.
Is that correct? Now, the hairs that the state asked you about weren't the only hairs collected. Is that correct?
I'm not aware.
Are you aware of a hair being retrieved from a power transformer in this case?
I'm not aware of that.
And are you the individual that packaged these hairs?
It was me along with 2 other hair examiners.
Okay. Which ones did you package?
I can tell you which labels are the ones I made.
Please.
I would need to see them.
Yes, ma'am. Let me slide these back in. In court's indulgence to figure out which hair is which. I'm just looking for a particular slide, if that's okay. And thank you so much for your patience. And these are the conditions. Well, let me rephrase that question. This isn't the condition that you put these slides or package these slides up as, are they?
So yes, we took those slides, put them in the slide boxes, and then packaged them.
In this condition, with the slides broken?
I'd have to see it a little closer, but it's possible, yes. So, no, it's fine. So the slide is a little bit broken, but it's still intact, so I am not sure if anything happened.
Policies in regards to safekeeping evidence in a criminal case?
What types of policies are you referring to?
Sure. Quality assurance policies, retention policies, storage policies to ensure that items aren't damaged.
So again, when we are done with an examination, we will package the items away into a sealed, secured container.
And your testimony is that you are not aware of any other hairs missing from these containers.
I'm not aware of it.
Sure. And you have your report with you?
I did not issue a report for this particular.
Well, Ms. Kistler-Rao, during direct, you said you were using your report to refer to the hairs.
No, I was using my notes to refer to the hairs.
Understood. So you didn't issue a report on and if I phrase it wrong, please correct me, but you didn't issue a report to the work you did prepping these hairs?
So I did not prep these hairs. It was just opened and inventoried, and then we might have taped some of these slides, repaired anything to preserve it for future effort. So no actual analysis was done at the time.
I may have asked this question wrong.
And I'm sorry, we've got a lot of these boxes open, a lot of people are handling them. I just want to make sure all the slides go back in the boxes that they were taken out of. So if we could do it in a way in which we're talking about one box or opening one box at a time, I think that is the best way to do it. I'm sorry, I know that's not a legal objection. It's just, I think it's something that might be important.
Well, and I guess we didn't talk about publishing it to the jury. They are in evidence, but we need to talk about, are you trying to publish all of the slides to the jury?
The relevant slides to the jury, Your Honor.
Okay. I'm going to have you put that on the record, which slides you want to publish to the jury.
Yes, ma'am.
I think, Your Honor, the jury something needs to be passed to the court, maybe through the bailiff or from the jurors, but they're trying to address the court about something here.
Thank you. Thank you for that. All right. Yes, sir.
Can we display these on the Elmo, please? I understand there's some latitude about how to do it, but this is not a good way to do this.
I think that would be best. Mr. Cruz, I'm going to ask you to retrieve that
Yes, ma'am.
piece of evidence.
I can do that.
Judge, I'm sorry, we may need to send the jury out so that we can see what fell, what we can recover, and what we can't recover.
Sure. Well, Mr. Chile would like to make sure that we have recovered everything. So I think probably that's the best way to handle this moment. Ladies and gentlemen, have you go into the jury room. It's a good time for a restroom break. And please don't talk about the case. I'll bring you out as soon as we can put things back together.
Yeah, do you want some gloves?
Yes. All right, Mr. Yeoman, Chile, Mr. Cruz, I'm going to have you, Mr. Bolden, take a look. Mr. Hall, take a look.
No, do not. No. She needs to go.
You can all go observe it.
Yes.
Yeah.
Okay. Please don't.
Y'all may be seated. Mr. Faust, you may be seated, sir. Y'all may be seated. I'm sorry, I didn't realize you were standing. You may be seated. Thank you.
Can we ask Ms. Kistler-Rao to step
Yes.
down?
Yes, sir.
Thank you, Judge.
that what we need to do? Ms. Cruz? Your client needs to use the restroom? Okay. Hopefully 10 minutes. We will be in recess for 10 minutes. We'll work it out, don't worry. I'll just call that for work. All right, let's go back on the record. We ready to proceed, counsel?
Yes, Judge. State's ready.
We have a motion, Judge. We may need a hearing on this.
Okay. Go ahead.
In regards to these items, we do need to have a chain of custody here, and I know I've raised that objection multiple times, but I'm looking at the glass slides, and I can stand to be corrected. But according to this slide, it is labeled as 2001 1002454, which is item number 12. Okay, this is our case number. There's no issue with the case number. But when you go to the chain of custody report, and this is listed as Q hair recovered from debris with power module. First, Your Honor, that isn't listed anywhere on the chain of custody report. But when you go to item number 12 on the chain of custody report, item number 12 is identified as sealed package identified as containing power transformer. These are two different items, Your Honor.
Let me just interrupt you for one moment, Mr. Cruz, and ask you this question about a chain of custody motion.
Yes, ma'am.
What is it ultimately you're asking the court to do with regard to your issue, whatever it is, with the, as you articulate, lack of a proper chain of custody? What are you asking the court to do?
We raised the issue. The state elicited testimony regarding these items and the proper packaging of these items.
I know, but what are you asking me
The
to
very
do?
first thing I'm asking, Your Honor, is to determine whether chain of custody is proper. If chain of custody is not proper, Your Honor, we're going to move for a mistrial. But I think we should flesh out the threshold issue. And, Your Honor, I respect the cross with utmost respect. Even if the Honorable Court decides to deny the motion, we may still move for a mistrial. A significant number of these hairs, if I'm understanding the labeling properly, are mislabeled. Now, I can stand to be corrected. The state could show me something that may be completely different. But I would ask to have opportunity to flesh this out on the record, if I may.
Mr. Yamacho, you care to respond to the motion, even though we haven't gone into full detail, about a lack of chain of custody and issues related to that in terms of a...
I can try, Judge. Here, I'll step to the microphone.
Okay.
I guess, one, there's been no identification of what exhibit it is that Mr. Cruz is talking about. I believe to the extent that a chain of custody challenge is made, and I'd have to look at the cases, Your Honor, but I do believe reading something about needing to make an affirmative showing of tampering, at least some type of evidentiary showing of that. But again, that's just off the top of my head when you're thinking about litigating chain of custody issues. As far as the chain of custody in this case, with both Lieutenant Liedall as well as Dr. Falzon, I believe, as well as Mr. Newton, who testified about the collection of known hairs as well, Your Honor. I think that the state has met its obligation thus far in chain of custody, and with the caveat that Mr. Peterson is expected to testify for the state as well. The extent of his testimony will be determined by the court's ruling in the Daubert motion, but at a minimum, he would testify for purposes of establishing another link of that chain of custody. I also believe, at least, that there is case law indicating that when you have an investigative agency or an agency like the GBI, essentially the entire agency is considered for chain of custody purposes. But again, Your Honor, I'm not citing these as holdings. I do believe that general principle is correct, though, but certainly could look into the issue further if the court instructs us to do so.
All right, thank you. So, Mr. Cruz, are you asking the court to not allow certain evidence in based on a chain of custody argument? Is that what you're asking?
So, Your Honor, that's what I was asking originally when we made the initial motion, just that the state lay a foundation for the chain of custody. Now I'm asking to flesh out, if the Honorable Court will allow, to flesh out the record in regards to chain of custody with the Honorable Court. And probably either way the hearing goes, Your Honor, unless I am mistaken, and I can be. I don't want to stand in my place and say I'm certain. I can be, but the burden is on the state to establish a chain of custody. If I am not mistaken, if there are errors with the chain of custody based on how far we've gotten in this testimony, not just her, but things we've discussed in this trial, including the envelopes, I would be moving for a mistrial at that time. But I would like to flesh out the issue a little bit further on the record first, if that is okay.
Okay, so the answer to your question is no.
Yes, ma'am.
And I don't really know what your motion is with regard to chain of custody, but I will just say this, that chain of custody, if you choose to challenge the chain of custody, certainly you have the right to do that if you decide that that's appropriate for your case. What you are referring to is the weight of the evidence rather than the admissibility of the evidence. And it is not... I'm just going to deny your motion on chain of custody. You can challenge it however you choose, but this is not a moment where the court has where the court is in a position to exclude evidence based on your argument that chain of custody has been established or hasn't been established. And that is an argument you certainly can make however you choose to do it. You can always make that challenge, but what you're asking the court is not something the court needs to make a ruling on in the manner that you have asked it to. So I'm going to deny the motion as best I understand it about chain of custody, and we're going to continue cross-examination. The court's question for all counsel is, where are we with the evidence that was on the floor or not on the floor, or did we sort that out?
Yes, Judge.
Okay.
One of the slides broke. However, it's my understanding that the mounting did not come apart.
Okay.
The evidence was not lost. Ms. Kistler-Rao, I think, was able to put things back together, and it was placed back in the plastic slide box.
Outstanding. Okay, so we're going to bring the jury back in. You may continue your cross-examination, and I think it is best at this point, Mr. Cruz, if you want to publish to the jury, to use the, well, I call it an overhead projector, but that is not what it is. We're going to use that. And then if the jury needs to handle any of the slides during deliberations, I think we need to talk about how to make that happen. Maybe bring them out, do it in more of a supervised fashion, things of that nature. All right. Would you bring the jury in, please? Thank you. All right, you all may be seated. Thank you. We're back on the record. Thank you for your patience, ladies and gentlemen. And Mr. Cruz, cross-examination.
Ms. Kistler-Rao, you would agree that the GBI has a policy for the preservation of evidence. Is that correct?
Yes, that's correct.
And the purposes of such a policy is to prevent evidence from being lost, damaged, mixed up, things of that nature. Is that correct?
Yes, as long as it's in our custody, we want to keep it secure, and then when we return it to the agency, we send it in a secured package.
Okay. Thank you. I would like to show you, I believe, a slide that you mentioned with the state that you repackaged. Can you identify that slide? Is that one of the slides that you repackaged, or would that have been one of the other two individuals?
I don't know who repackaged it. We all worked together at the same time, so I don't know which particular individual put that in the package.
Sure. But this, I'm assuming it was an agreement that it was okay to put this in the packaging in this condition?
Yes, it's intact and was able to be put in a slide box.
Sure. What year did this take place where you started going through the boxes with the two other individuals?
That was in 2024.
So this recently. Okay. Do you know that these hairs were collected in 2001?
Yes.
Okay. Do you know whether the hairs that are contained in these items are the actual hairs that were collected?
So I have no direct knowledge of the mounting of the hairs. The only knowledge I have is of the slides we received, everything. We repaired what we could and put it back in a package.
You said it repaired what you could. What about the things that you could not repair?
Again, we repaired them to the point where we felt that they were secure in their package.
Were these slides relabeled in 2024?
No, I don't believe so.
And I could have heard you wrong. I thought you mentioned during direct examination that you relabeled or you labeled some of these slides.
I was referring to the slide boxes. So the label on the outside of the box that told you what was inside that box. Those are the labels that we created.
That would be that item there?
That's correct, yes.
Can you tell the jury the preservation policy of the GBI when it comes to evidence collected on an open crime, on an open case?
Again, like our preservation is that we will place evidence in sealed packages. We seal them with evidence tape. That's secure, to secure them.
So to make sure I understand the entirety of the GBI policy and the preservation of evidence, you put it in sealed packages and secure it with evidence tape?
That's correct.
Is this considered a sealed package?
Those slides were placed in a larger slide box, and that slide box was sealed with evidence tape.
And were you the individual that sealed that box?
I don't believe I was the one who did the final sealing of the box.
I'd like to show you a couple of these slides. You let me know if this was part of the repackaging that you all were doing. Was it this difficult to get the slides inside of the box?
Sometimes it can be, yes.
Does that raise concerns about the slides being potentially damaged or breaking?
No, as long as they're in the box, it should provide at least better security for them than the former method of wrapping them in paper towels.
What I'm asking about particularly is putting the slides inside of the box. There are no concerns about these slides breaking?
I have yet to have an issue with slides breaking when I put them in the box.
Worse indulgence.
Do you want to give it to the witness?
Not these, you or another.
But if you're having trouble putting it back in, choose one.
I'd like you to put these slides in the box for the jury. Is it okay if I approach you?
Sure.
Would you like some gloves?
No, that's okay.
Okay.
So one of the slides was just misplaced, and it's no longer, I have to take two of them out because it's no longer in order. Okay. All right, now it's back in the box.
This slide here is one of the slides that that was found in that box. Not that one there, I'm sorry. This one isn't labeled. Your Honor, I'd like to show the witness what I'm marking as Defense Exhibit 31. Let the record reflect that I am showing the witness what is. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit 31. And take your time and look at Defense Exhibit 31. If you would like, you could take the slides out just to review the slides.
Okay.
I'd like to also show you State's Exhibit, well, before I show you State's Exhibit 114, do you recognize Defense Exhibit 31?
Yes, this item also has labels with our unique case number and item numbers of the slides that it contains.
And I want to make sure I pronounce it correctly. Can I call this a container?
Yes.
The container that the slides are in, you recognize that container, right?
Yes.
And the slides that are within that container.
Yes.
And are those slides in the container, have the slides in the container been altered in any way to your knowledge?
Not to my knowledge.
Okay. And is that a fair and accurate package of slides as you remember those slides?
As far as I know, yes.
Your Honor, I would move to admit Defense Exhibit 31 into evidence.
Any objection, Mr. Limoncelli?
No objection, Your Honor.
It is admitted.
May I approach the witness, Your Honor?
You may.
Now, you gave us a qualifier. You said not to my knowledge. Can you explain that? When I asked you, had these slides been altered in any way?
They don't appear to have been altered by me.
I'm trying to retrieve a particular slide. I ask you this. The state didn't ask you to introduce Defense Exhibit 31, did they?
No.
Okay. In Defense Exhibit 31, there's a hair in this item that is labeled hair from the power transformer. Is that correct?
Yes, that is what the box indicates, and yes.
And just, you didn't do any testing? I want to be clear on that.
Not on these particular items.
That is fair. But the hair that's from the power transformer is a fair and accurate depiction of what you remember packaging up in this device.
Yeah, that's what it was identified as with its label, yes.
And just so we don't confuse the issue with the jury, the hair from the drain assembly is different from the hair that would be on the power transformer that was found, correct?
Well, I might misunderstand the question a little bit. I'd object if it's calling for some kind of comparison between the hairs, as Ms. Kistler-Rao has testified that she didn't do any analysis. If Mr. Cruz is just saying that the two slides are different slides, then I don't have an objection. I'm just not clear entirely what the question was eliciting.
All right. Mr. Cruz, any response?
It was for comparison as far as her looking at the slides, both slides.
I'm going to object then, Your Honor. If he's asked, he already asked, and the witness said she had not conducted any analysis.
All right. Any response to the objection?
No, ma'am, I stand by my response, Your Honor.
Okay. I'm going to sustain the objection.
Yes, ma'am. Well, in this sense, slide-wise, because both of these will be into evidence, if I could get it out. And I ask you this, can you help me with this, Mr.
Try. Okay, which one? On that one? Oh, yeah, it's the only one. Oh, gosh. Get that. Almost. There we go.
I'd like to show you the slide that has been labeled as hair number 12 from cord of power transformer. Do you see that hair there, Ms. Rao? Kistler-Rao?
Yes. Yes, I do.
I'd like to also show you my last question for you. This hair is a part of Defense Exhibit 31, is that correct?
Yes.
Thank you. And I have no other questions for this witness, but I may need this witness's help putting these slides back in, Your Honor, so please forgive me.
All right. Mr. Yelman-Chile, any redirect of this witness?
I do.
All right. Go ahead, sir.
Yeah. Oh, that's fine. Do you want to just take it up? I can wait until you're done.
If you want to get that assistance now, you certainly can, and we can wait. That's fine.
No problem. Yeah, that's fine.
Go ahead, sir.
Thank you, Your Honor. I'm going to show Mr. Cruz what I've marked as State's Exhibits 124 and 125. And Ms. Kissler, I'm going to hand you States 124 and 125. Just a couple. Starting with States 124, do you recognize that item?
Yes.
How do you recognize it?
This item has our crime lab case number and the item number that the slides came from on the package.
What's located in 124 and where does it indicate that it was recovered from?
This is identified as the known head hair and known pubic hair of Ashley Peavy.
And does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And Judge, I move to tender 124.
Any objection? It is admitted.
And then as to State's Exhibit 125, what is 125?
125 is identified as the known head hair and known pubic hair of Tara Baker.
And how do you recognize that?
It also has our unique crime lab case number and the item number that the slides came from.
Does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And I'd move to tender 125 at this time, Judge.
Any objection, Mr. Cruz? No, ma'am. It is admitted.
And then Mr. Cruz asked you a question about what year it was when these items were repackaged. I think he testified to this earlier. What month and year was it when they were repackaged?
It was February of 2024.
Okay. I don't think I have any other questions for you right now, Ms. Kissler-Rao.
Any recross, Mr. Cruz?
No, ma'am, no recross.
May this witness be excused, Mr. Yamamochili?
We'd ask that she is, Judge.
Any objection from the defense?
No, ma'am.
You are free to go. You may call your next witness.
State calls David Griffith.
Could you get David Griffith, please?
Sir, will you raise your right hand and take an oath? Do you swear or affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? If you would, please state and spell your name for the record.
My name's David Griffith, D-A-V-I-D-G-R-I-F-F-E-T-H.
And sir, what do you currently do for work?
I'm a technology consultant. I primarily manage public safety information technology stacks.
Okay. Before you did that, did you ever work for the Athens Clark County Police Department?
I did.
How long did you work for ACCPD?
I worked for ACCPD for just under 15 years, from November of 2004 until October of 2019.
Okay. And what was your title when you were with ACCPD?
I was a criminal analyst.
All right. Let's back up a little bit. And what did you study when you were in college?
Finance at the University of Georgia.
All right. Did you take a little break before you received your degree?
I did. I was in school at UGA from 89 to 93. During that time, I started a software company, and my senior year of college, I left school to pursue that software company, sold the assets of that company in 2003, and went back and finished my last couple of classes to obtain the finance degree.
Yeah. Well, I just found this out now, but I think we were at UGA at the same time. I would have been a freshman, and
Yeah.
when you went back. But that software company, after you sold the assets of it, went back and got your degree, what were you doing after that?
I didn't really know what I was going to do. I just by chance ended up attending the Citizens Police Academy. I guess let me back up a little bit. I was in a church group. I made some offhanded comments about police officers to a buddy of mine that was a police officer in Athens, Clark County. And he challenged my assumptions about law enforcement in the community and said I should attend the Citizens Police Academy. So I did. The Citizens Police Academy at the time, and I guess it probably still is, was a kind of a public outreach effort to bridge the gap between the community and law enforcement. And it was I think it was a 12-week course. One night a week you would go, and some aspect of the department was presented to you, and you would get to see the inside operations of the agency. During that Citizens Police Academy, the command staff asked me to apply for a position at the agency that they had open. It was the crime analyst position. And I thought, well, I'll apply, and they offered me a job, and I thought, well, maybe I'll do this for a couple of years, and a couple of years turned into 15 years.
Initially, when they brought you on, was your technology background an attraction to them?
It was. The chief at the time, Jack Lumpkin, was looking to modernize the police department's technology stacks, and so I could offer some expertise in that area.
The crime analyst field in general in law enforcement, kind of what stage of its development was it in when you started with ACCPD?
It was a very new position that a lot of agencies did not have at the time. Athens was kind of on the cutting edge. The best way to describe it was it was a specialized unit that was trying to figure out its way in law enforcement and what role it would play at the time.
In your work as a crime analyst, were you ever involved in any trainings?
I was. Over the course of 15 years, I had hundreds of hours of training. As it relates to this trial, I was trained in all facets of intelligence analysts through the years, but specifically cold case homicide training. At the time I was hired in 2004, this case had languished a little bit, and they sent me to cold case training at GBI headquarters. It was a cold case training put on by DHS and FLETC. That was a 40-hour course, and they also sent me to the FBI Academy in Quantico, Virginia, to do cold case training there. That was another 48-hour homicide training course.
Okay.
And in addition to that, I think I went to Brunswick, Georgia, and did 40 hours of training with an NCIS.
Okay.
Did the homicide.
And so those were the trainings that you attended. Did you ever conduct trainings for any other crime analysts?
I did. Sometime shortly after the GBI training, FLETC approached me and asked if I would be an adjunct instructor for FLETC. FLETC is the Federal Law Enforcement Training Center down in, they've got multiple campuses, but the main campus is in Brunswick, Georgia. They train federal law enforcement across the nation. And so from 2007 to 2011, I was an adjunct instructor for FLETC and helped develop curriculum to train analysts across the nation.
At any time during your career with the Athens Clark County Police Department, were you assigned as a crime analyst to work on the murder of Tara Baker?
I was.
Okay. And if you recall, it's been a while, when do you think you first had contact with the case file?
Sometime in late 2005, I've got a very vivid memory of meeting the Baker family at the Arch on the 5th anniversary of Tara's death. So I know that in January of 2006, I was actively working on it.
Okay. Well, was there a detective at the Athens Clarke County Police Department that when you first got the case file, you were working on it with in conjunction?
There were two, Sean Potter and Courtney Gale.
Okay. And can you describe for the jury how crime analysts work in conjunction with detectives? What's your role in that relationship?
Can. So we were a support unit and that brought a specialized skill set to help analyze the case file. Our role was to help, at that time the case file was very large. So multiple volumes of statements, supplementals, evidence. It would have been thousands of pages at that point. So my role was to review the case file, make an assessment of where we were, what avenues we might explore going forward, and to give a broad overview synopsis of the case.
And so what kind of organizational condition was the case file in when you picked it up for the first time, or I guess we're assigned to it for the first time? I'm not sure you could pick the whole thing up.
No, you couldn't pick it up. It was literally multiple volumes locked away in the Criminal Investigations Division at the police department. So the case file at that time was what I would call analog. It was literally paper reports assembled in 3-ring binders. It was in good order. Lots of care had been taken to keep it in good order through the years. At that point, lots of investigators had worked on the case. My role was probably something like attorneys would get ready for a trial in court. I wanted to assemble a timeline of events so that we were sure we understood. Let me back up a little bit. When you've got a homicide investigation going on, this case had dozens of active investigators in the days immediately following the crime. There were investigators from the Athens Clarke County Police Department, the University of Georgia Police Department, the Georgia Bureau of Investigation. They were all working collectively to gather information and put together this case file. So what happens is those agents and case investigators go out and conduct interviews, collect evidence, and they write reports about what they've discovered or found or collected, and they're assembled in this case file. So my role was to go through that case file and to assemble a common book of facts, chronology. The software that we used to help assemble that knowledge was called Case Map. It's probably still used today. So that software labeled things like a cast of characters that would be the subjects that were part of the investigation, the witnesses, the persons of interest, the victims, the facts of the case, so the dates and times, the events that happened, the evidence that was involved in the case, so the trace evidence collected at the scene, all the evidence that you're going to talk about during the course of this trial.
So at any point, did an opportunity come up to discuss this case with other law enforcement professionals?
On many occasions.
Right. That was an imprecise question. I'll try again. Did any of those occasions involve the Federal Bureau of Investigation?
Yes.
Okay. And so can you tell me what that event was?
So at some point in 2006, one of the avenues that we pursued was we submitted the Tara Baker case to the FBI's Violent Criminal Apprehension Program. What that entails is we prepared a synopsis of what we knew about the crime and what had occurred, and what we knew about the victim and the offender, and we transmitted that information to the specialized unit at the FBI. The FBI, after receiving that report, asked the agency to come present the case file for peer review in Quantico, Virginia. That was sometime in 2006.
Did you take advantage of that opportunity?
We did. Myself, Sergeant Courtney Gale, who was with the Athens Clark County Police Department, Jesse Maddox, who was a GBI agent. I believe he's probably the SAC in Athens at this time. Monica Bumgarner, who was also a GBI agent. She now works for the ATF. We traveled to Virginia to present the case.
Can you describe, what does that mean or look like to present the case at the FBI Cold Case Symposium?
I can. We were one of, I believe it was 8 agencies that presented cases. So basically, the investigators and analysts from these agencies come together and present their cold case in a roundtable type form. So we all sat around and discussed our cases, made a formal presentation, and then collectively we talked about what each agency could do to further its investigation in the case.
Okay. In preparation for that, what's the depth of, I guess, information and knowledge about the case that you're presenting that's necessary to be able to present at a symposium like that?
The expectation is that you'll be able to present every aspect of the case that's important to the investigation. So you would need to know the case from beginning to end, all the facts, all the chronology, all the people involved.
And obviously, I think you said that was, you believe, sometime in 2006. It's been, depending when in 2006, 19 or 20 years since then. Has your memory faded a little bit since then?
Oh, yeah.
Okay.
I probably have forgotten more than I recall about this case after 20 plus years of working on it.
It's a pretty large file.
It is.
Well, let me ask you this. Do you recall the name Chris Melton?
I do recall the name Chris Melton.
Okay. So did ACCPD investigate Mr. Melton after this crime occurred?
We did.
And did you have an opportunity to review that investigation?
Yes.
Okay. At any point, did Mr. Melton become, in your estimation as a crime analyst and being part of the continued investigation for a number of years, no longer a viable suspect in ACCPD's mind?
Chris Melton, of course, was a person of interest from the very beginning. If you looked at homicides in aggregate across the nation, more often than not, the offender in a homicide's known to the victim, and often it's somebody that's close to the victim, a significant other, boyfriend, spouse. So Chris Melton was a person of interest for the agency, very much so. The agency went to great lengths, I guess colloquially in the inner workings of the agency, that the investigators would say, we're trying to either put this person in or put them out of the case as a suspect. I don't know that anybody would say Chris Melton was absolved as a person of interest, but he was not. Let me back up. So the case investigators very diligently tried to put together a timeline of Chris Melton's actions the day before and the day that Tara's body was found. And that effort alleviated a lot of suspicion in the minds of the investigators that worked on the case. Collectively, the thought was Chris Melton is not at the top of the person of interest list. The timeline that the case investigators assembled related to his activities had him, and I'm working from memory here, had him at home the night before Tara's body was found. His parents...
Say at home, where do you mean?
Well,
Yes.
I would, lack of personal knowledge and hearsay.
All right. Hearsay objection. Mr. Yalamachili, any response?
Judge, I think Mr. Griffith has information, personal information about the timeline that was assembled by the agency. Obviously, the state will be calling witnesses to establish Mr. Melton's whereabouts at the time that this murder occurred. But I do believe that this witness has personal knowledge of the agency's timeline.
I'm going to overrule the objection. You may continue.
So, Mr. Griffith, you were talking about the steps that the agency took in order to establish a timeline.
Right.
Can you talk a little more about what witnesses or were witnesses interviewed in order to establish that timeline?
Sure. The agency interviewed Chris Melton, Chris Melton's parents, a coworker of Chris Melton's, I believe his name was Josh, and interviewed bank employees related to a banking transaction that occurred the day that Tara's body was found.
And so, and you said interviewed, was the timeline that the agency put together established that there were individuals who said Mr. Melton was with them during the time that Ms. Baker was murdered?
Based on the collective statements of all of those people, it would have been virtually impossible without some magic technology to move you from here to 60 miles to the west for Chris Melton to have killed Tara Baker.
I don't have any other questions, Judge.
Cross-examination, Mr. Cruz.
Can you let the jury know what year Chris Melton's timeline was finally confirmed?
I would say it was 2000 and, well, I can't say what year it was definitive, not without looking at the supplementals, but it would have been early on in the investigation.
Yeah, sure. And this was based on an interview with Chris Melton, is that correct?
Right.
Okay. And you just tell me if you agree or disagree. Mr. Melton said he started his morning at his parents' home at 7:15 a.m. Do you agree, disagree, don't know?
Do we have can I use the copy of the timeline that I brought with me?
May I see it? Is that okay? May I see it?
Yeah. Yeah. Sure.
Questions open. Let me do this. Let's start this way, and I'll get back to Chris Melton.
Okay.
And thank you for allowing me to see this. Can I use this for a second? If you need
Sure.
it, I'll bring it to you. And the information in here is all information within your personal knowledge. Is that correct?
That's correct. I just understand that that document was prepared by me more than 20 years ago, so.
That's fair. I want to talk about the mitochondrial DNA analysis. Okay. What I understand is on page 5 of 36 of your report, the cold case, FBI cold case form, it states a request has been made to have mitochondrial DNA analysis done on one Caucasian pubic hair, which has not matched any elimination hair submitted. Is that correct?
That's correct.
Okay. Do you know, you know that mitochondrial DNA test was completed, is that correct?
I do.
Okay. And that pubic hair came back to match Mr. Chris Melton. Is that, excuse me, I said that wrong. That mitochondrial DNA test came back that it could not exclude Chris Melton as a contributor of that hair.
I don't know that that's accurate.
Okay.
I think my recollection is it matched a roommate. My recollection could be wrong, though.
Sure.
There was a lot of hair involved in this.
Sure. Was seeing a copy of the mitochondrial DNA report refresh your recollection?
Surely, yeah.
Court's indulgence. Hey, Your Honor, I'll ask this. Some testimony was presented that was not expected. I would like to address the testimony, but it may take me a minute to get the different files together. I would ask if we could take maybe a 5-minute recess for me to collect those files.
We can take a 5-minute recess.
Thank you, Your Honor.
I'll send you all into the jury room. This is a good bathroom break. Please don't discuss the case. Back on the record in 5 minutes. You all may be seated. Mr. Cruz, you have the floor.
All right, I'd like to show you I'm going to mark as Defense Exhibit 32. And Your Honor, thank you for the 5 minutes.
You're welcome, sir.
Let the record reflect that I've already shown the state what has been marked as Defense Exhibit 32. May I approach you?
Absolutely.
I'd like you to look at, take your time, look over the entire document, but the particular page that I'm going to ask you about in regards to your response to my prior question is page 4, the first paragraph, and the last sentence in the first paragraph of page 4.
And, Your Honor, just to be clear, I understand this is being offered to refresh Mr. Griffith's recollection.
That's correct.
Yeah, okay.
Okay, I got the first paragraph. What was the other part of the last page?
So the fourth paragraph on the last page. I'm sorry. The fourth paragraph on the last page in the, I'm saying that wrong. Page 4.
Third paragraph.
Page 4, first paragraph, last sentence.
And Judge, I do believe the witness can just review whatever he would like out of the report that he believes would refresh his recollection.
I mean, I think that is correct. You can
I don't disagree with that, John. I was trying to direct him.
Okay.
Have you looked at it?
I have.
Okay. Is your recollection refreshed?
It is. So the hair.
Can't read off of it.
Yep. Yep. So, all right. I'll let you ask a question.
Yes, sir. So in regards to the hair that was found on Ms. Baker's buttocks, Chris Melton could not be excluded as a source of that hair. Is that correct?
That's correct. And so could not Ashley Hall.
So let me ask you this. We talked about his alibi, okay? And you mentioned in regards to his alibi that he was with a coworker. Do you recall saying that?
I do.
Okay. Did you obtain any employment contracts to ensure that those two worked together?
I did not.
Okay. Did you go to any place of employment that them, excuse me, did you go to any place of employment that they may have worked on January 19th that confirmed that they were coworkers?
I did not. I did not personally interview Mr. Melton or the coworker.
Court's indulgence, Your Honor. Were you aware that Mr. McCourty and Chris Melton stayed less than a mile away from each other?
I have a recollection that they lived in close proximity to each other.
Okay. Were you aware that those gentlemen went to high school together?
I don't know that I was aware that they went to high school together.
Were you aware that Chris Melton left, were you aware that Josh McCourty drove Chris Melton to Athens?
Yes.
Okay. Were you aware that when Chris Melton gave his alibi to law enforcement, Josh McCourty left the police department?
I don't know that that would have been relevant to any of my analysis.
Okay. Well, the statement that you made is that Chris Melton's alibi has been confirmed. And I want to go through the steps that you all have taken as an agency to confirm his alibi. So as of right now, we've established that you did know that, or you may have known that Josh McCourty stayed less than a mile from Chris Melton, but you did not know that they went to high school together. We agreed on that fact, correct?
No, we don't agree on that fact. I may have known, it's been 20 years. I'm not going to remember all the details. I think I was doing good to pull up the first name Josh from memory, actually.
Yes, sir. But you told the jury on direct examination that you confirmed his coworker. Is that right?
That's my recollection, is that we interviewed his coworker, we interviewed his parents, we interviewed bank employees that were at the bank the morning he visited the bank, and that's how we came to put together the timeline of events surrounding Mr. Melton.
And I want to take it piece by piece, step by step, so the jury can understand what was done to verify this timeline. Is that fair?
Sure.
Okay, and please forgive the, I have to grab a couple of different things to go over that with you. So please, court.
Sure.
Would you agree that during ACCPD's investigation, you all were unable to speak with any supervisor that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I can't say. I don't recollect.
Okay. And that would be a fact that you, and I know it's been 20 years. I'm just asking this to put it on the record. Would you agree that fact would be significant?
My recollection of Melton's timeline is essentially this. Josh showed up at his house. They drove to the bank to withdraw some money. They went to a truck, to a company to have some work done on his truck, if I recollect. Those are all the details I can pull from memory off the top of my head.
Sure. So if you don't know, you could just say, I don't know, okay?
Okay.
I think we've already agreed, but I'll ask just in case. You're unable to speak with any coworkers that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m.
I did not speak with any of Mr. Melton's coworkers, other than reading supplementals and putting together the timeline after the fact. I couldn't attest to what was said or not said or who was interviewed.
Sure. But to your knowledge, you wouldn't disagree that as you sit here at this time, that you don't know if that was done?
I don't know.
Okay. Would you agree that you don't know at this time whether or not ACCPD spoke to any receptionists that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I don't recollect.
Would you agree that as you sit here today, you don't know if ACCPD was able to speak with any eyewitnesses that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
Can I have the report that I handed you back?
Absolutely.
Refresh my memory.
Now, I would ask you this. I've read the report. I know there's some language in the report. I would ask that, and just to let you know where I'm headed with these questions, I'm going to ask you very specific questions, and if you say that it's confirmed, I'm going to follow it with how. Is that fair?
Sure. Okay.
All right. So I believe the last question I asked you is, as you sit here today, you're unaware as to whether any any eyewitnesses confirmed that Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
Here's what I can definitively say about Nash Plumbing. Back in 2006, when I was reviewing the case supplementals and interviews related to this investigation, my note says that Chris Melton and Josh McCurdy visited Nash Plumbing from approximately 7:45 to 9 a.m. on the morning of the 19th. That was based on an interview that Billy Ricketts did on January the 19th, 2001 and January the 21st, 2001. I think the best source of information related to that interview would have to come from Mr. Ricketts or from the people that were the subject of his interview.
Sure. Can you repeat those times to the jury?
Sure. 7:45 a.m. to 9 a.m.
All right. So you were unaware that Josh McCurdy told law enforcement that at 8 a.m. he was in Grayson at a house. Were you aware of that fact?
I can't say that I was or was not. I don't recollect.
Well, you spoke of Detective Ricketts' report. Would you like to see Detective Ricketts' report to refresh your recollection?
Sure.
Court's indulgence. I'd like the record reflect that I am showing, and please forgive me, officer. Good afternoon. My name is Mike Cruz. I represent Mr. Edrick Faust. It has been a long day.
David Griffith.
Thank you, Mr. Griffith. Please forgive me. Let the record reflect that I am showing the State Detective Ricketts report from January 21st, 2001. Let the record reflect that I am showing the witness, Detective Ricketts' report from, I said the date wrong. I need to correct the record. From January 20th, 2001.
Okay. So my notes list Ricketts' report from January the 19th and January the 21st.
I have those two.
Okay.
Now I'll give you all three. I'll give you the 19th, 20th, and 21st.
Okay.
And what I'll do to make it easiest, since we're talking about Josh, I want to start with Josh. Is that fair?
Sure.
All right. It's okay if I approach you?
Mm-hmm.
All right. Mr. Griffith, I would like for you to read the second paragraph on that document, second paragraph, line number 4.
Okay.
You would agree that Josh McCurdy stated at 8 a.m. he was in Grayson checking a house for leaks. Is that correct?
He said that they went to a house to check leaks.
At what time?
8 a.m.
But you just told this jury that from 7:45 to 9 a.m. they were at Nash Plumbing.
Well, the jury that I was, this is my recollection of what happened. It's based on these notes here.
Understood.
Right.
Will we agree at this time that there's at least one error in the notes?
So Sir, this is a supplemental report written by a case agent. Hopefully, at the time that we prepared this, we went back and listened to the interviews directly. But I can't recollect what we did 20 years ago. But the case synopsis that we took with us to the FBI in 2006, we collectively made the analytical determination that from 7:45 to 8 a.m., Melton was at Nash Plumbing.
So the time has changed from 7:45 to 9 a.m. to 7:45 to 8 a.m.
From 7:45 to 9 a.m.
Okay, excellent. May I approach?
Sure.
And just to make sure that we're clear on what we established that Josh said that he was in Grayson at 8 a.m. Would you agree with that?
Yes.
Okay.
That's what the supplemental report that I read says.
Okay. And the one that you mentioned that your notes were based off of, is that right?
No. My notes were based off reports from the 19th and the 21st.
Okay. So we'll go to the 19th. Showing the state Detective Ricketts report from January 19th, 2001.
Cruz.
Yes, sir.
And I guess no objection. I think that is Detective Ricketts' report from January 19th of 2001. I don't know that the witness has been asked an additional question that he has said he doesn't recall in order to refresh his recollection with this report, however.
Sure.
I think that's fair.
Sure. Chris Melton stated that they went to Grayson, Georgia after 9:30 a.m. Is that correct?
I don't know that I can say. I don't have a recollection of what Chris Melton said at this point 25 years later. I'm looking at the notes that are here in front of me to try to recollect, but I can't definitively say what Chris Melton said.
Would Detective Ricketts' January 19th, 2001 report refresh your recollection?
Possibly.
Okay. And I would like you to look at paragraph 2. The third sentence from the bottom to the bottom of the page. And let the record reflect that I'm showing the witness, Detective Ricketts' January 19, 2001 report.
Okay.
So Chris stated they were in Grayson at 9:30 a.m. Is that correct?
That's correct.
And just to make it clear for the jury, so Josh McCourty's alibi for him and Chris is at 8 a.m. We're in Grayson. Chris Melton's alibi for himself is at 9:30 a.m. We're in Grayson. Is that correct?
That's what that supplemental report says, yeah.
Okay. And this was the report you told me you relied upon. Is that correct?
So we referenced the interview that Ricketts had. We probably listened to the interviews.
Officer, we've already talked about this. We've already agreed on this. We talked about this earlier. So you didn't tell me that the January 19, 2001 Ricketts report was the report that you relied on?
So we looked at the total collective case file back when we prepared this in 2006, which would have been the interviews. You know, if there were video or audio interviews, we would have reviewed those. We would read those supplemental reports. Our collective assessment was we felt like Chris Melton was nowhere near Athens, Georgia during those hours.
But officer,
Whether it's in Grayson or at Nash Plumbing or it wasn't Fawn Drive in Athens, Georgia.
But you would agree with me, law enforcement officers don't go off feelings, they go off evidence. Is that right?
That's correct.
Okay.
Yeah, but it's not abnormal to take statements from different individuals and have time variations in their statements. You know, it's difficult for people to remember what they did yesterday.
Sure. What if they say they went to different places? Is that abnormal? Abnormal?
I don't think they say they went to different places. They collectively agree that they went to Grayson, right, to check a house for leaks.
Sure. So this is what I like to do. I like to show you the January 20th, 2001 report from Detective Ricketts, and I would like you to advise the jury of where Mr. McCourty said they went after leaving Nash Plumbing. Is that fair?
Well, and Judge, I am going to object to that. Refreshing recollection isn't handing Mr. Griffith the report and asking him to relay to the jury what the report says. The question needs to be whether or not the report refreshes and brings to mind independently a recollection of that event.
Any response, Mr.
I agree.
I'm going to sustain the objection.
Josh McCourty stated after leaving Nash Plumbing that him and Chris went to Chick-fil-A. Would you agree with that statement?
That's what the report said.
So Josh McCourty said they went to Chick-fil-A. Chris Melton said they went to Truck Customs. Would you agree?
I think they did both, probably.
Well, we'll get into that. We're going to get into that. But Chris's next stop was Truck Customs. Is that correct?
Right.
Okay. And Chris says that they were at Truck Customs around 9:30 or sooner.
That's possible. I don't remember, what exactly his statement was.
Sure. Was seeing the report refresh your recollection?
All I'll be able to tell you is what that report says. So if that report says,
well, so don't move the ball on me.
But what you need to recognize is that's a summary of an interview that was conducted with this individual, and it's a summary that's paraphrased. So that wouldn't have been the best evidence for us at the time. Looking at this case file, we would have listened to the interview. Hopefully, I don't recollect if Ricketts recorded it or not, but that was the expectation at the time, is that you would record your interviews. We would have listened to the recorded interview.
So I want to make sure that you and I are on the same page. So it's not Ricketts' reports that you relied upon, it was the recorded interviews that you relied upon.
So we looked at the totality of the case file when I started looking at this case, which included audio recordings, video recordings, supplemental reports that case agents and investigators wrote. The totality of the case file as it was when we picked it up in 2005.
Sure. So I asked you a couple of questions. If you don't remember, we'll play the audio recording for you. Is that fair?
Okay.
Judge, I am going to object. I think the witness has testified that all this will do is give him an opportunity to say what is in the report or what is in the recording, not develop an independent recollection of his own. I think that was his testimony the last time that a report or anything else was offered to him. So I'm going to object to that. Detective Ricketts I anticipate is going to testify in this trial. So I'm going to object at this point to using cross-examination as a method to just read in portions of a police report.
May I respond?
Of course.
The state opened the door to this line of cross-examination. This witness, nowhere in the discovery file, mentioned a statement that we confirmed Chris Melton's. Let me rephrase that. The anticipated testimony for this witness based on the state's discovery file had nothing to do with confirmation of Chris Melton's alibi, or non-confirmation of Chris Melton's alibi. When the state elicited an answer from him stating that we confirmed Chris Melton's alibi, it would be impossible for Chris Melton to be in Athens at the time, and he relied on these reports in making that decision. The state opened the door to this line of cross-examination. That's one, but I think that misses the issue of the state's objection. In regards to the state's objection, Mr. Griffith stated that he relied on these reports as well as the recorded audio in coming to his decision, Your Honor.
So let me ask you this question, Mr. Cruz. What is it that you're trying to do right now?
confront the statement that he made that Chris Melton's alibi was confirmed. It was not, Your Honor. We have the evidence to show that.
I'm going to sustain the objection and ask you to move on.
Yes, ma'am. Officer, I have no more questions for you.
Okay.
Any redirect, Mr. Yalaman-Chile, of this witness?
I just want to clarify, because there were a couple questions that Mr. Cruz asked you that I think the tail end of your answer may have been cut off. Just want to clarify a couple things. Mr. Cruz asked you if Josh McCurdy said...
Objection, Your Honor. You just stated that we could not go down that line of questioning, so I would ask that the same restriction is placed upon the state.
Okay, well, that's not exactly what I said, but what is your specific objection?
Relevance, Your Honor.
Okay. Mr. Yalaman-Chile, how is that relevant?
I'm simply asking the witness to clarify the answers he gave to two questions that Mr. Cruz directly asked him.
All right. Anything further, Mr. Cruz, based on that?
I would just simply ask the same restriction that's placed on us, that we can't get into that with this witness. I would ask that the same restriction is placed on the state. As I mentioned, Your Honor, they opened the door to this line of questioning. I was confronting the answer. If I can't ask about it, and I stopped as soon as he made his objection, the Honorable Court stated that I couldn't ask those questions. I would ask the state not to make, let me rephrase that. I would ask that the state is, the same restrictions are placed on the state that's placed on the defense at this moment.
And if I,
that line of questioning.
if I could respond briefly.
You may, sir.
This is a question that Mr. Cruz did ask and received a response to with no objection, so I don't understand that argument. And I believe it is something that's proper in redirect to ask about specific responses to questions asked on cross-examination and the answers that were admitted in front of the jury.
All right. Yes, sir.
He is trying to skirt around the Honorable Court's ruling. Your Honor has made it clear that that line of questioning is not appropriate for this witness. If he didn't object to it, he can't open the door, allow the questions, object. The Honorable Court says, no, those questions are not allowed, and then get up and follow up on the questions that I understand the Honorable Court is saying are improper for this witness. So I would ask that the state not be allowed to ask those type of questions, Your Honor.
All right. Thank you. All right. So with regard to the actual objection, I think, Mr. Cruz, you're misstating what the court did. I have said this before. The use of the word restriction is not appropriate. The court made a ruling based upon the law and the analysis of the objection and what it entailed. It is not actually called a restriction. The state made an objection, the court ruled on it, and I sustained that objection. With regard to this particular moment, the state is asking to redirect based upon two questions that the defense asked that were permissible. I'm going to allow it. You may proceed.
So I want to start first with a question that was asked to you. I think Mr. Cruz asked you a question of Mr. McCurdy said he was in Grayson at 8 a.m., I believe was the question. Your answer said they were. What do you mean by they?
So Josh McCurdy said that that's what the supplemental report said, they. So I think the best way to let's back up and talk about what I know. Collectively, at the time we were reviewing all of the interviews that had taken place previously in this case, where we looked at Josh's statement, Chris's statement, the parent's statement. Collectively, they all put Mr. Melton to the west, way out of Athens, Georgia. There may not have been perfect agreement in the minute-by-minute recollections of where people were, but at the end of the day, there were multiple people that put Chris Melton over at his home, near his parents' home.
Well, and I'm sorry, and I just want to stop you because I think I might have asked my question poorly.
Okay.
But
hang on one second, Mr. Yalaman-Chile. I think Mr. Cruz has an objection before you continue. Go ahead, sir.
The state has opened the door again, and I would ask for the of opportunity to cross-examine this witness on the statement that the witness just made before the jury?
You will certainly get the opportunity to cross-examine. I don't know, I'm not going to respond to the opening the door at the moment. I don't know that that's necessarily an objection, but if you need to recross this witness, you certainly may do so. Go ahead, Mr. Yalamanchili.
And I'm sorry, I'll ask it more precisely. They is a plural pronoun, correct?
I take that to mean, based on my collective knowledge of the case, that Josh and Chris.
Okay, that was my only question. And I'm sorry, I should have asked it in a more precise manner that way. Mr. Cruz asked you about some mitochondrial DNA results, and he said this result indicated that Chris Melton could not be excluded in the report. And your answer referenced one other person in addition to Chris Melton. Who were the people who could not be excluded as contributors of that hair?
One of Tara Baker's roommates and Chris Melton.
Okay.
I believe it was Ashley Hall.
That's it, Judge. Just those two questions.
Recross, Mr. Cruz.
Absolutely, Your Honor. And I just want to follow up on a specific question that the state asked you. He asked you what did, he stated that on cross-examination, I said he, you said they, and they means Chris and Josh. Is that correct?
That's how I took it.
Okay, that's fair. And then he asked you about the timing of being in Grayson at 8 a.m. Is that fair?
Yes.
Okay, so I'm asking you a different question from what I asked you before. Chris Melton stated that he was at Nash Plumbing at 7:45. Is that right?
I believe that's correct. Yeah. So my notes say that, and this is a case summary that was presented to a bunch of investigators at the FBI, right? We believe, based on the totality of the interviews that we listened to, the case supplemental reports that we read, that Chris Melton was not in Athens, Georgia. He was over near Nash Plumbing.
But, officer, you already said that you all didn't confirm, or you're not aware of you all confirming Chris being at Nash Plumbing. That's
not what I said. I said I couldn't confirm, but I'm looking at this case file multiple years down the road, looking back at interviews that were done in 2001. As I sit here today, 20 plus years later, I may not recollect accurately what we looked at 20 years ago. But my understanding of the case is we felt collectively at the time that Chris Melton was not, that it would not have been possible for him to have been in Athens, Georgia and killed Tara Baker.
Okay. And that was based on, I think we agreed, just you all's collective feeling. Is that correct?
No, not our collective feeling, our collective review of all the evidence that had been collected to date.
So let's talk about the evidence. You would agree that law enforcement spoke to Chris Melton's parents 4 months after Ms. Baker's death?
I couldn't tell you when they spoke to them. Here, 20 years later, I don't know what day they spoke to his parents.
Mr. Griffith, we can't have it both ways. We can't say we're sure that we confirmed Chris Melton is away from Athens, Georgia, and then when we asked about the specific...
I don't think those are my words.
Hold on. I'd ask that Mr. Cruz ask questions to the witness, not make comments about the witness's response.
Yeah, I think that's correct.
Yes.
Ask a question, Mr. Cruz.
Yes, ma'am. But you would agree that, I believe it was, I won't even say the date, but in May of 2001, law enforcement went to interview Chris Melton's parents regarding his alibi for the first time.
I cannot tell you when they went to interview them for the first time. Sitting here today in 2026.
That is fair. Did you look at any report that discussed when they went to interview?
I'm sure I did.
Okay. Would seeing that report refresh your recollection?
All I would be able to do is read back the report to you at this point. And that, I'm not trying to be belligerent or difficult. I can't tell you, what we did 20 years ago to a certain date.
But officer, you just told the jury what you all did 20 years ago. We just want to understand the foundation of it. Is that fair?
Object again, Judge. Mr. Cruz is to ask the witness questions, not make comments about the witness's responses. So I would object to the form of the question.
That's correct. Mr. Cruz, ask a question if you want to.
I do want to, Your Honor.
Then go ahead.
Please forgive me. And I'll say, please forgive me, Mr. Griffin. Let's take it step by step, okay? You relied on Detective Ricketts' January 19th and January 21st report. Is that fair to say?
Asked and answered.
I'll allow it. Go ahead.
Is that fair to say?
Yes. And the only reason I can say that is because I have it in my notes that that's what we relied on.
Okay. Excellent. And we've agreed that from 7:30 to 7:45, Chris Melton stated that he was at Nash Plumbing.
My notes say that from 7:45 to 9 a.m., Chris and Josh McCurdy were at Nash Plumbing. And that, this is a summary of a lot of interview that took place. So as I sit here today, all I can tell you is we didn't believe they were in Athens, Georgia. Now the best way would be talk to Chris Melton, right, and Josh McCurdy.
Well, I just want to follow up on your statement. So let me ask you this. Is it fair to say that we shouldn't, and this is the best way I can frame it, so please forgive me. Based on our conversation here today, your report may not be the best place, your report may not be what we need to trust in determining whether or where Chris Melton was on that date. Is that fair?
We started out talking about what my recollection and understanding of the case file was, and my analytical assessment in 2006, and still to this day, is that Chris Melton was not in Athens, Georgia, and that's based on all the testimony of the people that we've talked about.
And that's Josh McCurdy, correct? Chris Melton, and Chris Melton's
You could say yes or no, please, sir.
Yes, yes, and bank employees at a bank. I want to say it was a Wachovia, but off the top of my head, I can't be certain.
You would agree with me that Chris Melton wasn't at the Wachovia until 9:08 a.m. Is that correct?
I don't know for certain.
But you spoke to 4 people. Is that right?
No, more than 4 people.
Okay, so it's no longer Josh McCurdy, mom and dad, Chris Melton, and bank employees. Who else did you speak with?
My recollection is we spoke to Chris Melton, Josh McCurdy, Chris's mom and dad, and 2 bank employees.
So for the purposes of this conversation, we'll take the bank employees out of it. You and I have agreed upon that you didn't know that Josh and Chris went to school together. Is that right? We've agreed on that.
No, we haven't agreed on that. I don't remember if I knew that or not. Right now, as I sit here, I don't recollect.
Did you note it in your report?
Not in the report that's in front of me, no.
Okay.
And I'm not sure why it's relevant. What does that have to do with anything that we're talking about?
Well, we could talk about it after court, but as of right now, the Honorable Court has said I only can ask questions. So can you answer that question for me, officer?
What's that?
The question is it in your report that Josh and Chris went to school together?
No, and I don't believe that I would have included it in my report if I'd known it.
So your report does not include all the details relevant to this case. Is that fair?
I think it includes the key details that were important to our investigation at the time that I prepared it.
But, officer, you told the jury that Josh and Chris were employees. Would you agree that that gives a different significance from high school classmates? I'll say that.
Absolutely. The totality of the relationships between all the people involved are for the jury to weigh. Absolutely.
And were you aware that Chris Melton was his parents' only child?
I believe I was.
Okay. And is it fair to say, do you have children, officer?
I do, yeah. And parents will do a lot for a child.
I don't even have to ask my next question then, officer. In regards to Nash Plumbing, that's really what I want to focus on. I want to focus on the Nash Plumbing. I want to make sure that we're on the same page. We've gone from, I believe, and correct me because I think I'm going to say this wrong. We've gone from 7, I'll say this. Give me the times that you state Chris is at Nash Plumbing.
So on this timeline, we have from 7:45 a.m. to 9 a.m.
At Nash Plumbing.
Mm-hmm.
And we've established that Josh McCurdy said at 8 a.m. they were in Grayson, Georgia.
Right.
Okay, and we've also established that Chris Melton said after 9:30 a.m. they were in Grayson, Georgia.
Right.
Okay, so you'd agree this is one contradiction in the alibi.
And like I said before, there are going to be contradictions when people are trying to recollect
Sure.
minute by minute.
That is fair.
History, right?
That is fair. Would you agree that after leaving Nash Plumbing, Chris Melton stated that they went to,
I think it was Truck Customs.
correct. However, Josh McCourty stated they went to Chick-fil-A. Is that correct?
That's what the supplemental report has in it. Yeah.
Sure. And this is a question I want to ask you, okay?
Mm-hmm.
You would agree that Josh McCourty was asked if he went to the bank with Chris Melton. Would you agree with that?
Yes. I feel certain that that was a question that was asked of him.
Okay. And Mr. McCourty said he didn't remember.
I don't recollect what I can't tell you what he said.
Would he in the recording refresh your recollection?
The same objection as before, Your Honor. This witness has indicated repeatedly that all the reports or recording would do would prompt him to say what is in the report or recording, because he didn't interview. Anyway.
Sustained.
Yes, ma'am. Yes, ma'am. Court's indulgence. Chris stated that they went to, well, excuse me. Do you recall Chris stating that they went to Forsyth and met with a contractor named Mike? Do you remember that?
I don't remember those details.
Okay. Do you remember anyone at ACCPD ever speaking to a contractor named Mike that could confirm that Chris was in Forsyth?
I can't say with certainty whether or not a contractor in Forsyth was spoken to.
Okay. And I ask you this, and I'll let this probably be my final question. When it comes to the questions I asked you, there's no certainty, but you would agree when the state asked you if Chris...
You object to that question, it's argumentative.
Sustained.
Sure. Is it fair to say we aren't... Outside of the three individuals you spoke to, excluding the bank, is it fair to say we don't have any other evidence of where Chris Melton was between 7 a.m. and 9 a.m. on January 19, 2001?
Mr. Cruz, what I can tell you with certainty is that as I sit here today in 2026, my assessment of Chris Melton's timeline in 2001 as an investigative analyst that's investigated hundreds of violent crimes is that Chris Melton has substantial testimony from other people that puts him away from Athens, Georgia at the time Tara Baker was killed. And our assessment in the analytical unit at the Athens Clarke County Police Department was that Chris Melton could not have killed Tara Baker.
And that's based on those?
That's based on the totality review of the case file at the time that we looked at it in 2005. And that's what we presented in Quantico, Virginia at the FBI Academy.
Sure. And even the FBI advised you all to investigate Chris Melton's hard drive. Is that correct?
I recollect that there was a suggestion to look at his hard drive in an email from Christine DePoyster. I don't know that Chris Melton had a hard drive to look at.
Well, this is what I follow up with. If ACCPD was so certain that Chris Melton was away from Athens, why would the FBI request or instruct you all to look at his hard drive?
It goes back to something I said before. We did not eliminate Chris Melton as a person of interest. He was not at the top of our list of persons of interest. So, from an analytical standpoint, we had to look at, could we absolutely eliminate him? I would not absolutely eliminate my mother from the crime. If somebody came and said that my mom could possibly have been involved, but it made it, the totality of the statements that we reviewed made it seem very implausible that Chris Melton was in Athens, Georgia at the time Tara Baker was killed. Now, if you presented some significant evidence, if Chris Melton was seen on video in the neighborhood with a timestamp of 8 a.m. on January the 19th in 2001, that might change my assessment. But
Well, can I ask you this?
Sure.
You would agree that Mr. Faust wasn't seen on video at 8 a.m. in the neighborhood. Is that correct?
I didn't say he was, but I was talking about what might change my mind. Now, if we saw a video of Mr. Faust in the neighborhood, that would be a clue, right?
But you also didn't see any video of Deer Park. Is that right?
I don't think I saw any video from Deer Park.
And outside of the bank, so we're not talking about the bank. We're going to assume that the bank is at 9:08. Between 7 a.m. and 9 a.m., you all didn't collect any video where Chris Melton was located. Is that correct?
The only video that I recollect being collected, or I don't think it was collected, I think it was seen, was Chris Melton in a bank.
That's fair. And to conclude my questions for you, FBI stated search the hard drive. That wasn't done, was it?
I don't believe there was a hard drive to be searched.
So that's a no?
I cannot say with certainty that we didn't search a hard drive as I sit here today, but I do not have any recollection of searching a hard drive.
Okay. Well, I thank you so much for your time. I thank you so much for answering my questions. Your Honor, those are my questions for this witness.
Any redirect, Mr. Yalamanchelli?
No, Judge.
May this witness be excused. Mr. Yalamanchelli, may the witness be excused.
Judge.
Any objection from Mr. Cruz?
Did you receive a subpoena from our office?
I did not.
Okay. No objection.
You are free to go, sir.
May I sit in the courtroom, Your Honor?
Yes, you can. Your testimony is over. All right, ladies and gentlemen, it's 5:30. We have gone a little bit past sort of my 5 o'clock stop, and so we are going to stop. Thank you for your patience. I'm going to release you today, ask you to return tomorrow at 9 o'clock. The attorneys in the court are going to take up some things outside your presence, so hopefully we'll be able to start right at 9 o'clock tomorrow. We are going to finish tomorrow. I believe it's at 2:30. Is that the time? Okay, 2:30 tomorrow. And so because of that, we are going to bring lunch to you all again tomorrow. We'll bring you the, I'm not sure what it's going to be. It may be menus again. I'm not really sure, but we will certainly provide that for all of you. Please don't discuss the case. Do any research. Go on the internet and look up anything you may have heard. Enjoy your evening. We will see you tomorrow at 9 o'clock. The deputies, are going to escort you all, of course, to the elevator and take you down to the parking garage. Thank you. let's talk about what we were going to do. Were we doing the motion at 8:30 or was it to now? I think we may have said two things.
Fortunately, there are two, Judge.
Okay.
One now and then
Okay.
Mr. Peterson was 8:30.
Mr. Peterson's the one in the morning.
Yes, sure.
Okay.
Hey, can I put something on the record just in the meantime?
Can you, I'm sorry, go ahead.
Can I put something on the record?
You may.
In regards to next. Just putting this on the record in regards to Defense Exhibit 30, which were Tara Baker phone records. If undersigned counsel understands Mr. Bowden's objection correctly, it was that the records were hearsay and I needed to lay a foundation for the business records.
Wait, Mr. Cruz, I probably should have asked you what you need to put on the record. What is it that you're doing?
I was just going to put the grounds of admissibility for D30. That's all.
But I've already heard the objection and ruled on it.
No, I wasn't asking for a ruling, Your Honor. I was just asking to preserve the record.
Well, the record is preserved because it's being transcribed. I'm not sure I know what you're referring to.
Please forgive me.
Okay.
So I didn't quite understand Mr. Bowden's objection, so I didn't put my response to his objection once I understood it that it may be a hearsay objection on the record. What I intend to put on the record, if I may, is just simply that the phone records are non-hearsay because they are computer-generated records. So if his objection was that it needed a business record certification to come in as hearsay, our response would be that it is non-hearsay because these records were computer-generated. That's all, Your Honor.
All right, thank you. And Mr. Bolden, did you want to respond then to Mr. Cruz's response?
No, Your Honor.
All right, thank you. All right, what are we going to handle this afternoon since we're doing something at 8:30 as well?
Your Honor, we are prepared, state is prepared to address Mr. Cruz's Daubert motion filed back on October 2nd of last year. The court may remember that the state, I think we made a joint motion to continue this. The state's reason for doing so is that pardon me, Your Honor, is that our witness, who is currently right outside the courtroom, would be traveling from California, and we were trying to see if we could only require her to travel here once. And so the plan was, as I understood it, was to have her testify outside the presence of the jury for the Daubert purposes, and then, depending on the court's ruling, we would have her testify tomorrow morning.
Hold on just a minute. I'm trying to find your motion. You said the motion you're referring to, it was October 2nd? So you want to have the Daubert motion now?
Yes, Your Honor.
Okay, I just need to find it.
And I would object to having it now. I would like notice to prepare for the hearing. I know we said that we would have it when she gets ready to testify, but we never set a date certain. So I would ask for time to prepare for her hearing as opposed to doing it on the spot now. I don't have all my items.
All right. Tell me the name of the person that you were asking to exclude the testimony of? Okay, I just have to find, oh, here it is. All right. All right, Mr. Bolden, do you care to respond to this defendant's request?
Your Honor, Ms. Lycombe, like I said, is right outside the courtroom. The state's ready to go. I thought that was what we had discussed this morning, so we're ready.
Okay.
I'm requesting more than the same day notice for hearing on this Daubert.
Okay, well, let me say a couple of things. So first, I think it's appropriate for counsel to always be prepared for motions they know that are coming up. I mean, we have discussed this. I remember it now. I'm looking at the motion. There were several, I think, that we were going to have before the testimony. Now, I think it's appropriate for all counsel to always be prepared once trial starts anything can go. So I will say that. This is what I'm going to do, though. I'm going to let the state present their side, and if you're not prepared to go forward, we will address it tomorrow at 8:30. All right, you may proceed, Mr. Bolden.
Thank you, Your Honor. Marissa Lacon?
Would you get Marissa Lycon, please?
You can go ahead and have a seat if you'd like. Ma'am, can I get you to raise your right hand, please? Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you could state your name and spell it for our court reporter, please.
My name is Marissa Lacon, and it's spelled MARISSALICON.
Where are you employed, ma'am?
I'm employed at Pure Gold Forensics.
Where is Pure Gold Forensics located?
We're in Southern California.
What what is Pure Gold Forensics?
We're a private accredited DNA forensic laboratory. So as a private lab, we provide services for prosecution, defense, as well as private parties.
How long have you been working at Pure Gold Forensics?
Since May of 2022, approximately 3.5 years.
Okay. And can you tell the court a little bit about the responsibilities you've had at Pure Gold since you started working there?
Yes, so I started as a laboratory assistant, which consisted of maintaining the laboratory cleanliness, receiving and sending back evidence, maintaining chain of custody of that evidence, as well as any administrative duties, as well as I'd maintain the temperature logs in the laboratory and clean our instruments. Do you want me to go to my duties now?
Yeah, and then after working as a laboratory assistant, were you promoted to the title of forensic scientist?
Yes.
And when did that occur?
In February of 2024.
Okay. Tell the court a little bit about your responsibilities as a forensic scientist.
As a forensic scientist, I perform serology testing as well as DNA casework using Global Filer and Y-Filer amplification kits. I analyze mixtures using StarMix probabilistic genotyping software, and I analyze the data and produce scientific reports based on that data.
You mentioned StarMix just a minute ago. Are you familiar with TrueAllele? I'm
familiar.
Okay, and I guess my question would be, are those kind of competing brands of probabilistic genotyping software? Okay. Talk to the court, if you will, a little bit about your educational background.
I have a Bachelor's of Science degree in Forensic Chemistry with a concentration in Criminalistics from California Baptist University.
Can you speak a little bit to any specialized training that you've had as it relates to your job as a forensic scientist at Pure Gold?
As far as like continuing training or just training in general?
Yes.
So as analysts, we're required to complete at least 8 hours of continuing education per year. That can include lectures, conferences, webinars that brings analysts up to date on current technologies and information, as well as we're required to complete monthly reading in the laboratory on scientific articles, anything having to do with DNA analysis.
Do you belong to any professional organizations?
Yes, I'm an affiliate member of California Association of Criminalists, as well as a professional affiliate of American Academy of Forensic Sciences.
In your role as a forensic scientist at Pure Gold Forensics, do you have the occasion to run testing on items of evidence that may be submitted in an attempt to ascertain their possible biological origin?
Yes, so at our lab, we offer testing for different biological fluids. We offer blood, semen, saliva, urine, as well as microscopic examination of vaginal epithelial cells and identification of spermatozoa.
Ma'am, have you previously testified as an expert?
Once before.
Okay, and where was that?
In Colorado.
And do you recall what you were tendered as an expert in?
DNA analysis.
Your Honor, at this time, I would move to tender Ms. Well, I haven't finished talking yet.
Go ahead, sir.
I would move to tender Ms. Lycon as an expert in forensic chemistry and forensic biology.
Okay, forensic chemistry. All right, Mr. Cruz, any objection? And
Yes.
we talked about your needing to go get your information, and so let me know, do you want to proceed or do you want to adjourn and come back at 8:30 and finish any cross-examination?
I think I'll proceed, Your Honor.
All right, go ahead, sir.
And just to make sure before I proceed, Your Honor, can you repeat what the state has tendered her as an expert in?
Yes, what I wrote down, Mr. Bowl, to make sure that this is correct, is that he is asking to tender this person as an expert in forensic chemistry and forensic biology. Is that correct, Mr. Bowl?
It is, Your Honor.
All right, go ahead, sir.
Can you tell the Honorable Court what forensic chemistry is?
Forensic chemistry would be, well, it's chemistry, so the study of elemental composition with a forensics application.
Can you explain that in layperson terms?
So it would be like chemical substance in reference to forensics, so having to do with evidence examination.
Okay, in what way?
So, for example, an example that comes to mind would be blood alcohol content. So, testing that in regards to like a legal matter.
Okay. You would agree that you are not here today to testify about blood alcohol content. Is that fair?
That's correct.
You would also agree that you have never been admitted in any court as an expert in forensic chemistry. Is that correct?
That's correct.
Okay. Nor have you ever been admitted as an expert in forensic biology. Is that correct?
I would say that a DNA expert is an expert in biology.
Sure, but you're not here today to discuss DNA. Is that correct?
That's correct.
What are you here today to testify about?
Serology testing.
And I believe you said you've been in your field since, did you say you graduated in May of 2024?
I graduated and was hired at the lab in May of 2022.
2022, okay. And from May 2022 to February 2024, and I'm going to go point by point, your duties included maintaining temperature and cleaning logs. Is that correct?
That's not correct.
Okay. That's not on your resume or your CV?
Well, yes, my title changed in between there. So I started doing serology cases in August of 2022.
And what type of serology testing are you here to testify about?
Vaginal epithelial cell testing as well as saliva testing.
You'd agree that epithelial cells are all throughout the linings of the body.
Yes, that's correct.
Okay, and the mouth, is that right?
Yes.
Your Honor, I would object. I think at this point, we're just trying to voir dire the witness as to whether or not she's an expert. Now, he's
correct. That is
certainly
correct.
sound like, anyway.
Okay, well, I'm going to advise all counsel that we are having a hearing under 702.
Correct.
All the factors under 702A, B, and particularly B 1, 2, 3, and 4 need to be addressed in order for the court to make a decision. So you may continue, but at the same time, Mr. Bolden is correct. This is not necessarily about the entirety of her testimony, but I'm going to let you continue.
Yes, ma'am. So can you tell me about your experience with identifying vaginal epithelial cells from oral epithelial cells?
As far as the method we use in our laboratory, or can you clarify?
Yes, ma'am. How many times have you been asked to differentiate oral epithelial cells from vaginal epithelial cells?
Between training and casework, possibly around 50 times.
And there is a test to separate epithelial or differentiate oral epithelial cells from vaginal epithelial cells?
A presumptive test, yes.
Okay. And what's the name of that presumptive test?
Lugol's iodine presumptive test for vaginal epithelial cells.
Okay. Now, would you agree that a presumptive test is a test that requires a confirmatory test to make a determination whether the substance is what you believe it to be?
I wouldn't say it requires. A presumptive test alone is just an indication that a substance may be present.
So the Lugol's iodine test is what you're here to testify about today, is that right? Not today, but testify about, is that correct?
Correct.
But from what you just stated, this testing is just to determine if something may or may not be present. Is that fair?
An indication if something's present.
Okay, it's an indication that something may be present, correct?
Yes.
What is the confirmatory test that is done following a Lugol's test?
There's no confirmatory test for vaginal epithelial cells that I'm aware of.
Okay. Excluding the I'm aware of portion, do you know why there isn't a confirmatory test?
Yes, because some buccal oral secretions, well, I guess I would have to explain kind of the test further. Is that okay?
Whatever you're comfortable with.
And again, Your Honor, I think I still have this witness on direct. I understand that the procedures allow Mr. Cruz to voir dire her as to her expert qualifications so that we can establish that for the record, and then the state would intend to go about its direct examination about the testing that Ms. Lacan did. So can we just get past that first hurdle?
That's actually true. I sort of got far afield. You're actually right. We got to do this in two separate portions.
Sure.
Your objection was to the state tendering this witness as an expert
Correct.
in forensic chemistry and forensic biology.
Correct.
Your objection, I'll let you voir dire her for your objection.
Correct. And
Right.
I don't mean to cut the honorable court off.
That's all right. Anything else you want to ask her with regard to that objection before we get into whether 702 is met?
Oh, okay, let me make sure I understand, because maybe I understood differently. I was asking her questions regarding B2 and B3. I was getting into that area. Are you saying you would like me to focus only on
There are two parts to this Daubert motion.
Sure.
We kind of got far afield on that. So my question to you now is, do you object to this person being tendered as an expert in forensic chemistry and forensic biology?
Yes, ma'am.
Okay, and the reasons for that?
I was getting into the examination with her regarding.
That's for the next portion of the motion.
Sure. Yes, ma'am. Yes, ma'am. So if If the Honorable Court would like an answer now, one, this witness has, and correct me if I say anything wrong. I don't want you to think I'm trying to, I just forget sometimes. But this witness has never been tendered to testify as an expert in forensic chemistry and forensic biology for this particular test. From what I understand, she stated is that her expertise that she has been admitted in court on is DNA.
That's correct, but I would argue that that encompasses also serology testing.
Sure. Does that encompass Lugal's iodine test?
Yes.
You've been admitted to testify, if I may, Your Honor.
Go ahead.
You've been admitted to testify as an expert in regards to Lugal's iodine test in the court?
No.
And the reason for that is because it is a presumptive test. Is that fair to say?
I haven't been called to testify ever on the specific test.
Well, so this is the first time you've been asked to.
Yes.
This
Your Honor, once again, we are venturing so far astray of the purpose of the voir dire of the expert or the witness's expert qualifications.
So I'll make my objection
Go
simple.
ahead and make your argument.
That's fair. As far as an expert in forensic chemistry and forensic biology, I would object to her being tendered as an expert to just those broad ranges of fields. As she mentioned, it includes multiple areas. If the state wants to narrow her expertise, I could address it at that time. But as of right now, I do object to her just generally being tendered as an expert in forensic chemistry and forensic biology just as a whole.
All right. Thank you, Mr. Cooper.
Thank you, Your Honor.
I'm going to overrule your objection. I'm going to admit this witness as an expert in forensic chemistry and forensic biology. The next question is whether 702 is satisfied. So, Mr. Bolden, go ahead.
Thank you, Your Honor. Can you say, I'm sorry, just so I'm saying it correctly, can you say your last name one more time?
Lacan.
Lacan.
Yes.
Probably said it wrong. Okay. Ms. Lacan, back in, let's see, bear with me. Where's all my stuff? Back in October of 2024, did you receive items from the Georgia Bureau of Investigation?
I believe it was in September of 2024.
Okay. And what, if anything, did you receive from the Georgia Bureau of Investigation?
We received 2 items of evidence, which were apparent cuttings of swabs.
Okay. Can I purchase the witness, Your Honor?
You may.
Ms. Lacan, showing you what I marked as states 126 and 127. Do you recognize those?
I do.
What are they?
They're the items of evidence we received.
Are those photographs fair and accurate depictions of the items that you received?
Yes.
Any material alterations, deletions, or changes to those photos?
No.
Move to tender states 126 and 127.
Any objections? All right. For the purposes of this hearing, I will admit them.
Ms. Lacan, I know we don't have a jury here, but I'm going to put some stuff up on the Elmo just because I think it'll be helpful for everybody else. States 126. That is a picture of one of the 2 envelopes that you received from the Georgia Bureau of Investigation?
Yes.
Okay. And that is item 2I or oral swabbings B, is that right?
Yes.
And once that piece of evidence arrived at pure gold, did you give it the number 1?
Yes, I did.
Okay. And then States 127 is just, is that the other, I guess, box or envelope of evidence that you received from the GBI?
Yes.
Okay, and is that item 2J or oral swabbings A?
Yes.
Okay. And then did you give, once that arrived in pure gold, did you give it the identifying number 2?
Yes.
Okay, so just want to make sure we're all clear. What were you asked to do with those 2 samples?
So I reviewed the case file and saw that we were requested to perform vaginal epithelial cell testing as well as saliva testing.
Okay. And is that something that is done at Pure Gold?
Yes.
Are there internal protocols and memoranda discussing, I'm going to start with the saliva testing.
Okay.
Because I think you mentioned Lugol iodine. Did you also perform saliva testing on those 2 items that we just showed?
Yes.
Okay. Second approach, Your Honor.
May.
Uh-huh.
I'm going to show you what's the mark of States 128 to 129. What is States 128?
128 is our laboratory procedure for our saliva testing.
Okay. And what is States 129?
Our laboratory procedure, this is our validation study for RSID saliva.
Okay. And are both of those documents something that is kept at Pure Gold Forensics?
Yes.
And are those both, I guess, I moved to tender States 128 and 129, Your Honor.
Mr. Cruz?
May I see those documents, Your Honor?
You may.
Mm-hmm.
I would object to those documents, Your Honor. I would ask for a more appropriate foundation. The documents that I don't even know how to identify them, but the state says it is that they introduced. The state hasn't mentioned what journal they're from, if they're from a journal, if there's something someone typed up. I was just asking for a more thorough foundation.
Thank you, Mr. Cruz. Mr. Gold, do you care to respond to the objection?
Yes, Your Honor. I think, we're under, this is a kind of the issue which I think is governed by OCGA 24-1-104 as a preliminary question. And the court's not bound by the rules of evidence. I'm just trying to get this witness to be able to explain what the science behind the test is and the way that the test is conducted in the lab, which again is absolutely relevant for purposes of the hearing based on Mr. Cruz's motion.
I'm going to overrule the objection.
So are they tendered, Your Honor?
They are tendered over objection. Admitted over objection. You tendered them, they are admitted over objection. For the purpose of this
For
hearing.
the purpose, of course, Your
Yes.
Honor. So, I'm going to go a little out of order. So, ma'am, the RSID saliva test, kind of describe how that test, what the science is behind that test.
So it's a lateral flow strip test that tests for the presence of human salivary alpha amylase, which is an enzyme found within saliva. So a lateral flow strip test, we deposit the sample along with buffer onto a test kit. Within the test kit is a membrane that has antibodies that are specific for the antigen, which in this case is the alpha amylase. So if alpha amylase is present, the antibodies will bind to the antigen. And a positive test will result in 2 visible lines, and a negative test will result in a singular control line.
Does it kind of look like a COVID test?
Yes, or like an at-home pregnancy test.
And so what states, that was states 129. Actually, I wanted to ask a little bit more about that. In validating the RSID saliva study, did Pure Gold test for the sensitivity of that particular test?
Yes.
And can you talk a little bit about that?
So we tested, well, I didn't participate in the validation, but I reviewed it. And so what was tested was dilutions of saliva. So on our procedure, we determined that 10 nanoliters of saliva would be detected.
How many, what is a nanoliter?
There's 1 million nanoliters in 1 milliliter.
And so, so that I understand, the RSID saliva test would indicate 2 lines with 1/1,000,000th of a millimeter. Is that what I'm basically understanding, or did I misstate that?
Not, it would be 10 of a million.
10 of okay.
Yeah.
Now, in kind of validating the RSID saliva test as a, I guess, preliminary or not presumptive test for the presence of saliva, are there the potential for any false positives?
Yes.
And if you could speak a little bit to that.
The most common false positives are human breast milk as well as fecal matter, also high concentrations of sweat.
So those 3 things could indicate a positive result in the absence of saliva?
Correct.
Or amylase? Okay. So I think we talked about. I'm going to move next to Lugol iodine, and I'm going to mark some exhibits. If I can approach again, Your Honor.
You may.
States 130, 131, 132.
Okay.
I'm going to actually start in reverse order. States 132. What is that?
This is a study that was published on the Lugol's test.
And is what you said is a study. What is that study? I guess what does it stand for?
What's the contents of the study?
Just summarize it. I guess that'd be my.
Okay, so in the Lugol's test, some oral secretions as well as cells from the urethral opening of the penis will. So the basis of the Lugol's test is that the glycogen content of vaginal epithelial cells is extremely high from a woman's first menstruation to menopause. So when they're stained with the iodine, the glycogen within the cells will uptake the iodine and stain a dark chocolate brown color. However, oral secretions as well as cells from the urethral opening of the penis will also stain the dark chocolate brown color. However, oral secretions have a less abundant amount of glycogen. So the study proposes that with an water extraction as well as mechanical shaking, that less than 1% of the oral secretion will stain the dark chocolate brown color.
And was that article published in, is it the Journal of Forensic Sciences in 2004? Am I remembering that right?
Yes.
Is that a peer-reviewed article?
Yes.
And, okay. States 130 and 131, as before, are those just internal memoranda or I guess, procedures relating to Lugol iodine being used to test for vaginal epithelial cells at Pure Gold?
Yes, so 130 is our internal validation study, and 131 is our analytical procedures for the test.
Move to tender states 130 through 132.
Any objection, Mr. Cruz? I'm going to overrule the objection and admit 130, 131, and 132 over objection for the purpose of this hearing. You may.
Mm-hmm. So, I think, Ms. McCon, you might have hinted at this just a second ago, but what is the theory behind using Lugol iodine to potentially test for the presence of vaginal epithelial cells?
So the theory is that the glycogen content of vaginal epithelial cells is extremely high, specifically from a woman's first menstruation to menopause. So when they're stained, the glycogen within the cells will uptake the iodine and stain a dark chocolate brown color.
And how would that test be helpful in trying to determine whether or not an item of evidence was potentially taken from a vagina versus taken from someone's mouth?
So at our lab, based on studies as well as our internal validation, we have a 10% threshold. So if more than 10% of the cells stain the dark chocolate brown color, it's considered a positive indication for vaginal epithelial cells.
Okay. And is that a higher threshold than what was proposed in the Lugol test reimagined?
Yes, it's higher.
Okay, what was, if you recall, what was the...
They proposed that anything greater than 1%, the mouth could be eliminated as the source.
Okay. So, going back to these two packages that you received from the GBI Crime Lab, when you received those items, did you perform both the RSID saliva test and the Lugol iodine test on those items?
Yes.
And explain for the court how you did that. like the mechanics of conducting that test with that piece of evidence?
So first, I took the evidence into the examination room where I opened it. I took photos, took notes, and then I took it for our Analytical Procedure 5, which is extraction for systematic semen analysis, which is a general extraction procedure that allows the analyst to retain the substrate, which in this case was the cuttings of swabs, while using the liquid portion for serology testing or multiple serology tests, and using the cell pellet for microscopic examination or DNA testing.
Okay. And once you did that testing, I guess, do you use, bear with me, let me look back through my notes. How do you take those cuttings to kind of separate for the purpose of doing an RSID test and a Lugol iodine test? I don't know if that's a great question, but
Yeah. So the procedure, the actual procedure we use?
yes.
So we place the substrate, which in this case was the apparent cuttings of swabs, and we place it into a test tube along with sterile water, and then we allow it to incubate at room temperature for approximately 30 to 60 minutes. During that time period, we vortex it several times, which means to shake it vigorously, which we do this by placing it on a machine. After the time period has passed, we take the substrate and we place it into what's called a spin basket on top of the tube, and then we centrifuge it, which spins the tube extremely fast, and it essentially pulls the liquid from the substrate. So while it's centrifuging, the cells also pellet at the bottom of the tube. That's what we refer to as the cell pellet. So once it's done centrifuging, we pull the spin basket off and place that into a separate tube. And then left within our tube is liquid as well as the cell pellet. So we pull the majority of the liquid off. That's what we refer to as the supernatant, and that's what can be taken for serology tests. And we place that into a separate tube, and then we're left with the cell pellet and a small amount of liquid, and that's what can be taken for microscopic examination and or DNA testing.
And so as it relates to both the item that you received, which you marked number 1, which was GBI Crime Lab item 2I, and your item number 2, GBI Crime Lab item 2J, did you do that for both of those?
Yes.
And let's talk a little bit about the results. We'll start with your item number 1. Okay. Did you perform the RSID saliva test that you previously described on that particular piece of evidence?
Yes, I did.
And what, if anything, were the results?
I would have to refer to my report.
Yeah, too many pieces. Would a copy of your report help you?
Yes.
I can approach again, Your Honor.
You may.
With the testing that you've been describing for the last 30, 45 minutes?
Yes.
Move to Tender States 133.
Any objection? It is admitted for the purpose of this hearing.
So did you conduct an RSID saliva test on your item 1, GBI item 2I?
Yes.
What were the results?
Human amylase consistent with saliva was detected in item 1 using the RSID saliva test card. However, other body fluid sources like feces and breast milk cannot be eliminated.
Did you also prepare a slide and for item 2I to conduct a Lugol iodine stain?
Yes.
And there they are. What was the result of that?
Item 1 was screened for the presence of vaginal epithelial cells using the Lugol's iodine test. Fewer than 10% of the cells stained positive. Therefore, the presence of vaginal epithelial cells was not indicated on item 1.
Now let's move to item 2, which again was item 2J from the GBI crime lab. Is that correct?
Yes.
Same questions. Did you perform the RSID saliva test on that item?
Yes, I did.
And what were the results?
No indications of saliva were detected.
And did you also create a slide to prepare a Lugol iodine test?
Yes.
And what were the results there?
Item 2 was screened for the presence of vaginal epithelial cells using the Lugol's iodine test. Greater than 10% of the cells stained positive, thus indicating the presence of vaginal epithelial cells.
Ms. Lacan, are either the RSID saliva test or the Lugol iodine test considered confirmatory tests?
No.
To your knowledge, based on the particular type of testing that you were asked to do in this instant, are there confirmatory tests for those questions?
Not to my knowledge, no.
Based on your observations of both the RSID saliva test and the I'm sorry, I apologize. I can figure this out. Item 1, which is crime. Oh, you have it. Okay, there we go. Item 2I, based on your observations to include the fact that that item tested positive on the RSID saliva and indicated less than 10% of stained cells using the Lugol iodine test. Would that be consistent with that being oral in origin?
Yes.
Similarly, as it relates to your testing of item 2J, or your number 2, based on your observation to include a negative RSID saliva test and the presence of more than 10% of stained cells using Lugol iodine, would that be consistent with that sample being vaginal in origin?
Yes.
I believe that's all I have, ma'am. Mr. Cruz will have some questions.
Mr. Cruz?
Thank you, Your Honor. Ms. Lycombe. Okay, perfect. I want to make sure I get it right. I'd like to start off by talking about the facts and data that you had in regards to this test and your conclusions. Okay, is that fair?
Yes.
Okay. So you established with the state that you received some swabs. Is that right?
Yes.
Okay. Do you know how old those swabs were?
I don't know.
Okay. Do you know the condition that they were collected in?
I don't.
Okay. And would you agree with me when it comes to the Lugol's iodine test, that it will, I'm going to use the word illuminate. If you have a better word, please share it. But it will illuminate starches. Is that correct?
A better word, maybe stained.
It'll stain starches. There we go.
Glycogen in particular. From my recollection, starch in particular would stain a blue color.
Blue?
Yes.
Okay. And I believe the state introduced the copies of your testing results. Do you have that with you up there?
Yes, I do.
Okay. I'm going to come and grab it.
Mm-hmm. Oh, I didn't receive that.
I'm sorry. They're right here.
Would you happen to have a copy of your results?
The photograph's not in my case file now.
Okay, that is fair. So the starch turns blue with Lugol's iodine test. What color did the cells turn in your case?
For which
For
item?
the Lugol's iodine test, for the swab that tested, or excuse me, the swab that was consistent with being a vaginal swab.
They were a dark chocolate brown color, ranging from tan to dark chocolate brown.
And is there a possibility of false positives with the Lugol iodine test?
There are other body origins that contain glycogenated cells.
And can you name those body parts?
Yes, so
Areas, excuse me.
it's oral secretion, so buccal cells, as well as the urethral opening of the penis.
So what were the steps taken, if any, to separate the swabs that you tested and them turning brown from cells from the urethra of a penis versus a vagina?
There's no specific way to separate those, like to separate the epithelial cells. We rely on the staining pattern.
So the swab that was consistent with a vaginal swab is also consistent with the swab having urethral cells from a penis. Is that correct?
I don't specifically, it says that test should not be used from swabs of the urethral opening of a penis.
And I may have asked that question the wrong way. The swab that well, let me do it this way. So the urethral cells of a penis would stain brown. Is that fair?
Some, yes.
Okay. Vaginal cells would stain brown. Is that correct?
Correct.
You received the swab. Is that correct?
Correct.
Okay. Can you differentiate whether the cells that stain brown are penis cells or vaginal cells?
No.
First indulgence. So when the swabs were given to you, what were they identified as, if you remember?
2I and 2J, they're both labeled oral swabbings.
So to your knowledge, you assume that you had oral swabbings. Is that right?
Yes.
Okay. And is it fair to say that there could possibly be urethra, if I'm saying that right, urethra or urethral penis cells on oral swabbings? Is that a possibility?
That's a possibility.
And at this time, we don't know whether the cells that stained brown are vaginal cells or urethral penis cells. Is that right?
Again, we rely on the staining pattern, but I guess I can say what is consistent with the staining pattern. Sorry, can you maybe rephrase the question?
Sure. The results are consistent with also being cells that may be from the urethra of a penis.
The cells that stain brown?
Chocolate brown, yes, ma'am.
Yeah.
I like to talk about the principles and methods behind the test, okay?
Okay.
Can you walk us through step by step the process with conducting a Lugol's iodine test?
Yeah, do you want me to go back through our extraction procedure or?
Not the extraction procedure. If you could give me the shorthand version, if you give me the shorthand version, just maybe the shorthand version, I'll leave it at that.
Okay. So we take it for our extraction procedure and we take the cell pellet portion, and then we take approximately 2 to 10 microliters of that cell pellet portion and we deposit it onto a microscope slide. We heat fix the slide and then we use a Lugol's iodine solution, so it's 1 part Lugol's, 19 parts water, and then we cover the slide with Lugol's iodine, and then we observe it under the microscope.
Sure. What is the error rate when it comes to distinguishing, and I'll just say penis cells to make it easy on myself, penis cells versus vaginal cells? Is there an error rate that you all have or a method? Well, I think you answered the question about the method. But is there an error rate to determine whether or not these are vaginal cells versus penis cells?
They are both epithelial cells, so they'll look fairly similar or identical under the microscope. And again, it's a presumptive test, so we're relying on the staining pattern if it's more than 10% consistent with a vaginal origin, rather than if it's lower than 10% being from the urethral opening or buccal cells.
Okay. Is there any error rate to determine whether sometimes it may be 10% and is penis cells versus sometimes it may be less than 10% and is vaginal cells?
For clarification, you're saying, is it possible for it to be less than 10% and coming from a vaginal?
Let me rephrase that question.
Okay.
I'm sorry. And I do ask some confusing questions sometimes, so I promise you it's not you, it is me. Is there an error rate to distinguish between, I think this is the best way to ask it, to distinguish between urethral cells or vaginal cells? Is there any type of error rate where you can say 90% of the time we're right, 80% of the time we're right, 60% of the time we're right, or no, there isn't a test that we could apply to determine outside of looking at the pattern of and the staining of the cells?
Outside of looking at the staining. Sorry.
Sure. So outside of looking at the staining, there isn't any type of test to determine the error rate?
No, the epithelial cells will look fairly similar or identical.
Okay, so is there no error rate? Is it fair to say that?
At our lab, we wouldn't necessarily identify cells from different origins of the body. Like, we use a staining. Again, we rely on the staining as the presumptive test, but we wouldn't look at a specific cell and say this is from this certain area.
Sure. So this is really just a staining test, if I was to put it in simple terms.
It's a staining procedure, correct?
Okay. Understood. Did you perform the test in this case, or was it, I believe you mentioned earlier, did you participate in testing or did you conduct the testing in this case?
I conducted the testing.
Okay. Was the testing reviewed by anyone? Yes. What is the review process?
So each report case file goes through a technical review, which is performed by another qualified analyst. They review the entire case file, so the administrative pages, the photos, the report, and they determine that there's a scientific basis for the findings. After it's gone through technical review, it goes through an administrative review, which is done by lab personnel. They'll also check the case file to ensure we're with laboratory procedures, as well as check the report for grammatical errors.
And that's for presumptive tests? All those steps?
Yes.
Okay. Outside of peanut shells, is there anything else that was stained chocolate brown using the Lugol's iodine test?
Some buccal cells will stain chocolate brown.
So cells in the mouth would stain chocolate brown as well?
Yes.
Is there anything else that was stained chocolate brown using the Lugol's iodine test?
Not to my knowledge.
I'd like to talk to you about the RSID saliva test. Did I say that correctly?
Yes.
Okay. And this is a presumptive test as well?
Yes.
All right. Now, I think I heard you correctly, but I heard two different things, so I want to check. I heard breast milk and fecal matter. Is that right?
Correct.
Did I also hear sweat?
High concentrations of sweat, yes.
Okay. And I believe we agree that you don't know the circumstances surrounding the collection of the evidence in this case. Is that right?
That's correct.
So you don't know if the cells that you received had sweat on them. Is that right?
Correct.
Okay. So your conclusion is based on, or I ask you this way, what facts did you have underlying your RSID saliva test to come to the conclusion that the testing confirmed that were consistent with the swabbings having saliva?
Just the results from the RSID saliva test.
Okay. So the underlying facts you didn't have, it was just pretty much the test itself saying, hey, this is consistent.
Correct.
Okay, that is fair. Court's indulgence. You mentioned in regards to the RSID saliva test that you did not conduct the testing, but you participated in the testing. Did I hear that wrong?
Oh, no, that was in our validation, our internal validation.
That is fair. That is fair. Do you know the error rate for the RSID saliva test?
The error rate would refer to the false positives, which are, as we mentioned, breast milk, fecal matter, high concentrations of sweat.
Okay, but we don't know if sweat was involved in that swab.
Correct.
Okay. And just for my notes, the test itself is what led you to your conclusion, just because it indicated the presence of, and I'm going to say it this way, saliva as well as sweat. Is that fair?
Yes.
Okay. I have no other questions for this witness, Your Honor. I thank you so much, Ms. Lycombe.
Any redirect, Mr. Bolden?
I'm going to try and keep it brief, Your Honor. I know the hour is getting late, but I do want to
Go ahead.
ask a little bit of redirect. Ma'am, I'm going to hand you what I hope is the last two. It says 134 and 135. Do you recognize those?
Yes.
Are those, what are they?
They are the slides from the items we received.
Okay. And are those fair and accurate photographs of the slides that you described as having on the blue ball iodine tests on?
Yes.
Any objection?
No objection.
They are admitted for the purpose of this hearing.
All right. So, this is 134. Is this a picture of the slide that you took from your item 1, GBI item 2I?
I would have to refer to my report or my notes to double check the item number.
Do you have your report?
I do in my case file.
Oh, in your case file. Okay. Well, maybe I can do it this way. The two photographs. No good way to do it. So again, are these the two photographs that you took of each sample that was tested using the Lugol iodine test?
Yes.
And again, I think there was some confusion earlier. What is the scientific theory behind glycinated cells not being as present in a buccal sample?
So amylase, which is present within saliva, will degrade glycogen. So there are glycogenated cells within buccal cells, but way less abundant. So that's why we use the 10% threshold.
And again, the peer-reviewed journal article that we talked about, I guess using water to dilute the samples might affect, or not affect, might. I'm going to let you take it from there. What did that article propose?
Yeah, so the article proposed that with water extraction, and they propose a method that with rehydrating the cells, the cell walls, allow amylase back in, so that amylase can degrade the glycogen. But with the water extraction and mechanical shaking, that less than 1% of buccal cells will stain the chocolate brown color.
And in this case, and so that article proposed 1% as a kind of guideline. Mm-hmm. Did I hear earlier that Pure Gold has a 10% guideline?
Yes.
And in States 135, what are we seeing here?
This is a Lugol's positive slide.
And so are all these brown or light brown things kind of what we've been talking about?
Yes.
And then States 134, do we see any of those brown things?
No.
That's all I have.
Any recross, Mr. Cruz?
Yes, we do.
Go ahead.
So we've established that vaginal cells, penile cells, would stain dark chocolate, right?
Mm-hmm.
In regards to the light color.
Thank you. She's making a recording of your responses, so thank you.
Yes.
In regards to the light colored cells, what type of items stain tan?
So epithelial cells will exhibit no staining to a light yellow staining. Also, the glycogen content of cells varies. Specifically within a vaginal source, the glycogen content varies based on the period of the menstrual cycle.
Help me understand that. I'm sorry.
At different periods of the menstrual cycle, there will be higher glycogen content or lower within the cells.
That's fair. How would this compare, and let's just say hypothetically, how would this compare to a penile sample?
You'd expect to see less dark brown staining.
How about tan staining?
Tan staining is also considered a positive. the negatives would be the light yellow.
In the material that was provided, I believe there were pictures of stains that were vaginal cells. Is that correct?
Yes.
And compared to the photos in the exhibit versus the photos that are here, and in fact, before I ask that question, Your Honor, may I approach the witness?
You may.
Oh, I don't have any on me.
Okay, thank you for your patience. Those are my questions for you.
Anything further of this witness?
Your Honor.
Or you may step down. All right. Any argument, Mr. Bolden, on behalf of the state with regard to this motion? Well, actually, it is, you know what? It's Mr. Cruz's motion. I'm going to start with him. Mr. Cruz, any argument with regard to your motion?
I do think the state has the burden, Your Honor, so I do think I have the ability to go first and last, but I would waive and reserve last word.
You're right. You know what? You're right about that.
It's been a long day, Your
It
Honor.
has been a long day. Okay, you're right about that, but you're waiving anyway. Mr. Cruz, any argument about your motion? Thank you.
Absolutely. In regards to the RSID test, Your Honor, well, let me start with the law. As the Honorable Court is aware, under OCGA Section 24-7-702, B1 through 4, and I will specifically address B2. The testimony has to be based upon sufficient facts or data. Ms. Lycon's testimony is that she didn't have any underlying facts or data regarding the swabs, only that the information that she had was that it was packaged up as oral swabs. She advised that in regards to the RSID saliva test, that not only would it test positive for saliva, but it would also test positive for sweat. And the state did not take any steps to eliminate that sweat would have been a cause of the positive test. As the Honorable Court is aware, a witness testified that Ms. Baker, and I believe it was Mr. Falzone, but I don't want to say for certain, but I do believe it was Mr. Falzone, stated that Ms. Baker was alive for a period of time before she passed away. Obviously, as the Honorable Court is aware, sweat, it'll draw on your body. If you're sweating down in your mouth, it'll go in your mouth. But the state took no steps to eliminate for the RSID saliva test that is something other than sweat or saliva, Your Honor. Also, she stated that this is a presumptive test. We heard testimony from a DNA expert, I believe it was yesterday or the day before yesterday, that talked about the importance of confirmatory tests. This is a test that simply indicates the presence of a substance that could be consistent with, again, sweat or saliva. And again, she didn't have any facts or underlying data to make the determination of whether either one is or which one is present. Additionally, and I think most importantly, and this may go to another factor as opposed to two, I believe this one goes to B as a whole, she's admitted that she has never testified or been qualified as an expert to testify about Lugo's iodine testing. As the Honorable Court is aware, when it comes to the type of science that's admitted under Daubert, it is a higher standard than the Harper standard. And here, Your Honor, I found no cases where the Lugol's iodine test has been accepted in the court. And I could show the Honorable Court, we could do a search on Westlaw, but I found no cases where a court has admitted it. And even Ms. Lycone states she's never been admitted as an expert to talk about the the RSID saliva presumptive test. So that would be my request to the Honorable Court in regards to the RSID saliva test, is to exclude it based upon saying it is not a set in stone science. It sounds more so like it's indicative of multiple different things. There's no way to confirm whether or not it's saliva. It's just a presumptive test, as she stated, that indicates the presence of an item. In regards to the Lugol's iodine test, she stated that the urethra of a penis could stain chocolate brown. She stated that buccal cells could stain dark chocolate brown. And she stated that there was no specific way to know whether or not the cells were penile cells or vaginal cells, except for just looking at the number and determining whether or not 10% of the cells stained positive. The state presented a picture that included dark brown cells. However, the state at no time elicited testimony from this witness, and it's their burden, that established that that was more than 10%. The Honorable Court didn't hear a number. We just saw a picture. It's a lot of cells. Some are lighter colors than others. So we would ask in regards to the Lugol's test, because we can't differentiate what's what, and the only basis that she has in regards to determining what the substance is just saying that it indicates the presence of the substance, Your Honor. But I think the biggest issue we have are 2 points, and I'll make it simple. The biggest issues we have, there's no confirmatory test. She stated there's no confirmatory test on this. We don't know what this substance is. We don't know if it's sweat. For the Lugol's, we don't know what the substance is. The second one, Your Honor, it's never been admitted. The state has presented no evidence that this type of testing has ever been admitted in a Georgia court before, in a criminal case or a civil case. So I would ask, based on those grounds, the Honorable Court excludes the speculative science of the presumptive test of the RSID saliva test, as well as the Lugol's iodine test. Thank you so much for your time, Your Honor.
Thank you. Mr. Bolden.
Your Honor, I'm going to try to be brief. I think we've been going at it all day, and I don't know that if I can approach. I won't speak for Mr. Cruz, but I'm going to try and, it's hard to stay focused after such a long day, so I'm going to try and be brief. I agree with Mr. Cruz that I did not find a case anywhere in the country that stands for the proposition that the Lugol iodine test is admissible under Daubert. I don't know that that's ever been considered before. I don't know if the court may well prove me wrong, but I did look. But I handed the case of U.S. v. Brown. I had a copy for defense counsel and for the court. This is an 11th Circuit case. 415 F. 3rd, 1257. It is a 2005 case. And I won't get into the type of expert testimony that the government intended to offer or did offer in that case because I didn't understand it. But there is some just really interesting language about Daubert in general. And I'm going to direct the court to if you go to the second column of page 10 of the printout that I just handed you, first stands for the proposition that evidentiary decisions are reviewed under an abuse of discretion standard, and then the 11th Circuit goes on to say that they defer to district courts on evidentiary rulings for a handful of reasons. One is that difficult evidentiary rulings turn on matters uniquely within the purview of the court, which has firsthand access to documentary evidence and is physically proximate to testifying witnesses and the jury. Being at the trial as the proceedings occur and the evidence unfolds, a trial judge has an advantageous familiarity with the proceedings and that may not have insights conveyed by the record. That goes on to page 11. the 11th Circuit goes on to say that the second reason they give deference to a trial court is because it is not possible, and this is the second paragraph on the left column of page 11, it is often not possible to precisely calibrate rules for many different circumstances that can arise. It goes on to say that this is a case-specific, detailed, factual determination. The last paragraph talks about how this abuse of discretion applies even more in the areas of Daubert. It says that's where it actually, the language is wonderful. It says that the review of evidentiary issues are even greater in Daubert issues, because that is where the abuse of discretion standard thrives. The trial court is familiar with the facts and details of the case, and the task of evaluating the reliability of expert testimony is entrusted to the trial court. There, the 11th Circuit found that only one of the 4 Daubert factors were met, and they said that the question then is whether expert opinion evidence that does not meet 3 of the 4 Daubert factors nevertheless can be admitted. In the right circumstances, the answer to that question is yes, and I'm on the middle of the right-hand column of page 12. Goes on to say that the inquiry envisioned by 702 is a flexible one. I'm almost done quoting the case. On page 13, the district court found that test and the court can obviously probably read better than I can at this point about the type of witnesses that the government had tendered as experts, but that their expert opinions were based on their knowledge, skill, and experience, and based on sufficient facts and data, and there was no abuse of discretion. I do point out, lastly, at the bottom of the left-hand column of page 13, that the trial court has not just a heavy thumb, but really a thumb and a finger or two on the scale of admission of evidence under Daubert. And so I point all that out to say this. I think that what Pure Gold was asked to do, and I think that what Ms. Lycon has testified to tonight, needs to be considered in the circumstances of the facts that the court already has before it. So Dr. Falzon testified that he collected oral, vaginal, and anal swabs. We tendered the swabs that are in evidence, and in case the court has forgotten, the whole issue here is that an X was labeled on an oral swab that was really a vaginal swab. That is the state's position. That has always been the state's position. Dr. Falzon testified that all 3 were collected. He testified that, and we have in evidence, vaginal, oral, and rectal smears, which he testified that a smear can only be created from a swab. And I'd go one step further, and I do think that the court can, in fact, take judicial notice of evidence that was tendered in the Daubert hearing related to true allele, because the state did, excuse me, the state did at that hearing tender the results of true allele. And if the court may not remember, but I can state in my place, that item 2I, which is what the state contends is the actual oral swab, only has the DNA profile of the defendant, Mr. Faust. Item 2J has the DNA profile of Chris Melton and of Edrick Faust. So they're not the same. So when you look at all of those factors, you look at the tests that Ms. Lycon described, which I would argue are based on scientifically valid theory, that they have been subject to peer review, and so at least 2 of the Daubert factors have been met. Based on sufficient facts or data, it is the product of reliable principles and methods. I do think in this context, especially when we are only asked to determine a very limited question, not just are these the same or are they different, but which one is more likely to be an actual vaginal swab? I think that the state has met its burden as it relates to Daubert, and I would ask that the court allow Ms. Lycon to testify at the trial to that effect.
Thank you, Mr. Bolden. All right, with regard to Mr. Cruz's motion, the first thing I want to emphasize is that the court has already allowed Ms. Lycon to be admitted as an expert in the area of forensic chemistry and forensic biology. With regard to 702, I'm making a finding that the state has met its burden, and I'm making a finding for these reasons. First, it is obviously very clear that this expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I mean, that's just clear. And anyway, I'm not going to say any more about that. I think that you can't really argue with that. Number two, the testimony is based, and this is under 702, the testimony is based upon sufficient facts or data. The argument that the defense has made about factor number two not being met because the evidence that she received may not have been sufficient is actually not what number two is about. The testimony that she provided was that she tested what she got, and whether the pieces of evidence that she tested were sufficient is a matter of weight. It doesn't actually go to 702. And so I'm making a finding that number two has been met. I'm going to jump to let me go to number three. I think number three is the one that we're sort of arguing about. The testimony is the product of reliable principles and methods. Certainly, Mr. Cruz is making an argument that the state acknowledged that certain of her testing has never been accepted, or admitted, I should say, not accepted, admitted in a court proceeding. And that the reason that number three has not been met is because of that. And certainly there is, that is an interesting argument, and it's important to consider. The trial court does, however, have the power to, I shouldn't say the power, the authority, the discretion, that's the better word, the discretion, to use, and we've heard this phrase many times today, the totality of the circumstances in making a decision as to whether any of these factors have been met. And the totality of the circumstances is that this witness is relying upon principles and methods that have been in existence for a very long period of time, that they have been peer reviewed. But I think most importantly for this moment is that it's just acknowledged, and the testimony has been, that these results are presumptive. And I think that lends a different lens to this particular case. And so I'm making a finding that number three has been met based upon the testimony that of this witness, that her testimony about her results is in fact presumptive. And I think that nuance is crucial to this determination. And number four, she has explained that she has reliably applied those principles and methods, whether they are accepted or have been accepted in a court of law or not. She has applied those principles and methods to the facts of the case. And so the factors I'm making a finding in 702 have been met. Most of the argument that the defense has made goes to the weight of her testimony, certainly the issue of the weight of her testimony, the credibility of her data, of her testimony, of her analysis, is certainly open for examination. And I'm not making a finding on those particular things. I will say also that another reason why the court is finding that factor number 3 has been met under 702 is because the thought just went out of my brain. Hold on just a minute. Let me think of what I was going to say. It's been a long day. I need to come up with this. Hang on a minute. I don't remember what I was going to say, so I'm just going to scratch that from the record. Anyway, I'm making a finding under 702 that the factors have been met by the state. The burden has been shown, and I'm going to deny the motion to exclude the testimony of this particular witness, Ms. Lycon. And that'll be my findings. And I hope I remember what I was going to say. I'm not sure I can. So, all right. We are going to meet here tomorrow at 8:30, and we're going to go over Mr. Peterson's address the motion with regard to Mr. Peterson. Am I right? Is there anything else we have to take up?
Nothing from the state,
Okay.
Your Honor.
Mr. Cruz, anything else, sir?
No, ma'am.
All right. Then court is adjourned, and I will see you all tomorrow at 8:30. Mr. Cruz, I have a note for you from our court administrator about the room to store your things in. If you want to come up, I'll give it to you, and you can take this with you and do all that. Other than that, court is adjourned. I cannot remember what I was going to say. All right. It's a different room, and I'm assuming you have keys? Okay, very good. So I'll just leave you with that. All right. See you all tomorrow. I cannot remember what I was going to say. My brain is not working.